Third issue. Separate ಆಗಿಟ್ಕೊಳ್ಳಿ. ಹೇಳ್ಬಿಟ್ಟು ಕ್ರಿಮಿನಲ್ ಹೇಳ್ಬಿಟ್ಟು ಎರಡನೇ ಸಲ ಮೂವ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. ನಮ್ಮ ಬುಕ್ ನೋಡಿ ಯಾವ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀವಿ ಇಲ್ಲ ನೋಡ ಕೊಟ್ಟಿರ್ತೀವಿ. ಹಾ ಅವತ್ತೊಂದು ಏನಾಯ್ತು ಮೆಮೊ ನಮ್ಮ ಮೆಮೊ ಬುಕ್ಕಲ್ಲಿ ಇಲ್ವಾ? ನೀವು ಮೂವ್ ಮಾಡಿದ್ರಾ? ಕನ್ಫರ್ಮ್. ಸರಿ ಆಯ್ತು ಹೇಳಿ, ಇನ್ನೊಂದ್ಸಲ ಹೇಳಿ. ಫ್ರೆಶ್ ಮಂಡೇ ಇಲ್ಲ ಟ್ಯೂಸ್ಡೇ. ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಹೇಳಿ.
ಯಾಕೆ? ಹಾಂ ಹೇಳು. Applications, yeah, because it has to come out on an order sheet. Yeah, yeah. 2-3 applications. 3 applications. ಹಾಂ ಸರಿ ಬಟ್ ಲೇಟ್ ಅಂತಂದೆ ಅಲ್ವಾ? ಇಲ್ಲ ಇನ್ನೂ ಲೇಟ್ ಆಗುತ್ತೆ, ಇನ್ನೂ ಜಡ್ಜೆ ಬಂದಿಲ್ಲ. ಜಸ್ಟ್ ಹೈಕೋರ್ಟಿದ್ದೀನಿ, ಜಸ್ಟ್ ಫೈಲ್ ಮಾಡ್ತಾರೆ, ಡೇಟ್ ಕೊಡಬೇಡಿ, ಒಂದು 10 ನಿಮಿಷ ಆದ್ಮೇಲೆ ಬರ್ತಾರೆ ಅಂತ ಹೇಳಿ ಫಸ್ಟ್ ರೌಂಡ್ ಆದ್ಮೇಲೆ ಬರ್ತಾರೆ ಅಂತ. ಈಗ ಟೋಟಲ್ 17 ಎರಡು ಪ್ರಾಕ್ಸಿ ಕೌನ್ಸಿಲ್ ರಿಟರ್ನ್ ಮಾಡೋ ಪ್ಲೀಸ್. ಟೋಟಲ್ 43 ಅಲ್ಲಿ 44 ಆರ್ ನಾಟ್ ಗೋಯಿಂಗ್. You don't attend, ask someone to attend, no?
ಮಾಡ್ಬೇಕು ಸರ್ ಅರ್ಜೆನ್ಸಿನ. ಅಲ್ಲ ನೋಡ್ತೀನಿ ಅಂದ್ರಲ್ಲ, ಅರ್ಜೆನ್ಸಿ ಅಂದ್ರಲ್ಲ. ಮಂಡೇ ಟ್ಯೂಸ್ಡೇ ಫ್ರೆಶ್ ಬರೋರು ಇದ್ರೆ ಕೊಡಿ.
ಹಳೇದು ಅಂದ್ರೆ ಅವರು ಎಕ್ಸ್ಪರ್ಟ್
ಮೆಮೊ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ. ಮಂಡೇ ಟ್ಯೂಸ್ಡೇ ಅರ್ಜೆನ್ಸಿ ಇದ್ದವ್ರು ಮಾತ್ರ ಮೆನ್ಷನ್ ಮಾಡಿ ಸರ್, ಬಾಕಿಯವರೆಲ್ಲ ಕೊಡ್ಬೋದು ಮೆಮೊ. ಮಂಡೇ ಟ್ಯೂಸ್ಡೇ ತಗೊಳ್ಳಿ. ಈಗಲೇ ಮಧ್ಯಾಹ್ನ ತರಿಸ್ಬೇಕಾ? ಹಾಂ ಸರಿ, ತೊಂದರೆ ಇಲ್ಲ ಅಂದ್ರೆ ಪರವಾಗಿಲ್ಲ. ಹಾಂ ಹೇಳ ತೆಗೆದಿಟ್ಕೊಂಡು. ಹಾಂ ಹೇಳಿ.
Your Lordship.
Yes. Fresh matter. Fresh matter kodri. Fresh matter. All fresh matter first time it will come tomorrow. If everything is ready. Kudi memo.
Your Lordship.
Fresh matters kudi. No, it is not at listed before the court. Kudi. First matter first time barod notice agde irado. Not Friday. Friday you move it on Thursday. Yes.
Lordship.
Kodi fresh matter kodi naale bar. Fresh matter, first time tomorrow. I am telling now. Why you are again mentioning that? Give that.
Your lordship,
Yes. Yes, 2013 matter.
No, no, to be listed on 13th August. Trial court ಮುಂದೆ 17th ಇದೆ. Written statement has been taken as
ನಾಳೆ ಯಾಕೆ ಬೇಡ?
senior executive.
Not 13th, yes. 13th is the 16th, yes.
your lord,
13th is Friday, we will take.
my lords,
Execution was stayed with the orders of this honorable court.
Hmm.
It was listed on 5/3. Other side took a date at 10:30. It is adjourned to after 2 weeks. Lord, the warrant is stayed, please, my lord. I am the decree holder.
Have you filed application for vacating?
Lord, it's a compromise decree. I have not filed. It was listed for B group, my lord.
ಆಯ್ತು.
Monday.
File ಮಾಡಿ application ಹಾಕಿ.
No, Monday at least, please.
B group, I don't think it will reach also. Yes.
your,
Read this matter on 2nd.
your lordship,
Hmm.
Amendment application rejected. Same government didn't allow.
Fresh matter. Tomorrow ತಗೊಳ್ರಿ fresh matter ಮೇಡಮ್.
your,
ಯಾಕೆ ನಿಮಗೆ ಅರ್ಥ ಆಗ್ಲಿಲ್ವಾ ನಾನು ಹೇಳಿದ್ದು? ಕನ್ನಡದಲ್ಲಿ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
your lordship,
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಫಸ್ಟ್ ಟೈಮ್ ನೋಟಿಸ್ ಆಗದೆ ಇರ್ತಕ್ಕಂಥದ್ದು ಮೆಮೊ ಕೊಡಿ, ಮೆನ್ಷನ್ ಮಾಡಬೇಡಿ, ನಾಳೆ ಬರುತ್ತೆ.
ಇದರಲ್ಲಿ ಅಲ್ಟ್ರಾ ವೈರಸ್ ಡಿಕ್ಲೇರ್ ಮಾಡಿದ್ದೀನಿ. ಆರ್ಡರ್ 8 ಫೋರ್ಫಿಕ್ಷನ್ ಆಫ್ ರಿಟರ್ನ್ಸ್ ಡಿಕ್ಲೇರ್ ಮಾಡಿ ಅಲ್ಟ್ರಾ ವೈರಸ್ ಅಂತ ಡಿಕ್ಲೇರ್ ಮಾಡಿ ಯಾರನ್ನ ಒಬ್ಬರು ಹಾಕ್ತೀವಿ ಜಸ್ಟ್ ಟೇಕ್ ಇಟ್ ಅಪ್ ಅಂತ ಹೇಳಿ ಎಲ್ಲ ನಾನು ಮಾಡಿದ್ದೀನಿ.
one small
ಈ
submission.
ಸುಮಾರು ಮ್ಯಾಟರ್ ಯಾರೋ ಹಾಕಿದ್ದಾರೆ. ನಾವು ಐ ಆಸ್ ದಟ್ ಅಡಿಷನಲ್ ಅಡ್ವೊಕೇಟ್ ಜನರಲ್ ಟು ಅಸಿಸ್ಟ್ ವೆದರ್ ಇಟ್ ಹ್ಯಾಸ್ ಟು ಗೋ ಬಿಫೋರ್ 226 or 227.
One small
Because
submission.
constitutional validity has to be under scrutinized under 226.
ಬಟ್ ಇವಾಗ ಅವಾಗ ಏನಾಗುತ್ತೆ ಅಂತಂದ್ರೆ the challenge
Consequential order also will be done there only.
main prayer will be to set aside the order of not filing.
No. Main player should be, quashing up that legislation. Then consequential
ಅವಾಗ GM ಹೊರಟೋಗುತ್ತೆ.
GM ಹೋಗುತ್ತೆ. ಯಾಕೆಂತಂದ್ರೆ 227 I don't think we have can quash that notification.
GM ಹೋಗ್ಬೇಕಾಗುತ್ತೆ.
ಅದು ಅದಕ್ಕೆ
ಮಾಡಿದ್ದೀನಿ ನೋಡೋಣ. Let us I'll just convince you.
Yes. ಯಾಕೆಂದ್ರೆ ಇನ್ನೂ 3-4 ಜನ ಮಾಡಿದ್ದಾರೆ.
ತಾವು ಹೇಳ್ತಾ ಇದ್ರಲ್ಲ
ಅದೇ ಆಗಿರೋದು ಒಳ್ಳೇದಾಯ್ತು. Will give some conclusion that. Yes.
One small submission, your lordship.
Adjournment. Wait. We'll finish that moving.
My lord,
Yes.
It's a suit for recovery of money. They've obtained the interim ex parte order, so I request to post it tomorrow, your lordship.
Fresh matter.
It's not a fresh matter, lordship. We are vacating for the interim order.
Vacating application is filed.
Kindly post it for tomorrow, your
Not
lordship.
tomorrow. Yes. 25th. Yes.
Lordship, pending matter, my lords. All connected matters stay has been granted. In this particular matter, stay has not been granted, my lords. It's been listed tomorrow before the trial court. And it's for defendant evidence, my lords. They are about to close the stage.
This matter is not granted stay in connected matter.
My lords, only in this matter, the respondents have objected, my lords. In the other 3 matters, they have not objected.
No,
That's why
it
only
is not depending upon that respondent is subjected. If you make out in a case,
Please,
court
my
will
lords,
grant that.
my lords will convince your lordship. Kindly have it tomorrow, my lords, because
When
it's
you are
listed.
not convinced that time, when similar matter is granted stay,
Please.
I don't think you have any case.
My lords, it's listed for tomorrow before the trial court, my lords. That's the only urgency.
17th, yes.
my lordship.
Submission, my lord, I moved the matter on last week Friday. Today the date has been given. The trial has not yet come, my lord. Just wait and inquire.
Give that memo. What is that number? We'll verify.
Memo ಕೊಟ್ಟಿದ್ದೆ ಸ್ವಾಮಿ. ಕೊಟ್ಟಿದ್ದು ಹಾಗೆ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ ಇವತ್ತು ಡೇಟ್ ಕೊಟ್ಟಿದ್ದು
Date ಕೊಟ್ಟಿರೋದು ಬಂದಿಲ್ವಾ?
ಬಂದಿಲ್ಲ.
ಕೊಡಿ ಅದು ಮೆಮೊ ಕೊಡಿ. We'll verify.
ಇಲ್ಲ ಅದು ಏನ್ ಹೇಳ್ತಾ ಇದ್ದಾರೆ one submission. It's the second time coming before the court. Returnable on 1/4 ಅಂತ ಅದರಲ್ಲಿ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಆದ್ರೆ 6 ಜನಕ್ಕೆ ನೋಟಿಸ್ ಹೋಗಿದೆ. ಸೊ ಇನ್ನೊಬ್ಬರಿಗೆ ಹೋಗ್ಬೇಕು. To that effect, I filed a memo for issuance of the notice. ಅದಕ್ಕೋಸ್ಕರ
ಆಯ್ತು ನೋಡಿ ನಾಳೆ.
ಇವತ್ತು ಬಂದ್ರೆ ತಾವು
ನಾಳೆ. Yes. Tomorrow. Yes.
ನಾಳೆ
Tomorrow.
ಫೈಲ್ ರೆಡಿ.
Tomorrow ಹೇಳಿ. Tomorrow. Yes.
Number ಕೊಡಿ sir, number.
My lords, memo for being spoken to, my lords. On 6th, the matter was listed, my lord. Lords were stayed the order, my lords, but the stay is granted to the disposed of matter, my lords, in the execution. It has to be read as execution 1 of 26, my lords. Instead, it is reading as 2 of 2021.
Yes.
My lordship. My lordship.
Tomorrow, my lords.
Yes, tomorrow. We'll verify if it is.
My
if
lordship.
Done it in the chamber, we'll do it. Yes.
Please, my lord.
The typographical error, we will do it. Let us.
Execution court has a date for tomorrow.
Yes, mister. If it is done, we will done it. Otherwise, we'll post it tomorrow.
Please, my lord.
My lord, both connected matter, old matter, my lord. My lord, the petitioners enjoying the interim order. I am for the respondent. I am filed IA, my lord. Yes, my
Here.
lordship. 2024.
Why that not vacated all these days?
My lord, from 20,
Yes, 6th.
please, my lord.
6th.
My lords, it's
Nale. Yes.
It's a RFA matter, my lords. IF for recall has been filed.
RFA matter tali. Friday.
Adjournments, if any, adjournments, list number 1, adjournments.
My lord, serial number 37, my lords.
17.
I am for the petitioner in this matter. There is some inconvenience for the senior today, my lords. Can we be taken up in the next week, any date, my lords?
Request of counsel for the petitioner. Leave this matter on 26th.
Grateful, my lords.
121. Correspondent B group.
121. What do you want, mister? Have you informed other side?
I'll inform them.
First inform ಮಾಡ್ಕೊಂಡು ಬನ್ನಿ.
This matter was disposed, my lords. Again, for being spoken, it has been restored.
ಆಯ್ತು ರೆಸ್ಟೋರ್ ಮಾಡಿದಾರೆ ಅಂದ್ರೆ ಏನೋ ಕೇಸ್ ಇದೆ ಅಂತ ಆಯ್ತಲ್ಲ. You have to inform first, mister.
I will inform.
You inform and mention at 1:30. Yes.
My lordships,
91.
Yes, at the request of 121.
serial number 103, my lord.
91.
For petitioner. I had an informed other side.
For the petitioner, you have informed other side. At the request of counsel for the petitioner, leave this matter up to 2 weeks.
Any date?
Yes. Yes, April 8th. Yes.
Serial 117, my lords. 117.
117.
This case of the petitioner, my lords. The respondent is served is unrepresented. Kindly have it
The
on
request
next.
of counsel for the petitioner, leave this matter up to 2 weeks.
Interim order may be extended.
Interim order extended till next date of hearing.
Oblige, my lords.
92. Yes, madam. Yes.
Objection was not received.
I have informed other side. At the request of counsel for the petitioner, leave this matter after 2 weeks. 2 weeks, interim order granted earlier is extended till next date of hearing.
Serial number 65, my lord.
60?
65, list number 1, my lord. Appearing with petitioners, my lord, kindly await notice put up on list.
Yes, awaiting service of notice to respondents. Interim order till next date of hearing.
Serial number 103, my lordship. For the respondent in this case, there's a bit of personal inconvenience. We have informed the other side they are present on VC.
Yes, 103.
3, my lordship.
103. Yes, at the request of counsel for
Respondent, man.
respondent, leave this matter up to 2 weeks.
My lordship, date may be kindly fixed.
Yes.
Date may kindly be fixed.
Yes, 8th April.
8th April.
Yes.
Grateful.
Serial number 11, my lord.
Serial number
Serial number 11. I'm for the proxy for the petitioner, my lord.
11.
Kindly have it tomorrow.
At the request of counsel for the petitioner, leave this matter next week.
Tomorrow.
Not tomorrow.
Tomorrow.
Next week, 17th. Yes.
Please.
Serial
My-
number 62, my lord. Wait for 63 more.
62. Awaiting service of notice, interim order till next date of hearing.
My lord,
I've informed the other side. And in 3 days time will be granted.
3.
3 days time will be granted. Lord.
Yes, at the request of counsel for the petitioner, leave this matter on 16th.
Interim order may kindly be extended.
Interim order extended till next date of hearing. Yes.
my lords, serial number 55, we have withdrawn the case, my lords. We have filed the memo in the registry.
Yes, filed in a memo seeking leave of withdraw. This memo is taken on record. The above petition is dismissed as withdrawn. Yes, ma'am.
Grateful, my lords.
Serial number 83, your lordship. Some office objections are there. Some urgency, your lordship. Today itself I will comply the office.
Comply ಮಾಡಿ.
ಅದೇ ಕೊಟ್ರೆ ಈಗ
Yes,
please.
List number 1 for preliminary hearing, serial number 1, N. Sridhar for petitioner.
Petitioner, my lord, plaintiff petitioner. The petitioner filed a suit for declaration against the respondent and also filed application at 39 rule 1 to IA number 1. The trial court issued emergent notice, sir. The IFR not to alienate the scheduled property until the next date of hearing, until disposal of the suit. The respond number 1 to 6 alienated the scheduled property in favor of respond number 7, dated 17/2/2025, my lord. 17/2/2025. We have filed a suit against the declare and also claim relief against the defendant number 7 not to alienate the scheduled property. This petitioner acquired the scheduled property under the compromise dated 19/1/2019. The father of the petitioner mortgaged the scheduled
but
property.
after that 11/11/2025 ಏನಾಯ್ತದ?
11/11/25, kindly, the suit summons served by the respondent, some of the respondents suit summons and notice issued by the trial court is not served here. They deliberately avoid the suit summons. The petitioner is in possession enjoyment of the scheduled property. The father of the petitioner is absolute owner more.
What is the next date?
Next day is date is Your Honor, next month it is.
What is that next date?
Stage.
6/8/2025 issuing emergent notice. Yes,
11/11
directed to dispose of in, consider your application for interim.
Until disposal of the application, may status quo may.
No, will directed him to dispose of that matter, IA.
Yeah.
Or he will take notice, which one you want?
Kindly I will take notice and until appearance.
Nothing, yes, from last 6 months, nothing is there, yes, issue emergent notice to respondent.
A trial court counsel kindly I've taken the.
In addition, permitted to take out, to serve a copy on the counsel appearing for the respondent before the trial court. Yes.
Serial number 2, R.V. Srinivasa Reddy.
Okay, date may be kindly fixed. I have served the copy.
Serve ಮಾಡಿ ಆಮೇಲೆ move ಮಾಡೋಣ. Yes.
Serial number 2, R.V. Srinivasa Reddy.
I'm for petitioner, my lord. I'm plaintiff in OS also, my lord. My lord, the suit is for eviction and recovery of arrear of rent, my lord. During the pendency of suit, I filed an application that is IA number 3, my lord, seeking direction to the defendant to pay the arrears of rent which is due from 1/2023, my lord. Even the defendant filed his objection. However, the trial court passed an order stating that the IA number 3 will be considered along with the application, my lord. That is page number 88, my lord.
You have filed a suit for recovery.
Eviction and
Recovery of
arrear of rent.
What is that application you have filed?
My lord, the application is for directing the defendant to pay the due amount, my lord. I mean arrear of rent, my lord, which is pending. My lord, the trial court has said that the application will be considered along with the main petition, main suit, my lord. The petitioner is a old age person, my lord.
Where is that order?
Page number 88, my lord.
Respondent is appeared.
Yes, my lord. Respondent has appeared, also filed an
no
objection.
representation reversed. There is an order on IA under so on. So plaintiff is absent and no representation. Hence, I will be taken along with that. ನೀವೇ ಪ್ರೆಸೆಂಟ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಇನ್ನೇನ್ ಮಾಡ್ತಾರೆ?
ಬರೋಷ್ಟಲ್ಲಿ ಅದು ಕೇಸ್ ರೀಚ್ ಆಗೋಗಿತ್ತು, my lord. So.
Yes.
And also the petitioner is 74 years, my lord.
Yes, notice.
My lord, I will take notice to the trial court advocate,
In
my lord.
addition, permitted to take out, serve
And
a
also
copy on the counsel
fix the
appearing.
date for hearing, my lord.
Serve ಮಾಡ್ಬಿಟ್ಟು move ಮಾಡಿ. ಅವ್ರು ಬರ್ಬೇಕಲ್ಲ, ವಕಾಲತ್ ಹಾಕಿದ್ಮೇಲೆ. Yes.
Serial number 3 adjourned. Serial number 4, Rajaditya Sadashivan for petitioner Joseph Anil Kumar A.
Serial number 3, my lord. Your lordship has adjourned it to 16th, my lord. Along with serial number 3, there is one more connected petition may have been clubbed along with that matter, my lord.
ಕೊಡಿ.
Yes, my lord.
Serial number 4, Rajaditya Sadashivan.
For the petition, my lord.
Yes.
Serial number 4 and serial number 122 are connected matters. They were ordered to be taken up together yesterday.
Yes.
And 122 actually is preliminary hearing only. It was ordered to be listed in preliminary hearing by mistake preliminary B group list ಮಾಡಿದ್ದಾರೆ. 122 ಮೇಲೆ.
Serial number 4 ಅಲ್ಲಿ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲ. Petition copy serve ಮಾಡಿದ್ರೆ
if they had asked for a copy
similar order is passed. It's been challenged. But ಆ petition ಏನಿದೆ ಅಂತ I'll have to just check.
ಏನು you are caveator?
No, it's not a caveat. No notice has been issued. ನಾಳೆ
If you want to assist the case, you assist. You are not filed any caveat. Don't insist that ಇದ್ರಲ್ಲಿ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಅದ್ರ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ. Day before yesterday also it is posted. It is posted today. Yes, Mr. Yes, what is your case?
This is challenging the jurisdiction.
I said post it today, Mr. Yes.
This is, if your honor may, if your lordship may recollect, the invoice had a small sentence saying that Bangalore court has jurisdiction.
Where is that?
They're relying only upon that. Sir, citations.
You got any judgment that invoice is there's an agreement?
6 of 4
Where citation?
Number ಕೊಟ್ಟಿದ್ದಾನೆ.
Yes.
On the last occasion, I had, your lordship has citations.
Yeah, yes, you have.
One citation of this honorable court of 1991.
Yes.
That is regarding page number 27, my lord. An extract of the Honorable Supreme Court cited in Hakam Singh versus Gammon, page number 27, my lord.
Yes.
Extract of the Honorable Supreme Court. Where there is a choice of forum, it is certainly open to the parties to agree on an exclusive forum for settlement of disputes. But such an agreement must be clearly spelled out either by
Page 20?
27, my lord, page number 27.
27, yes.
Para 14,
Yes.
Hakam Singh versus Gammon Supreme
Yes,
Court.
yes.
When there is a choice of forum, it is certainly open to the parties to agree on an exclusive forum for settlement of disputes. But such an agreement must be clearly spelled out either by express words or by necessary implication. Ouster of jurisdiction of courts cannot be lightly assumed or presumed. If there is such a concluded agreement, it will certainly operate as estoppel against the parties to the contract. If it is merely unilateral affirmation or statement made by one of the parties, as long as it is not shown that the statement has been accepted by the other party as a term or condition of the agreement, it cannot be held that there is an agreement
Yes.
to confer exclusive jurisdiction on
Yes,
any
Mr.
court.
What you said.
There are two other, directly on the point of regarding consignment notes.
Where is that?
Next citation, my lord.
Kerala.
Kerala High Court.
Yes.
Para 5, my lord, page number 35.
Yes.
Exhibits A2 and A3 are the consignment notes.
Give me the.
Your lordship has.
Yes.
Consignment notes in respect of the two consignments. It is admitted that the consignment notes were entrusted at Calicut for the purpose of transporting the same to Patna. The learned counsel admitted that no cause of action arose in Calcutta. He, however, relied on the note subject to Calcutta jurisdiction at the bottom of Exhibit A2 and A3 and contended that this would amount to a special contract between the parties so as to exclude the jurisdiction of the lower court and confer exclusive jurisdiction on the courts of Calcutta. The plaintiff first respondent has not signed Exhibit A2 and A3. There is no written contract between the parties excluding the jurisdiction of the courts other than the courts at Calcutta. Para 7, my lord.
Yes.
In United Insurance so-and-so, the division bench of this court had occasion to consider whether printing of words subject to Bombay jurisdiction alone in way bill would amount to a special contract. The division bench held that apart from the existence of these printed words, there was no evidence of meeting of minds between the consignor and the carrier. And in the circumstances, the printed words subject to Bombay jurisdiction alone cannot be treated as a special contract conferring exclusive jurisdiction on Bombay courts.
Yes.
In this case also, apart from the printed words, same. Next
Yes.
citation is also in the same lines, my lord, of Delhi High
Paragraph.
Court.
Paragraph.
Delhi High Court, last page number 45, my lord. Page number 45, para 19.
Yes. Yes.
No doubt, the copies of the bills raised by the appellants also contain a jurisdiction clause by stating all disputes are subject to Delhi jurisdiction. However, this condition is again subject to acceptance of the purchase order. Therefore, once the appellant agreed to supply the goods in terms of the purchase order placed by the respondent, which provides the jurisdiction in case of dispute, would be that of Faridabad courts only. Mere mention of the term subject to Delhi jurisdiction in their invoices will not annul the terms and conditions contained in the purchase order, which is the basis of accepting the purchase order by the appellants.
Eitherly, I'll just brief the facts. Purchase order was issued by the petitioner.
Yes.
Purchase order was received by the respondent in Bangalore. The registered office of the respondent is in Bangalore. The purchase order is also, I'll produce that purchase order. Purchase order is accepted here in Bangalore. Eitherly, purchase order, page number 2 is there.
Yes.
Page number 2 ali, address order to antida. That is to the left side.
Order to.
Ado Bangalore address. Thereafter, there is a relationship of purchase and supply between petitioner and respondent from a very long time. Page number 6. Page number 6 ali, the payment is made, part payment by the petitioner to the respondent in Bangalore address. The account I hold is in Bangalore. The part payment is paid in Bangalore.
No, that office of that.
Respondent is in Bangalore. ಇವರು ಜೈಪುರಿಂದ ಆರ್ಡರ್ ಮಾಡ್ತಾರೆ, ನಾವಿಲ್ಲಿ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ತೀವಿ, ಇಲ್ಲಿಂದ ಸಪ್ಲೈ ಮಾಡ್ತೀವಿ ಗೂಡ್ಸ್ನ, ಆ ಸಪ್ಲೈ ಮಾಡೋದನ್ನ ಅಲ್ಲಿ ಡೆಲಿವರಿ ತಗೊಂತಾರೆ. ದಟ್ ಇಸ್ ದ ಓನ್ಲಿ ಜುರಿಸ್ಡಿಕ್ಷನ್ ದೇರ್. Here, the offer what they have made, I have accepted in Bangalore.
Yes.
I have registered office in Bangalore.
Yes.
I have GST registered, which is also in Bangalore. Payment made by petitioner for the previous transaction and the part payment of this present dispute is also made to the Bangalore bank address. The cause of action, and I have made a demand. I have made a demand saying that you have not paid the balance amount paid. That is also from Bangalore.
Yes.
One. And thereafter, my lord, the invoice after the purchase order, which the petitioner is.
Government advocate, yesterday you have received the copy from, you get it that, then you ask that, yeah, no, that is also there. Rubin Jacob to assist on that matter on that constitutional validity, whether it has to go to. Okay. Whether it has to go before the 226 or in the 227. Yes. Yes. Yes.
The cause of action, my lord, is arise in Bangalore. One more important aspect, my lord, petitioner, serial number 122 ಅಲ್ಲಿ writ petition number 51522, ಅದರಲ್ಲಿ page number 53, my lord, where I have raised an invoice where the jurisdiction of Bangalore is shown. That is what petitioner is relying on. After I issue that invoice, the petitioner has never raised any objection, saying that no, this cannot be the jurisdiction. It should be Jaipur or some other place. That is not the case of the petitioner. I issue a notice. In the notice, he is not disputed the jurisdiction of Bangalore. The pre-litigation is filed.
Yes.
As per the Commercial Court Act. In that also, there is no dispute about the jurisdiction. Only when the written statement is filed, a vague line is made saying that this court has no jurisdiction. On what basis? It has not been brought to the notice of the court. Lord, I am relying on few judgments where the coordinate bench of this court has, in the same company, a commercial appeal, Lord.
Yes.
Page number 17, 17.
Yes.
17, sorry, 18.
Yes.
Idರಲ್ಲಿ, the similar facts were there, where on the purchase order, the jurisdiction was mentioned. Here, in this case, we don't have a contract. In the present case on hand, we don't have a contract. What is the contract? The contract which is made by the purchase and the invoice, that amounts to contract. If the contract is disputed, that is a different issue. Now, the contract is through the invoice, it has been accepted. Thereafter, the supply is made. When the dispute regarding the balance payment is arise, the jurisdiction issue has been raised. Here also similar facts.
Yes.
Second line ali, it starts and anta start agutte.
Yav page?
Page number 18. And where the contract ought to have been performed, the purchase order, idrallo purchase order, being the contract of supply between the parties, were issued by the appellant from Bangalore, Karnataka. The said purchase order admitted document have been marked as exhibit so and so before the commercial court. Here the dispute was that commercial court Bangalore has no jurisdiction.
But what is the finding of the court?
Finding of the court is at page number 35. Page number 35. Para number 20.
One sentence. Other than our word, next sentence, the person who's disputing jurisdiction has come down to Bangalore and physically issued a purchase order, and a contract is there in this particular citation. Exhibit P7, same sentence, next para 8, page number 18.
Yes.
Next sentence. The purchase orders are admitted and have been marked as exhibit P. The exhibit P7 is will indicate place of issuance is in Bangalore. They have come down to Bangalore. Here, there is no purchase order.
Let him complete, then you can answer.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ page number 20 ಮಲ್ಲ.
Yes.
Page number 35, sorry, para number 20.
Yes.
In the case on hand, There is no dispute between the parties that the purchase order were issued in Bangalore, Karnataka. Additional invoice raised by appellant were payable at Bangalore. That is, I have already showed, my lord. The part payment was made in Bangalore. It is also not in dispute the parties commenced the discussion as engaging the service of the respondent for so and so in June 2021. And the first meeting were to discuss the terms and contract was held at appellant's office at Bangalore. It is also not in dispute that the supply of cotton fiber by the appellant and the subsequent supply converted by the respondent to two districts are separate transaction. Exhibit P7, the purchase order, which is an admitted document, indicates that the place of issuance of Exhibit P7 is shown as Bangalore, where the registered office of his appellant is located. The purchase order were also accepted by the respondent, and the communication of which is also received by the appellant at Bangalore, Karnataka. The representatives of the parties had a meeting on so and so, which was held at the corporate office at appellant at Bangalore. In this meeting, the respondents expressly agreed to supply the remaining quantity of finished so and so. Here, everything happened in Bangalore, my lord, but the commercial court had taken a different view. That is being struck down by this coordinate bench of this court.
Provisions of the explanation 20C of the code also information disclosing of the Supreme Court to court where of the considerable that section of the plaintiff.
Section 20 clause C of CPC is being appreciated here, where the cause of action partially has been agreed.
You will take notice to whom?
The respondent.
Only one respondent.
Howdo.
In the
Innondu
connected matter
judgmental.
also. Connected matter also.
Connected matter also only one
Yes,
respondent.
You take that notice. So and so is undertake to appear for respondent.
I've already
You also
filed
serve a copy to him. Yes.
Only
Copy
serial number 4 I have not
Isn't
served
it?
copy. Serial number 122 I have already served a copy.
Yes, on judgment also you copy.
I've already served.
Kindly stay may be granted because nalega
Yeah, stay long.
stay jurisdiction is heavily
When is
disputed.
that next date? Mr.?
Tomorrow.
Yes. Tomorrow don't precipitate that matter.
I will not, my lord.
Yes.
I may be permitted to file a memo that they should not proceed.
Fix the date, we'll hear and dispose of it. We'll have it on, yes, on 7th April.
Only request is the lower court may be directed to
ಅಲ್ಲ, 7th
adjourn.
ವರೆಗೂ after
Because no
7th
such thing.
ಹೋಗಿ
No,
ನಾವೇ
one
ಹಾಕಿ
ನಿಮಿಷ.
ಹೇಳ್ತೀವಿ ಸುಮ್ನೆ.
15
I will-
in 1522 this honorable court had
ಅಲ್ಲ,
directed the lower court
the
to
reason
adjourn
I-
by 2 weeks. Kindly similar order may be passed to directing the trial court to
Now he is
adjourn.
undertaking that, he will not.
I will bring to the notice of the court.
ಇವ್ರು ಪ್ರೆಸಿಡೇಟ್ ಮಾಡದೇ ಇದ್ರು
ಅವ್ರು ಮಾಡ್ತೀವಿ ಅಂತ ಅಂದ್ರೆ you move that matter before this court, I will grant it.
ಇವ್ರು ಪ್ರೆಸಿಡೇಟ್ ಮಾಡದೇ ಇದ್ರು ಕೇಸ್ ಸಿಸ್ಟಮ್ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಇದೆ
ಆಯ್ತು.
ವಿತೌಟ್ ಪಾರ್ಟಿಸಿಪೇಷನ್ ಆಫ್ ಪಾರ್ಟೀಸ್ itself
ನೀವು
court is duty bound to fix
Sir,
dates.
Council, I am saying that tomorrow is that matter. Tomorrow, both will say that matter is
Posted on 7th.
7th.
It
If
may
the
be
court
posted
say, no, I
thereafter.
will go on with that matter, move that matter day after tomorrow, I will grant an interim order.
Kindly today's order may be released today itself. Today's order may be kindly be released today itself.
What today's order?
ಇಲ್ಲ ಇವತ್ತು ವೆಬ್ಸೈಟ್ ಅಲ್ಲಿ ಅಪ್ಲೋಡ್ ಆದ್ರೆ ನಾಳೆ ವೀಕೆಂಡ್
Both the councils are saying that matter has been heard and urgent that if you take this, don't take an order, you take this advantage, mention before the court. If court is not agreed, move that matter day after tomorrow, I will grant an interim order. Yes, it's all commercial matter, Mr. Yes.
Much obliged.
Say number 5, Pradeep S. Saukar.
The petitioner, my lord. Lord, I've only sought for expeditious disposal, my lord.
Yes.
Lord, in fact, since 2019, matter is posted for cross of PW1. Lord, till today, they've been successfully being able to evade it. Lord, suit for specific performance. Lord, if your lordship sees, my lord, the order sheet, page 40, my lord, of the writ petition, if your lordship takes.
No, you are the plaintiff.
I'm the plaintiff, my lord. I've filed a suit for specific performance. 2019, my lord, I lead the evidence. Plaintiff leads the evidence. My lord, it's posted for cross-examination. Then, my lord, they do not appear several stages, my lord, it gets closed. Then, my lord, they file recall application.
Yes.
That gets allowed. Even after that, they don't cross-examine. Lord, the latest order sheet, if your lordship sees, my lord, page 83 onwards. Page 80 onwards, my lord. It's still posted for cross of PW1, my lord.
80?
Page 8, if your lordship sees, my lord, page 80.
83?
Page 80, my lord.
80?
Yes, my lord.
Yes.
Lord, stage gets closed, defendant evidence taken as nil for arguments. Idadmele page 81 nodidre, then my lord, they make another application for setting aside ex parte. Then my lord, bottom. Then my lord, in 2024, they file an application for filing a written statement. My lord, that gets allowed. Additional issues gets framed, further evidence of plaintiff. Then my lord, page 83.
Yes.
For cross of PW1 by D4 to D7 by so and so. My lord, not present. Then my lord, page 84, your lordship sees. Counsel
Yes.
for defendant not present. PW1, cross of PW1 finally by 12-2.
Yes.
Then page 85, my lord. They come up with another application for framing additional issues in 2025. My lord, that also I say no objection, that gets allowed. Matter is posted for defendant evidence. My lord, page 86, your lordship sees.
Yes.
For cross of PW1 again at the bottom, 19/6/2021.
Yes.
Page 87, they again seek time for further cross-examination. No convincing reason made out, adjournment, further cross of PW1 taken as nil, defendant evidence by 19/8. Then page 88, they file one more application for recall.
It is
Page
recalled.
88. They file another application for recall PW1 for cross-examination.
Yes.
Page 88, your lordship will see. My lord, since 2019, PW1 has been present in court, my lord, for tendering himself for cross-examination. For
Yes.
some reason or the other, they are evading. I've only asked for expeditious disposal, my lord.
In this writ petition, petitioner sought for following relief. Petitioner, plaintiff filed suit for
Specific performance, my lord.
specific performance of the contract.
Agreement for sale dated
Agreement
31
of sale.
2013.
Dated
31 2013.
31/2013. After appearance of the respondent, defendant, they have filed a written statement. On the basis of the pleadings of the parties, issues has been framed. Matter is set down for evidence. Learned counsel appearing for the petitioner submitted that suit of year 2017. The defendants, one or the other reason, dragging the matter. Hence, he sought for early disposal of that suit. In view of the above, without expressing any opinion on the merit of the case, since suit is of the year 2017, it's a commercial suit of year 2017.
2017. CCH OS only, my lord. It is before CCH 68.
Commercial OS number
Yes,
one.
my lord.
Other
Sir, sir. Commercial OS, sorry. Sir.
commercial or this thing, Mr.
Lord, it is before CCH 68, my lord. Regular court only.
Number ನೋಡಿ ಮತ್ತೆ
OS number 1156 of 2017.
ಕಮರ್ಷಿಯಲ್ OS ಅಂತ ಹಾಕಿದಾರಲ್ರಿ COM.OS ಅಂತ ಹಾಕಿದಾರಲ್ರಿ ಪೇಜ್ 62 ನೋಡ್ರಿ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ all that pages it shows that commercial OS.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಒಂದು ಮಾತ್ರ ಇದೆ. Then my lord, your lordship sees subsequent dates. I think that's some mistake. CCH
All pages
68
you see,
ಅಂತ.
Mr. From 60 all pages it shows that commercial.
My lord, only this one order on IA3 it shows as commercial OS.
Commercial but
ಅದಾದ್ಮೇಲೆ ನೋಡಿದ್ರೆ ಎಲ್ಲ OS 1156 ಅಂತಾನೆ ಇದೆ.
Yes, I think after that it has been transferred to the
regular court.
Then there may
CCH
be
68
is the reason for delay, Mr.
Yes.
Yes. Pending commercial but OS number so and so is pending from 2017. In view of the above, without expressing any opinion on the merit of the case, the trial court is directed to dispose of the suit as expeditiously as possible, not later than 6 months from date of receipt of the copy of this order. Parties are directed to cooperate for early disposal.
Let them not take any further time for
Yes.
Great.
Number 6, Kenchegowda PM.
Dismissed on the ground that in barred by limitation, my lord, that I have filed second respondent filed by the application for rejecting of the claim petition, my lord. But now is as principal, settled principal, my lord, is apex court held that in barred by limitation, my lord, is considered that in
Now, what is that order you are challenging?
annexure F, my lord. IA3 filed by the second respondent, my lord.
You are the plaintiff.
Page number, my lord, 26, my lord.
New plaintiff or defendant?
I am the claim petition, my lord, petitioner, my lord. In the
Petitioner.
Please.
in MEC matter.
Please.
Hmm.
But tribunal is rejected that allow the application filed by the second respondent and rejected our application, my lord, condemnation of the delay without given any reason, my lord.
Hmm.
But in our court, my and office court also hold that larger bench on 16th, my lord.
16th, yes, you take notice or issue notice.
Serial number 7, Janardana G for petitioner.
Petition. Not actually, K I am questioning, but I filed a memo that to delete D2 and D3, respond number 2 and 3 due to subsequent development. But what happened was that I have filed a suit against the BESCOM to disconnect the power connection to the suitable property because it is legally obtained by the respond number 2 and 3 by filing an injunction suit. But the trial court has dismissed their suit, they are not in possession. That thereafter, he filed a declaration suit, he lost it. And this Honorable Court rejected their plaint, went to Supreme Court, they lost it. Then subsequently I said that they doesn't have any subsisting interest over suitable property. So question of they are contesting the matter does not arise. Delete and direct the BESCOM to disconnection of power supply, so that issue may be decided. But the learned judge says, no, you want to, he can be re-agitate the same matter, so they cannot be deleted.
No, that private party has filed in a suit against you. Again.
Yes, my declaration suit they have filed. Earlier they filed a suit for injunction. The trial court has given a clear finding. Annexure D.
They are not in the position.
They are not in
the owner,
possession, and they ought to have filed a suit for declaration. But then they have filed a suit for declaration that has also they have lost and confirmed by Supreme Court.
Now you have filed in a suit for what?
I have earlier what happened by virtue of the interim order which they have in their suit they have obtained interim order. Then they got the illegally power connection, even though it was a vacant site as per the schedule which they have given. Then, my lord, I have filed a suit against the BESCOM, given a representation. In spite of that, they want to proceed with giving power connection illegally. But I have filed a suit for mandatory, temporary injunction, permanent injunction. Then, on coming to know the power connection is given, I filed a suit for converted into a mandatory suit for mandatory injunction. But that was pending.
No, see. They have taken a connection.
Yes.
Who are you?
Yeah. No, I am the owner of the property.
Where is that owner? You have not filed any suit for declaration and all.
I have not. He filed
lost that suit.
He has lost it.
He has lost.
He has
doesn't
also,
mean that you are the owner.
The court said I am the owner of the property.
You declare that you are the owner.
The court said, in his injunction suit, what said that? Court said I am the owner of the property. He is not in possession of the property. He ought to have claimed a declaration suit. But he filed a declaration suit against me saying that he is the owner of the property. Then he lost that case, went to Supreme Court.
No, if you are in the possession,
yes,
then you can ask that to disconnect. Why?
That is what I said.
No, then it shows that you are not in the possession. How can that give a power connection to him if he is not in the possession?
What happened was he filed a suit, obtained the interim order. On the basis of that, he went that. Kindly see this undertaking before the KEB annexure. I produced before this court. Kindly come to Millard, his annexure C, Millard.
I think you take notice.
Yes. But annexure C1, he said, my note, the BESCOM has noted my objection. Still, they have given possession on his undertaking that I will disconnect if the suit goes against me. Annexure C1, page 28, Millard.
Yes. After that, he has not.
He lost all the cases.
Notice.
That. Further, either the operation of this order or proceedings.
No, how can that operation is nothing but your.
You may stay further proceedings, not because evidence you wanted started with.
Yes. Stay of further proceedings in OS number 6461 of 2023, pending in the file of 44th additional city civil judge, Bangalore, till next date of hearing.
Right. Cell number 8, Aravinda, yes.
Petitioners, my lords. My lords, in the suit for partition, my lords, they have included self-acquired property, my lords, as joint family property, my lords. Here, item number 6 and 7 are 2 shops, my lords, which was purchased by my husband, who is late Shina Pujari, my lords, and there is a delay of 37 years, my lords. Even after the delay, they have considered it as in joint family property, my lords.
Again, application, what is that application you have filed?
For temporary injunction, my lords.
Who?
In MA, the trial court has ordered
ಆಯ್ತ್ರಿ OS ಅಲ್ಲಿ ಏನಾಯ್ತ್ರಿ?
OSL stay ಆಗಿದೆ ಸ್ವಾಮಿ.
ಯಾರಿಗೆ?
ಅಂದ್ರೆ ಟೆಂಪರರಿ ಇಂಜಂಕ್ಷನ್ ಅಗೇನ್ಸ್ಟ್ ಎಲಿನೇಟಿಂಗ್ ಕೊಟ್ಟಿದ್ದಾರೆ ನಮ್ಮ ಅಗೇನ್ಸ್ಟ್ ಸ್ವಾಮಿ. ನಾವು ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾ ಇದೀವಿ.
ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿ MA ಹಾಕಿದ್ರು, ಅಲ್ಲಿ ಏನಾಯ್ತು?
ಅಲ್ಲೂ ಸೇಮ್ ಇದಾಗಿದೆ ಸ್ವಾಮಿ. ಕನ್ಕರೆಂಟ್ ಫೈಂಡಿಂಗ್ ಆಗಿದೆ.
Where is that order of the trial court?
Annexure A, my lords. Page number. In Annexure A, my lords, in para 26, the court has
Page ಹೇಳ್ರಿ.
page number 20, 27, 20.
Trial court order ತೋರಿಸ್ರಿ.
ಇದೆ ಸ್ವಾಮಿ. 28. Annexure A. Para 26, my lords. Adರಲ್ಲಿ, on a careful perusal of the documents placed on record, it is established at this stage that suit item number 6 and 7, those are the shops, my lords, were purchased in the name of Shina Pujari, that is my husband, my lords, who is late Shina Pujari right now. They are standing in the name of said person. Even after
ಅದು now that has to be verified whether it is purchased from the income of your husband or a joint family.
My lords, the sale deed says that it was purchased from my.
ಅದನ್ನ ನೀವು ಹೆಸರಲ್ಲಿ ತಗೊಂಡಿರ್ಬೋದು. ಇನ್ಕಮ್ ಇತ್ತ ಅದನ್ನೆಲ್ಲ ವೆರಿಫೈ ಮಾಡಿ.
ಇನ್ಕಮ್ ಇತ್ತು ಸ್ವಾಮಿ, ಅದರಲ್ಲಿ
ಪ್ರೂವ್ ಆಗ್ಬೇಕು ತಾನೆ.
ಅದಕ್ಕೆ ಇದು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅದು along with that in our depositions we have said that we were working as a mason, my lord.
ಅದು ಫೈನಲ್ ಡಿಸೈಡ್ ಆಗ್ಬೇಕು.
Please,
ಈಗ ನಿಮಗೆ ಏನ್ ಇಂಜೆಕ್ಷನ್ ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ದಾರೆ? ನಾಟ್ ಟು ಎಲಿನೇಟ್.
ಆದ್ರೆ ಅಲ್ಲಿ ಡಿಫೆಂಡೆಂಟ್ಸ್ ಬಂದು ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಬಂದು ಕ್ಲೋಸ್ ಮಾಡಿಸಿದಾರೆ ಸ್ವಾಮಿ. ನಮ್ಗೆ ಅಲ್ಲಿ ಡೈಲಿ ಬಿಸ್ನೆಸ್ ನಡ್ಸಕ್ ಆಗ್ತಿಲ್ಲ.
Who has closed that?
The respondents, my lords.
Yes. You are in the position?
Yes, my lords.
ಎಲ್ಲಿದೆ documents?
Here only the
ಕ್ಲೋಸ್ ಮಾಡಿಸ್ತಾ ಇದ್ದಾರೆ ಅನ್ನೋದು ಎಲ್ಲಿದೆ ದಾಖಲಾತಿ?
That is I'll take instructions, my lord. But ನಮ್ಗೆ ಹಂಗ ಹೇಳಿದ್ದಾರೆ.
ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಅವರು. ನಾಟ್ ಎಲಿನೇಟ್ ಮೇಲೆ ಬಂದು ಕ್ಲೋಸ್ ಮಾಡಿಸ್ತಾ ಇದ್ದಾರೆ, ನೀವು ನಡ್ಸಕ್ ಬಿಡ್ತಾ ಇಲ್ಲ ಅಂತ. 21.
In 1 week, my lords.
Yes. Is this matter on 25th? Yes.
Any stay may be granted, my lords.
No, you are produce ಮಾಡಿ.
Please,
then we'll see. Yes.
Cell number 9, CR Subramanya.
Petitioner, plaintiff before the trial court, he filed the suit for partition and several partition. And all the suitable properties. And he filed an application under R6 to 17. It is produced annexure D, my lord. In page number 87. 87.
You have filed an application?
Yes, madam.
What is that amendment you are sought?
Amendment is a proposed amendment sought for in the plaint by the plaintiff in the plaint government 6 in line number 3. Delete the words the plaintiff was a small child and thereafter had the word the. In line number 5 of the government 6, delete the word 25 by substituting the word 10. In the same line, delete the word.
ಯಾಕೆ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರು?
There is no clarity ಅಂತ.
ಏನ್ ಮಾಡ್ಬೇಕಂತ ಹೊರಟಿದ್ದೀರಾ ನೀವು?
ಅದನ್ನ ಈಗ ಸ್ಮಾಲ್ ಇಲ್ಲಿ ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಅನ್ನೋ ವರ್ಡ್ ನ ತೆಗೆದಾಕ್ಬೇಕಾಗುತ್ತೆ. ನಂಬರ್ಗಳು ಆಲ್ಟರೇಷನ್ ಮಾಡ್ಕೋಬೇಕಾಗುತ್ತೆ. ಆಮೇಲೆ ಡೇಟ್ ಆಫ್ ಬರ್ತ್ ನ ಇನ್ಸರ್ಟ್ ಮಾಡ್ಬೇಕು ಅಷ್ಟೇ.
ಎಲ್ಲಿ ರೀಸನ್ ಎಲ್ಲಿದೆ?
ರೀಸನ್ ಕೈಂಡ್ಲಿ ಪೆರೋಸ್ ದಿ ಪೇಜ್ ನಂಬರ್ 96 one. 96 ಅಲ್ಲಿ the plaintiff has filed IA number IA under 617 read with section 151 seeking the amendment in the plaintiff mention the application along with the application affidavit filed by the plaintiff.
Respondent object ಮಾಡಿದ್ರು?
ಇಲ್ಲ ಮಾಡಿಲ್ಲ. There is record ಆಗಿದೆ. Defendant have not filed any objection to IA.
Issue notice. Stay of further proceedings in OS number
274 of 10.
274 of 2020 pending in the file of senior civil judge JMFC Ramnagara till next date of it. Please.
Cell number 10, HR Santosh.
My lord, here the petitioner is invoking the supervisory jurisdiction, my lord. The petitioner has filed the injunction suit against the defendants, saying that the property belongs to him. So in that, my lord, at page number 55, my lord, 54.
Yes.
when the petitioner has brought the witnesses, the PW 5 and 6, the court has made us following observation, my lord, saying that already mark ಮಾಡಿದರೆ plaintiff document, ಹಂಗಾಗಿ proof ಮಾಡೋ ಅವಶ್ಯಕತೆನೇ ಇಲ್ಲ ಅಂತ ಹೇಳಿ. That's a
No, that you are sued for
injunctions, my lord.
injunction.
Injunction.
What is that order you are challenging?
The page number 54, my lord.
Odi.
PW 5 and 6 are present, respective counsels present. Lower court for
54.
Page number 54, my lord.
54 ಅಲ್ಲಿ ಎಲ್ಲಿದೆ PW
The ಕೆಳಗಡೆ, my lord, the order sheet ಅಲ್ಲಿ.
Order sheet ಅಲ್ಲಿ ಏನಿದೆ? PW 5 and 6 are present.
Yes, my lord. Next paragraph. In the present case, the PW 5 and 6 has been examined in order to prove that the PW 5 and 6 as installed a fogger, mister, water tank and pipe in lines over the suitable property. Now the counsel of the plaintiff wants to identify the exhibit P 38, 39, 41, 42 and 43, which have already been marked on behalf of the PW1. But this court opinions that the said documents have already marked on behalf of the plaintiff, and it is not necessary to identify once again on behalf of the PW 5 and 6.
ಒಂದ್ಸರಿ ಮಾರ್ಕ್ ಮಾಡಿದ್ಮೇಲೆ ಇನ್ನೇನಾಯ್ತು?
ಇಲ್ಲ ಮೇಡಮ್, ಮಾರ್ಕಿಂಗ್ ಇಸ್ ಟೋಟಲಿ ಡಿಫರೆಂಟ್ ಅಂಡ್ ಪ್ರೂವ್ ಮಾಡೋದು ಡಿಫರೆಂಟ್ ಮೇಲೆ. ಯಾಕಂದ್ರೆ PW 5 and 6 they are the suppliers and also installer. ಅವ್ರು ಇನ್ಸ್ಟಾಲ್ ಮಾಡಿರೋದು. Actually the claim of the defendant is that they have ಕನ್ಸ್ಟ್ರಕ್ಟ್ ಮಾಡಿದ್ರಿ ಅಂತ ಅವ್ರದ್ದು ಕ್ಲೈಮ್ ಇರ್ತದೆ, ಅವ್ರು ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಿ ಅಂತ. ಇಲ್ಲಿ ಆಕ್ಚುಲಿ ಇರ್ಬೇಕಂದ್ರೆ ದೇ ಆರ್ ಸಪ್ಲೈಯರ್ ಆಕ್ಚುಲಿ ಫ್ರಮ್ 2006 ದೇ ಆರ್ ಸಪ್ಲೈಯಿಂಗ್.
ಇವ್ರ ಹತ್ರ ಏನ್ ಹೇಳಿಸ್ಬೇಕಂತಿದ್ದೀರಾ ನೀವು?
ಇಲ್ಲ, ಆ ಡಾಕ್ಯುಮೆಂಟ್ ನಮ್ದೊಂದು ಮಾರ್ಕ್ ಮಾಡಕ್ಕೆ ಅಷ್ಟೇ, ಏನಿಲ್ಲ ಮೇಲೆ. ಆ ಡಾಕ್ಯುಮೆಂಟ್ ಇದು ಮಾಡ್ತಾ ಇರೋದು ಮತ್ತೆ ಏನು ಮೆನ್ಷನ್ ಆಗಿದೆ ಎಕ್ಸಿಬಿಟ್ಸ್ ಅಲ್ಲಿ, ಅದು ನಮ್ದು ನಾವು ಸಪ್ಲೈ ಮಾಡಿದೀವಿ, ನಾವು ಇನ್ಸ್ಟಾಲ್ ಮಾಡಿದೀವಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅಷ್ಟೇ, ಇನ್ನೇನಿಲ್ಲ ಮೇಲೆ ಅದರಲ್ಲಿ.
Yes, or issue notice stay of further proceedings in OS number 128 of 2019 pending in the file of first additional civil judge JMFC Moodgere till next date of hearing.
Cell number 11 adjourned, cell number 12 Virupaksha PH.
Petitioner.
Yes.
The petitioners are challenging the order at annexure J, my lord, page 106, my lord. My lords, in the regular appeal, my lord, which is filed by the respondent number 124, my lord, challenging the dismissal of the suit, my lord, by the trial court. An appeal is filed, my lord.
That suit for?
My lord, suit for partition and separate position, my lord.
It is dismissed.
It is dismissed, my lord, which was filed, my lords, by defendant number, that is, my lord, I'm sorry, my lord, by respondent number 4.
No, filed by the plaintiff.
Plaintiff, my lord, who is respondent number 5. He did not choose to file any appeal, my lord.
Who has filed an appeal?
The defendant number 2 in the suit, my lord, has filed an appeal. In fact, the defendant number 2 is, my lord, no more. Her LRs, my lord, who are respondent number 1 to 4, my lords, have filed an appeal.
Appeal ಹಾಕಿದ್ಮೇಲೆ ಏನಾಯ್ತು?
My lords, now, my lords, if your lordship kindly peruse, my lord, the impugned order at page 106, my lord. There was a delay, my lords, of 1975 days, my lord, in filing the appeal. The learned first appellate judge, my lords, has allowed, my lords, the application filed by the respondent number 1 to 4, my lord.
What is your defense before the trial court?
My lords,
So family member.
I am also family member, my lords.
Why suit is dismissed?
Suit is dismissed, my lord, on the ground, my lords, that partial partition, my lords, is not maintainable. The trial court, my lords, has dismissed the suit, my lords, on the ground that all the properties, my lord, if your lordship kindly peruse, my lord, page 73.
If that is the case, trial court has to ask to include all the properties. It cannot be dismissed, Mr.
My lords, sufficient opportunity was given, my lord, to the plaintiff and also defendant number 2, who has now filed the appeal, my lord.
No, that
before the trial
why
court.
you have not included? You are not family members.
My lord, I am also family member, my lord.
Then
However, my lords,
property is partition.
partition, my lord, and separate position.
No, if it is partition, you will also get benefit. Why you are objecting that?
My lord, my defense, my lord, before the trial court, that there was already a partition, my lord, between the family members. But the learned trial judge, my lords, however, proceeded to hold, my lord, that few of the properties which were not made.
Then you have not challenged that.
My lords, that I have not challenged.
Then
I am happy, my lords, with the judgment and decree. In fact, the plaintiff, my lord,
degree says earlier partition was not there. Only that
My lords,
partial partition. It is always open for them to file in a fresh suit also.
my lords, all the parties, my lord, they are all enjoying, my lords, their respective shares, my lord, which were allotted to their share. However, my lords, the plaintiff, original plaintiff, my lord, did not choose to file any appeal, my lords.
ಯಾರ್
Against-
ಬೇಕಾದ್ರೆ ಮಾಡ್ಬೋದು partition suit ಅಲ್ಲಿ.
My lords, now, my lords,
What is the difficulties or prejudice caused to you if condoning the delay and
my lords,
allowing
the
that appeal, Mr.
prejudice, my lord, is that all the parties, my lord, they have been enjoying, my lords, the properties which have been allotted to their shares.
Trial court ಅಲ್ಲಿ earlier partition ಅನ್ನ upheld ಮಾಡಿಲ್ಲ.
The trial court has only dismissed, my lord, on the ground that all the properties.
ಇವತ್ತಲ್ಲ ನಾಳೆ ಇನ್ನೊಬ್ರು ಹಾಕ್ಲೇಬಹುದು suit.
Suit, my lord, they have all contested, my lord, the suit, and it was decided, my lords, on merit.
No, it is not decided on merit. Partial partition. ಇನ್ನೊಂದು ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಹಾಕಕ್ಕೆ ಏನ್ ಬಾರ್ ಇಲ್ಲ, ಇನ್ಕ್ಲೂಡಿಂಗ್ ಆಲ್ ಪ್ರಾಪರ್ಟೀಸ್.
ಅಲ್ಲ ಇನ್ಕ್ಲೂಡಿಂಗ್
ಅವಾಗ ಹಾಕಿದ್ರೆ ನಿಮಗೆ ಇನ್ನೂ 10 ವರ್ಷ ಆದ್ಮೇಲೆ ನಿಮ್ ಪ್ರಾಪರ್ಟಿ ನೀವು ಪೊಸಿಷನ್ ಅಲ್ಲಿ ಇರೋದು ಇನ್ನೂ ಡೆವಲಪ್ ಮಾಡಿದ್ರೆ ಇನ್ನೂ ಪ್ರಾಬ್ಲಮ್. Should I not settle now itself?
My lords,
It helpful for you also, Mr.
my lords, the parties, my lord, since my lord, they are all, my lords, settled, my lords, with their properties. Now reopening the, my lords, the partition would be, my lord.
ಎಲ್ಲರೂ ಸೆಟ್ಲ್ ಆಗಿದ್ರೆ ಅಪೀಲ್ ಯಾಕೆ ಆಗ್ತಿದ್ರು? ಯಾರೋ
ಅದೇ ಒಬ್ರು, my lords, one person, my lord, is not happy, my lords, with the.
He can file a suit also.
My lords, then, my
There is
lords.
no bar. ಅದ್ರ ಬದಲು ಅಪೀಲ್
ಅಲ್ಲ,
ಹಾಕಿದ್ರು.
they had contested the suit, my lord, they had filed counter claim also. ಅವ್ರು ಇನ್ನೂ ಸ್ವಲ್ಪ ಪ್ರಾಪರ್ಟೀಸ್ ಅದನ್ನು ಸೇರಿಸಬೇಕು ಅಂತ the defendant number 2 had contested. That, my lords, was also rejected by the trial court.
If it is rejected, that partial partition is not maintainable. Is it bar for them to file a fresh suit?
My lords, fresh suit also would be barred, my lords. They will have to only
Where is
challenge
that?
it by, my lords, by way of appeal.
Yes.
That is what they have done, my lords. They have filed an appeal, my lords, before the learned first appellate judge. That too, my lords, the appeal is filed after a lapse of, my lord, more than 5 years, my lord.
When the suit is disposed of?
Suit is disposed, my lords, in the year 2019, my lord.
19 ಇಂದ 21 ಕೋವಿಡ್.
21 COVID. 24 ಅಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ.
22 ವರೆಗೂ ಕೋವಿಡ್.
20, my lords, even after that, my lords, for over 2 years, my lords, there was delay.
Yes, you contest on that merit. Why do worry, Mr.?
My lords,
What is the reason given by the trial court?
the trial court holds, my lord, that the original defendant number 2, my lords.
Close to that respect to March 2020 till 2021, on several restrictions were imposed on the central government, state government, so on. So delay is not count on appellant. Learned counsel for the respondent while opposing the application for condonation are relied upon the authorities by limitation act. Excluded that still remains substantial delay in preferring the pliancy become necessary. Was examining PWN wife defendant was suffering from a throat cancer and was undergone continuous medical treatment. She was suffering from the throat cancer.
My lords, the original defendant, my lords, was suffering. She passed away, my lords, in the year 2022, my lords, February 2022. Even thereafter, my lords, for over 2.5 years, my lord, the appeal was not filed.
Was produced death certificate that Mumbai lost 25 years and he was used to visit Davangere occasionally. Family remains. No, Mr. They have given a sufficient reason, Mr.
My lords,
It's a pursuit for partition.
Suit for-
No
my lords.
prejudice will cast to you, Mr.
my lords, however, my lords, for over 2.5 years, my lord, there is no reason assigned, my lord, for condonation of delay.
I will say, what is that reason which has been? No, it's, she was suffering from the cancer
Lords,
after that death.
Cancer, I agree, my lords, she passed
Family
away.
members, it is a partition suit. Limitation al dismiss ಏನ್ರಿ ಆಗುತ್ತದೆ? Yes. Yes, that's all. Contest the matter on the merit, Mr. Yes, tally. This petition is filed challenging order dated 30/10/2025. ನೀವು ಕೂಡ ಆಮೇಲೆ 5 ತಿಂಗಳಾದ್ಮೇಲೆ ಬಂದಿದ್ದೀರಿ.
ಅಲ್ಲ,
Yes, 30/10/2025, passed in RA number 44 of 2024, whereby application filed by that appellant under section 5 of the Limitation Act has been condoned. Respondent number 4 herein is a plaintiff filed in a suit for partition and separate position.
Lords, I'm sorry, my lord, only one judgment, my lords, of the Honorable Supreme Court.
Yes.
To say, my lord, that there should be sufficient cause, my lord.
Yes, it is settled law, Mr.
Please.
There is no such. Yes. Yes.
Lords,
The suit came to be dismissed. Where is that? Agree?
my lords, page 40, my lord, annexure C.
Suit came to be dismissed on 1st March 2019, OS number 105 of 2015, filed in the additional senior civil judge JMFC Davangere on the ground that suit for partition on in the suit for partition, the partial partition is not maintainable. Being agreed by the judgment and degree dated 1st March 2019, the defendant number 1 has filed an RA before additional senior civil judge Davangere, third additional senior civil judge Davangere. ಅಲ್ಲ ಎಲ್ಲಿದೆ ಆರ್ಯದ ಆರ್ಡರ್?
My lord, page annexure D, my lord, page 77. Order is at page 106, my lord.
Before district and session judge Davangere in area number 44 of 2024. There was a delay of 1975 days in preferring that appeal. IA 1 of 2024 is filed for condonation of delay. By impugn order, trial court has condoned the delay. Being agreed by the same, the petitioner is before this court. Learned counsel appearing for the petitioner submitted that there is a delay of 1975 days in filing an appeal. There is no proper reason has been given for condonation of delay. The trial court has allowed that application. In support of his contention, he is also relied on judgment of Apex Court in 2022 SC 332, stating that when the parties has not shown sufficient cause for condonation of delay, order condoning the delay is unsustainable. Not shown sufficient cause, if the court is condone the delay, that such an order condoning the delay is unsustainable. It is not in dispute. Suit filed by the plaintiff is for a partition. The petitioner herein is also one of the family member. The suit for partition was dismissed only on the ground that partial partition is not maintainable. Being agreed by the same, one of the defendant has filed an appeal in area number 44 of 2024 and also filed an IA for condonation of delay. The judgment of the trial court was passed on 1/3/2019. Appeal came to be filed on 13/8/2024. During that time, there was a COVID-19 pandemic. The restriction was there from March 2020 to December 2021. Even thereafter, also there was delay in filing the appeal. The trial court has examined first appellant has PW1. It is categorically deposed that PW1's wife was suffering from throat cancer and was undergone continuous medical treatment until her death on 10/2/2023. To that effect, he has also produced Exhibit P1 death certificate of his wife and Exhibit P2 as medical history document. Considering all these aspects, and also relying on the judgment of the Apex Court in 2025, Live Law SC 399, the trial court has condoned the delay. Since this is a suit for partition, which was dismissed only on the ground that partial partition is not maintainable, and that appellant before the first appellate court has given a sufficient cause for condonation of delay. Considering that aspects, trial court has rightly allowed that application. There is no error in the order passed by the trial court, first appellate court. Accordingly, the petition is dismissed.
Serial number 13, Jaganmohan MT for petitioner, Reena R.
Yes, petitioner here challenging the orders dated 31/1/2026. Annexure D at page number, impugnated as page number 30.
Yes.
The respondent number 1 filed a suit for partition. The trial court granted 1 share in partition. One of the respondents challenged that in first appeal. That was appeal was dismissed, confirmed the trial court judgment. After that, the respondent number 1 filed a FDP, present FDP 11/2013. The commissioner appointed in that FDP to allot the share as per the. After commissioner appointed allot the share, the mother of this petitioners died. So petitioner filed application on 26/13 to allot the shares which was granted to her mother, to her and the respondent 6-9. That was rejected by trial court. Against that,
Why?
because trial court hold that cannot be doing this present because already shares are already granted.
Where is that?
Reasoning at page number 34, my lord. Respondent number 2 has filed the application to review the order dated when passed by the application by stating that review of the said order is quite necessary as the respondent 2 is no more and seeking allotment of share in the mother's property by the respondent number 2 C.
Mother share ಕೊಟ್ಟಿದ್ರಾ?
ಕೊಟ್ಟಿದ್ದಾರೆ. Mother share ಕೊಟ್ಟಿದ್ದಾರೆ. Instead of filing another partition suit, it can be decided in the same. ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅವರು
further proceedings in FDP number 11.
ಅಲ್ಲ ಈಗ ಫೈನಲ್ ಡಿಗ್ರಿ ಮಾಡೋದಕ್ಕೆ ಆರ್ಡರ್ ಮಾಡ್ಬಿಡಿ ಸ್ವಾಮಿ. ಪೇಜ್ ನಂಬರ್ 36 ಅಲ್ಲಿ ಇದೆ. ಡ್ರಾಯಿಂಗ್ ಆಫ್ ಫೈನಲ್ ಡಿಗ್ರಿ ಮೇ ಬಿ ಸ್ಟೇಟ್.
Yes, stay of further proceedings in FDP number 11 of 2013 pending in the file of first additional senior civil judge Chitradurga till next date of hearing.
Serial number 14,
Further proceedings ಅಂದ್ರೆ ಎಲ್ಲವೂ ಸ್ಟೇ ಆಗುತ್ತಲ್ರಿ, ಏನ್ ಡ್ರಾಯಿಂಗ್ ಏನ್ ಬಂತ?
Yes. Notice except as respondent 6-9 others may be dispensed.
ಕೊಡಿ ಮೆಮೊ ಕೊಡಿ.
Memo.
Serial number 14, Channabasappa SN for petitioner, Sampath A.
The objector in the execution proceedings. My IA number 8 under order 3 rule 2 and IA number 9 under section 151 seeking discard of evidence of PW1 has been dismissed for non-prosecution minutes.
Suit in execution.
Minutes. I am the objector in the execution minutes. Suit was for specific performance in which a compromise petition was drawn and then they came to my. I was in the possession of the scheduled property minutes.
How you came to the position? Wait, mister. How you came to the position?
Well, it's my title flow is I have produced all the documents. Exhibit P series have been produced by myself before as an objector minutes. In that I have led my evidence. Due to PW1, she is suffering from several ailments. She is not able to prosecute the matter. I had filed these applications. IA number 8 and 9.
What is that? Where is that order?
Minutes at page number 30 is the order sheet minutes. The typed copy of the same is also available.
Yes, which page, Mr.?
Typed copy is available at page number 44. PW1 absent. Shri NM filed IA 8 under order 3 rule 2A of CPC for representation as PA holder. Filed IA 9 for discard of evidence of PW1 and filed memo with Xerox copy of documents. Notes thereafter, the respondent, the decree holders and the JDR, both of the parties have not filed any objections to this.
ಆಯ್ತು ಆರ್ಡರ್ ಎಲ್ಲಿದೆ ತೋರಿಸ್ರಿ.
The impugned order is at page number 46, my lords. Sorry, my lords, page number 38 itself, my lords. The last portion of the page, my lords, case called out. In this case, objector filed IA 8 and 9 on 19/7/2023. Since then, not submitted arguments on these applications, hence both applications dismissed for non-prosecution.
Non-prosecution ಆಗಿರೋದು.
My lords, what has happened in this case, my lords?
If you have filed an application and not, filed an application in 2023, you have not submitted any arguments.
I'll try to convince your lords. My lords, what has happened is that there are there is a batch matters, my lords. Around 12 to 13 matters are being listed. They are a batch matters, my lords. One or the other confusion has happened, my lords, and we were not aware that the IA number 8 and 9 were our applications, my lords, since when they got dismissed.
You are in a council, you know that which case, which matter is posted, Mr.
My lords, this was unaware by us, my lords. There was a default on us, my lords. I go down to the court. I am just seeking permission of this honorable court to argue the matter on merits, my lords, before the trial court. That is my prayer, my lords. That itself is my prayer. Even my lords.
Document they have not prohibited. The application only dismissed for non-prosecution.
No, my lords.
You argue that there is no restriction.
No, my lords. We have not addressed our arguments over that.
Now, what is the stage?
Stage is for cross of PW1, my lords. She is not able to come to the court, my lords. That's why we had filed these applications, my lords. So I'm seeking for arguments on this applications, my lords. On merits, the trial court may dispose of the applications itself, my lords.
Yes, Mr.
My lords, maybe we are not served the papers yet. We maybe serve the documents, my lords, but the next date will address because the delay is more than 2 years, my lords, on the application. After 2 years, the
application, will fix the date and will impose the cost.
Yes, my lords.
Let him do it.
My lords, I'll seek instructions, my lord. Let us be served with the copies, my lords.
Yes, you are simply adjourning the matter without this. Then I will grant interim order. What?
My lords, the next date is 27/3, my lords.
27/3.
27/3. By then it may be heard and disposed of, my lords.
Yes. You are taking notice to whom?
The respondent number 1, my lord. The contesting, I'm the decree holder, my lord.
Who is respondent number 2?
Respondent number 2 is the defendant in the original suit.
No, you want to dispense notice.
It may be dispensed, I leave it to the court, my lords. If
you want to take notice for them. Yes,
It
so
may be
and so is
dismissed.
undertake to appear for respondent number 1. Issue emergent notice to respondent number 2. In addition, petitioner is permitted to take out hand summons to respondent number 2. Yes, when is the next date?
27/3, my lords.
27/3. Read this matter on 15th.
Please.
Yes.
Bill number 15, Usha Prakash.
Yes.
My lord, this is the limited supervisory writ petition being filed, seeking the direction to the learned trial court, that is additional senior civil judge and JMFC Magadi, my lord, to dispose of IA 8 and 9 in OS 70/2019, my lord. This was the suit filed for injunction and declaration, and my status is plaintiff there, my lord. And further, I am seeking the direction from this honorable court to direct the trial court to proceed with the trial in OS 70/19 and dispose of the suit as expeditiously as possible, my lord.
No,
My
what
lord,
is that IA?
Please come to page 61, my
No,
lord.
you explain
I
what
have
is that
filed-
IA 8 and
Yes,
9?
my lord. It was an application filed under order 6 rule 17 for amendment of the
First filed.
the plaintiff. I have filed, my lord.
When it is filed?
28/4/25, page number 61, my lord.
ಆಮೇಲೆ ಏನಾಗಿದೆ ಅದು?
Adadmele, please come to page 61, where for the first time, the matter was adjourned to file objection to IA 8, my lord, that is to 6/8/25, my lord, 2025. From there onwards, the case kept repeatedly adjourning for only filing objection to IA 8, my lord. Please turn to page 62, my lord. From 6/8/25 to 8/9/25, from 8/9/25 to 16/9/25. From 16/9/25 to 29/25, again the matter continues, my lord. Please come to page 62.
Yes.
Thereafter, again the matter was posted to 29/25 to 13/10/25, my lord. From 13/10/25 to 25/11/25, my lord.
But defendant has filed any objection to that IA?
No, my lord. Just the time was continuously granted to file objection to
Counsel for
IA
the
8.
plaintiff filed 2 memos along with the 2 citations respectively heard and argument on IA 8 of plaintiff side to hear on IA 8 of the defendant side. IA 8,
And the erroneous order was passed on 25, my lord.
what is that IA 9?
INN, I will just come to that, my lord. Before that, it is very important to note the order passed on 25/11/25, my lord, page number 63, where the court records that defendant counsel is present, prays time to file objection, peruse the order sheet, no grounds to grant more time, hence the prayer of the defendant counsel is hereby rejected. Hence, objection to IA number 8 of defendant side is taken as not filed. Continued at page 64, my lord, where the court records that the learned counsel for plaintiff filed 2 memos along with 2 citations respectively, heard the argument on IA 8 of plaintiff side to hear on IA 8 of defendant side by 19/12/25, my lord. This is the erroneous order that has been passed.
What is that?
That is, once again, once it has been rejected by application of mine, perusing the order sheet, the court again has recorded and given an opportunity for the defendant to hear on IA 8.
No, argument sheet, see, objection they have rejected, argument she is bar.
Yes, my lord. Now,
Which law says that, madam?
the Supreme Court has repeatedly held that once the application of mind has been made by the court, and again,
No,
if
madam,
it is,
application, there is no, see, his case for filing an objection to your IA, court has said that it is rejected because you have not filed in sufficient time. There is no bar for him to argue, madam. Yes.
okay, my lord. Further, the matter was posted subsequently to file objection to IA, my lord. IA 9 ಹೇಳ್ತೀನಿ, my lord. IA 9 was filed by the defendant on 19/12/25.
ಆಯ್ತು, ಏನು IA 9 ಏನು ಕೇಳಿ?
Under 151, seeking the permit to recall application and seeking permission of the court to file objection to IA number 8.
Yes, I will direct.
One nimsha, my lord, I will just continue. Then the matter was posted for filing the objection by
I will be
plaintiff.
directed to consider. You take notice then.
One second, my lord, I will just complete it, my lord.
It is not heard, madam. I know that. What is your?
My lord, two times the objection was, the time was granted to, sorry, my lord. On 9/1/26, once again, the plaintiff has filed the objection on both the sides. The matter was heard, and then the matter was posted for orders on 28/1/26, my lord. Again, on 28/1/26, the matter was not ordered. Again, further date was given, my lord. The further date is page 67, my lord. Further, again, it was posted for orders on 18/2/26, my lord. And again on 68, the court has passed an order recording on the order sheet at page 68 that order is not ready for further arguments, my lord. Therefore, again, from 4/3/26 to the matter has been adjourned to 26/3/26, my lord. Again, it has just posted for arguments, my lord. That is, the court is not exercising the lawful
No,
jurisdiction and
therefore I
passing the
said
order,
that I
my
will
lord.
direct it, madam. Again, you are giving in a one by one date. I said I will direct it to dispose of that.
Dispose
What
of.
else you want then?
No, my lord.
Then you take notice, madam. Yes. Or issue notice. Yes, you take notice to respond. Yes.
Serial number 16, Gaurav GK.
Yes. Yes.
Petitioner plaintiffs have filed a suit for partition, my lord, in 2021. An application under 39(1) and 2, my lord, seeking for non-alienation of the scheduled properties is filed, my lord, However, my lord, since 28/8/2025, my lord, the application is pending consideration for passing orders.
What is that, this thing, where is that?
Application, my lord, finds it page
And when did you
81.
file an application?
Page 81, my lord, 13/8/2025, I have filed an application.
Respondent is heard.
They are on record, written statements are filed. In fact, my lord, the
Section
relationship,
is also filed.
please, my lord.
What is that, where is that order sheet?
Order sheet, my lord, page
This is
28.
called out, order is not ready, call by 113(1), order is not ready on IA.
On IA.
Now
Page
when
28 ಅಲ್ಲಿ
31/1/2026 ಇಂದ ಎಲ್ಲಿಗೆ ಹೋಯ್ತು?
ಅವತ್ತಿಂದ as of now, my lord, 2nd April ಗೆ ಅಂತ ಇದೆ, next date.
2nd April.
2nd April.
Yes, third.
My limited prayer is only to consider the application and pass orders.
Petitioner sought following relief. Petitioner, plaintiff filed in a suit for partition and separate petition. Along with that, plaintiff, she has also filed an application under Order 39 Rule 1 and 2 seeking temporary injunction restraining the parties from alienating the suit schedule property.
Lord, one submission. This application is not filed at the time when the plaint was filed. It is filed subsequently.
Yes. Since defendant was appeared and has filed an objection and both the parties are argued on that, heard on that IA, no order has been passed. Therefore, he sought for early disposal of that application. In view of the above, without expressing any opinion on the merit of the case, the above writ petition is disposed of. The trial court is directed to dispose of that IA number 6,
please,
filed by that plaintiff under Order 39 Rule 1 and 2 on or before end of April.
But may I seek one more indulgence? Written statement is filed by the defendants, my lord. The relationship between the parties or the nature of the property is not under dispute. If an application is filed under 12 Rule 6, my lord, even that may be considered and disposed of in a time limit ಅಂತ. Judgment on admission ಅಂತ ಅಷ್ಟೇ.
ಅದಾಯ್ತು, ಫಸ್ಟ್ ಇದಾಗ್ಲಿ. IA ಆದ್ಮೇಲೆ ನಿಮ್ದು IA ಅಲೋ ಆದ್ಮೇಲೆ they may file an appeal also. There are so many remedies, we can't restrict that. Yes.
A direction to expeditiously dispose of the suit.
Now that IA, let us see. Yes.
Please.
Cell number 17, Chandrasekhar Patil for petitioner, Uma Shankar L.
Yes, my lords, suit is for injunction restraining defendants from dispossessing me without due process of law, my lords.
No, you are the plaintiff.
I am the plaintiff before the trial court.
Bare injunction suit.
Bare injunction suit. My lords, this property in question, suit shell property was a subject matter of OS number 1422 of 2006, filed by my father Munisonnappa, seeking for specific enforcement of agreement of sale executed by original owner H. Nanjundaya, my lords. On 2/1/1995, agreement of sale and general power of attorney came to be executed in favor of Munisonnappa, my lords.
Now, what is that order you are challenging?
My lords, I am challenging Annexure A passed in MA by the first appellate court.
What has happened in that OS?
My lords, OS is pending consideration, my lords. OS order is, I have filed interim application IA number 1 and 2 seeking injunction restraining the defendants from interfering with my possession, my lords. And IA number 2 was for restraining the defendants from alienating or encumbering the suit shell property, my lords. And insofar as IA number 3 is concerned, IA number 3 is filed by the respondents herein seeking for vacating of the injunction order.
What is the order passed by the trial court?
Yes, my lords. My lords, subsequently that IA came to be rejected by the trial court.
On what ground?
My lords, I'll take your lordship to
that has been confirmed by the appellate court.
My lords, appellate court has directed both the parties to maintain status quo, my lords.
What else you want, mister?
My lords, the question is, Now, by taking into consideration of one another suit, which has been filed by purchaser subsequent to the confirmation of judgment and decree in my favor by the Honorable Apex Court, my lords. 2014, the matter has attained finality, my lords. And execution petition is pending consideration. At that juncture, the respondents herein, they makes an application under Order 21 Rule 97, claiming to be the daughters of original owner H. Nanjundayya. The said application came to be rejected, my lords,
Where?
before the trial court.
No, in this case.
Not in this case.
No, we are not concerned all this thing. In
Yes,
this
madam.
case,
In this case.
you have filed an application for not to alienate, not to interfere.
Yes, my lords.
Trial court is dismissed.
No, trial court has allowed that applications. It is not considered it, my lords, because there are 17 defendants are there. Some of the defendants were yet to be served. At that juncture, these respondents appeared before the trial court and made an application IA number 3 seeking for vacating of interim injunction order granted in my favor, my lords. Thereafter, they approaches this honorable court seeking direction against the trial court, my lords, which your lordship would find.
Sir, you just tell me that.
Yes, my lord.
What is the order passed by the trial court on your application?
My application, it is not yet considered, my lords.
What is that? Where is that order?
Without considering my application, ad interim order was, the ex parte ad interim order was granted in my favor.
Has been challenged by you by filing an appeal.
No,
For vacating. Then it.
only vacating application was considered in view of the fact, my lords. Other respondents were yet to be served, my lords.
No, I want to just facts. After that, your application is rejected for vacating. Now that you have challenging for rejection of your application for vacating. Now they have stated that maintain status quo and then decide that application. What else they want, mister? Now the trial court has to decide application on merit.
Execution in view of the two subsequent suits, one by him and one by other purchaser. The proceedings are execution proceedings are stayed. Therefore, court has said.
Maintain status quo.
Allah, not for that reason, my lords. Insofar as these respondents.
What is that prejudice is caused to you if maintaining status quo?
Now, by virtue of this order, the purchaser who has purchased this property in the year 2023, upon the reaching of finality by the decree passed in my favor in the year 2014, now he is trying to take the possession over the property, my lords.
Can he take a position?
Allah, adike he has filed a separate suit seeking for declaration. And the court has come to the conclusion that the parties are directed to maintain status quo only for the reason that in another suit, the court has come to a conclusion that the other person, the defendant is the plaintiff therein is in possession of the property. Therefore, directed these two plaintiffs as well as the respondents to maintain, directed to maintain status quo, my lords.
In all cases, there is a maintain status quo. I am saying that how it will have prejudice to you. If anybody taking these advantages of status quo, tomorrow try to interfere into that. You can have any documents, it amounts to a contempt. Nobody can do anything, mister.
Allah, insofar as my application IA number 1 and 2 are concerned, my lords, those applications are yet to be considered.
That's why court said that you maintain status quo till disposal of the suit.
Not till the, my lords, because IA number 1 and 2 is a sought relief as against other respondents, other defendants as well, my lords. Some of the defendants are yet to appear before the court.
The disposal of both the parties means only you two are there. No, all parties are there.
No, none of them are appeared before the MA court as well.
MA court, they are not a party.
No, they have not appeared. Only the petitioners herein and the respondent want to.
They are not appeared for them to take care. But court has granted status quo in respect of all. It is not only between you two. Court said all parties has to maintain status quo.
I have entered appearance before the MA court through the caveat, my lords. Notice is yet to be served.
In the first appellate court, case has been disposed of.
Disposed of.
Person who has not appeared, order is passed for them to come and challenge. Why do you worry? Now the trial court said that maintain status quo. If anybody is aggrieved, let them come. But you are appeared there.
I have appeared.
Then what is the prejudice caused to you for granting in a status quo? If anybody misusing status quo, try to interfere your possession after this order, it amounts to a contempt. Nowadays, you have so many documents to serve that and you can file in a contempt.
Please, my lords,
Yes.
because the court has already held in my favor that in the earlier proceedings that I am in physical possession of the property.
Advantage now that you
Yes.
are in that position,
Yes.
what is that prejudice is caused? Yes. In this petition, petitioner called in question, order dated 5/1/2026, passed by First Appellate Court, that is Third Additional Senior Civil Judge JMFC Devnalli in MA number 22 of 2025, whereby parties are directed to maintain status quo in respect of suit scheduled property. Petitioner has filed suit for injunction.
Injunction.
Along with that plaint, he has also filed an application, IA number 1 under Order 39, Rule 1 and 2, seeking temporary injunction against the defendant not to interfere into the suit scheduled property, and also filed IA number 2, seeking direction to the defendant to not to alienate that property.
Please.
The trial court has granted ex parte temporary injunction. On service of summons, your defendant number
Defendant 6 to 8.
6 to 8 has filed an application under Order 39, Rule 4, CPC for vacating that ex parte interim order. The same came to be dismissed by order dated
6 to 13.
6?
6 to 13, my lords. Defendant 6 to 13.
6 to 13. Our application ಯಾವಾಗ dismiss ಆಗಿದೆ trial court?
Application came to be dismissed on on 16th August 2025, my lords.
16.
13.
6 to 13. Yes. The application came to be dismissed by order dated
16th August 2025, my lords.
16th August 2025, being agreed by the same. So and so, defendant number 6 to 13 has filed appeal before Third Additional Senior Civil Judge JMFC Devnalli in MA number 22 of 2025. The First Appellate Court by order dated 5th January 2026 has directed the parties to maintain status quo by granting an order. Parties to maintain status quo will not cause any prejudice to the petitioner herein. Therefore, there is no error or illegalities in the order passed by the First Appellate Court. Accordingly, writ petition is disposed of.
Right.
Serial number 18, Ramesh N for petitioner.
Petitioner plaintiff filed a suit for partition
Yes.
and filed a amendment application subsequent to the return statement filed by the defendant number 9, my lord. Application came to be rejected on a cryptic order that has been passed.
Suit for?
A suit for partition.
You are the plaintiff.
Plaintiff.
What is your application?
Application page number 67, my lord.
ಏನಕ್ಕೆ ಹಾಕಿದ್ರಿ?
ಅದರಲ್ಲಿ ಅವರು ರಿಲೀಸ್ ಡೀಡ್ ಇದೆ, ಒಂದು ರಿಜಿಸ್ಟರ್ಡ್ 1930 ಯಾವ್ದೋ ರಿಜಿಸ್ಟರ್ಡ್ ರಿಲೀಸ್ ಡೀಡ್ ಇದೆ.
ಅಮೆಂಡ್ಮೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರಿ?
ಅಮೆಂಡ್ಮೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ ಪ್ಲೀಡಿಂಗ್ ಕಂಪ್ಲೀಟ್ ಆಗ್ಬೇಕು. ಆಮೇಲೆ OS ನಂಬರ್ 337 ಯಾವ್ದೋ ಇನ್ನೊಂದ್ 2 ಪ್ರಾಪರ್ಟಿನಲ್ಲಿ ಐ ಆಮ್ ನಾಟ್ ಎ ಪಾರ್ಟಿ ಟು ದಟ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್, ಅದರಲ್ಲಿ 2 ಪ್ರಾಪರ್ಟಿ ನಮ್ಗಾಗಿದೆ ಅಂತ.
ಎಲ್ಲಿದೆ ಆರ್ಡರ್?
ಆರ್ಡರ್ ಬಂದು ಪೇಜ್ ನಂಬರ್ 21-22.
ಏನಂತ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ?
ಇನ್ನೇನಿಲ್ಲ. ದಿ plaintiffs have sought time to adduce evidence, then the pre-trial stage, then they have filed one after another application. It shows that they have intentionally dragged on the proceedings. Return statement filed on 23/5/22.
Further proceedings in OS number 39 of 2020 pending in the file of which court, mister?
It's a senior civil judge and CJM Kolar.
First Additional Senior Civil Judge CJM Kolar till next date of it.
Serial number 19, Giridhar SV.
Request for a passover, my lords.
Passover.
Serial number 20, BM Siddhappa.
Yes, Mr. Siddharth.
Well, it's a plaintiff writ petition. Suit is one for partition and separate possession. The defendant number 12 is a purchaser of the property, has made an application for seeking, my lord, casting the issue with regard to, my lord, non-joint of properties. Not suit is not maintainable. Without furnishing any particulars, the property which are left out by the plaintiff in the suit. On that basis, he has made an application. That application came to be allowed and ordered to frame the issue whether suit is maintainable for non-joint of all the family properties of the plaintiff. So the no particulars of the properties have been mentioned in the neither in the application or in the written statement. Without which, my lord, any basis, because your lordship under order 14, there must be an assertion. These are the property belongs to the joint family, though properties have not been included, therefore suit is not meant. That is not, there is not the case, no pleading at all. Simply only statement, mere statement in the written statement.
Now, what is that order passed by the trial court?
Now the trial court ordered to frame the issue.
Heard issue notice, stay of further proceedings in OS number 268 of 2021, pending in the file of Senior Civil Judge Kadur till next date of hearing. Yes.
21, PM Siddhappa.
Same, my lord, in another suit between the same parties.
Same parties. Yes, same matter.
22, Santosh Kumar MB.
Appear for the petition, my lords.
Yes.
Petitions are defendant number 8 to 11, my lords. It's
Yes.
partition suit, my lords, wherein the defendants had not appeared before the court, and then they made an application for recall of the ex parte order, my lords, which has been recalled, my lords. And
Ex parte?
Ex parte has been recalled, and they were permitted to appear before the court, my lords. Then the defendants filed application seeking permission to file written statement, my lords, along with counterclaim, my lords. The claim, my lords, is that the plaintiff's father had sold the property to the defendant's father, my lords, 3.5 quintas of land. And Kata has also been standing in the name of the.
Application.
That application has been rejected, my lords, stating that it's delay, my lord, delay.
Now, when you have been order of ex parte is recalled.
My lords, order was for ex parte, my lords, without any objections, my lords, has been recalled on the order date, my lords. 18/11/2025, my lords.
18/11/25.
Sorry, my lords, that was 3/11, my lords, 3/11/25.
3/11/25.
Please, my lords.
When did you file an application for permission to file either?
My lords, it was filed on the same day, my lords, but it was taken on record on 18/11, my lords. 18/11.
18/11.
Please, my lords.
Why it is dismissed?
My lords, it's been dismissed as delay, my lords, delay in, because since it's a counterclaim, there is a counterclaim in the written statement, my lords. It's on the basis of, on the ground of delay, it has been dismissed, my lords.
Counterclaim for what?
Counterclaim, my lords, stating that, my lords.
Doesn't warrant interference. Such question was specifically raised before this court. Right, that if cause of action has arises before or after filing of a suit, and such cause of action continued up to extended date of filing retention. Now, when the cause of action has arises, you are not stated in that.
My lords, it is stated, my lords, stated, my lords, I have, for the, that is case, my lords, that it is not been stated for counterclaim, that is what has been claimed. my lords. It's not so much.
Counterclaim have stated.
My lords, it's been stated, my lords, since, since purchase, my lords.
Issue notice, stay of further proceedings in OS number 24 of 2019, pending on the file of first additional senior civil judge, JMFC, Krishna Rajapet, till next date of hearing.
Cell number 23, Syed Kamruddin.
My lords, the suit of the plaintiff/petitioner is for recovery of money, my lords, on the ground of price escalation for the civil works that was carried out. Now, my lords, the matter is of the year 2013. The matter was dismissed on two occasions for limitation, my lords, prima facie. Finally, the matter was remanded with a direction to form an issue on limitation and dismiss the lead evidence and take up the matter on merit in the year 2025, my lords. Now, on the first instance of evidence, my lords, the petitioner herein had filed IA number 2 under Order 11, Rule 1, my lords, to allow the petitioner to produce certain original documents. Now, the said IA was allowed in part, allowing only for the marking of a board resolution, my lords, and it was dismissed on all the other documents, my lord. Now, my lords, the other documents that are sought to produce are very important, my lords.
No, very important. Have you pleaded that?
Yes, my lords, we have pleaded each point we have pleaded, my lords, why it's important as well, my lords.
No, why
Now
you have
the
not produced that time?
My lords, that time the copy of the two of the documents was produced as well, my lords. One of the documents, in fact, was admitted by the defendant.
No,
as
even
well, my
then,
lords, my
that
lords.
what is that rule says? You have to produce along with that. It is a commercial dispute.
Yes, my lords, but it was filed in the year 2013 before the Commercial Courts Act was enacted, my lords. The rigors of the Commercial Courts Act was not in place when the matter was filed, my lords. Now, in the first instance of evidence itself, my lords, this IA was produced, my lords, to condone the delay and
You
produce
are
the
already
documents, my
delayed
lords.
your own suit. Again, you want to delay further?
No, my lords, we have no.
Yes, heard. Issue notice. Stay of further proceedings in commercial OS number 5254 of 2013 pending in the file of 82nd Additional City Civil and Session Judge, Commercial Court, Bangalore, till next date of hearing.
Cell number 24, Harsha Kumar Gowda.
For the petitioner, my lord. The petitioner is the defendant number 2, my lord. My lord, the suit for partition, my lord. My lord, at the stage of the cross-examination of the defendant, my lord, the plaintiff filed the amendment application, my lord, after a lapse of 10 years from the filing of the suit, my lord. And the application is allowed, my lord, against which I am before this honorable court.
Application is filed for?
Filed for amendment, but to insert the properties, my lord.
Who has filed?
The plaintiff has filed, my lord.
Suit for partition.
Yes, my lord.
If the properties which is not included, if it is a joint family property, it has to be.
My lord, my lord, earlier, my lord, the partition taken place, my lord, in that, my lord, the property was allotted to the husband of the petitioner, my lord. Now, after lapse of 10 years, my lord, they want to insert, my lord, even at the stage of the cross-examination of the defendant, my lord.
Are you disputing that this is not a joint family property? What is your objection for that?
Objection is that, my lord, it is not the ancestral property. They are claiming that it's ancestral property, my lord. It is not ancestral property, my lord. It is.
Where is your objection to that IA?
Annexure D, my lord, page number 23, my lord. And in
23.
Yes, my lord.
Where is that?
Para 3, my lord, the plaintiff has filed IA dated so and so. The plaintiff has filed the suit against the defendants on so and so.
Delay ಮೇಲೆ ಹೇಳಿದ್ದೀರಾ?
Yes, my lord. Now the present.
It is not in a joint family property. Only delay you have said.
Para 5, my lord. The defendant submits that the father of the plaintiff by name Singraya is brother Chelvai and another brother Kalaya. They have partitioned the amended application property in the year 1979, my lord. As per the partition between them, all these three persons have equal shares in their respective survey number 61/1 measuring 27 quintals of land, including the other survey numbers bearing number 48/2.
What is the trial court reason given that is it a joint family property?
My lord,
what is it cannot compensate on the money considering the plaintiff. If the relief is necessary, that proposed amendment has to be allowed for deciding whether.
Para 8, my lord, page number 59, my lord, the reasoning part.
Statement of the defendant has specifically taken place in the included all family. ನೀವೇ defendant return statement all properties is not included ಅಂತ ಹಾಕಿದ್ದೀರಾ?
That is with respect to the some other properties.
Which property?
My lord, in the written statement, my lord, annexure B, page number 15, my lord.
15.
Yes, my lord.
ಏನ್ ಯಾವ ಪ್ರಾಪರ್ಟಿ ಅಂತ ಹೇಳಿದಿರಾ? Where is that your statement that property is not included? ಎಲ್ಲಿದೆ ರೀ? Yes, mister. Where you have stated that all properties is not included ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದಿರಿ?
Not stated, my lord.
ಮತ್ತೆ ಕೋರ್ಟ್ನವ್ರು ಅಬ್ಸರ್ವ್ ಮಾಡಿದಾರಲ್ಲ.
It's a wrong observation, my.
Yes, heard. Issue notice. The learned counsel for the petitioner submitted that the plaintiff has not produced any document to show that properties which plaintiff wants to include as a suit scheduled property by way of amendment is a joint family properties. The trial court has wrongly given a finding that defendant have specifically taken the contention that plaintiff has not included all the family property. Hence he sought for stay of that impugn order. In view of the above, stay of order dated 8/1/2026 passed in OS number 591 of 2015 pending in the file of Principal Civil Judge JMFC Mandya till next date of it.
Much obliged.
Bill number 25, Prasad Hegde KP.
Defendant petition, my lord. Suit is for declaration to declare that they are the owner of the Schedule A and B property. Schedule A, my lord, we are in the position that is a residential. After return statement, among other issue, three issues. Issue number 3 is regarding pecuniary jurisdiction and non-payment of stamp duty. And issue number 5 was that regarding a non-claiming the possession. I filed an IA to decide the issue first. Then that was my application was rejected. Then I challenged the same, my lord, before this one court, my lord, annexure G, my lord, in page 78. Then, my lord, they said, my lord, dismissal of IA-6 is set aside and remanded the matter. Now again, my lord, my application was finding by this one court, my lord.
What is that order of this court?
Yes, annexure G, my lord, in page 80, relevant, paragraph 4, my lord. If perusal of the impugned order passed by the trial court will indicate that in so far as issue number 3 is concerned, the trial court came to the conclusion that the suit had been properly valued and the court fee paid was sufficient. And consequently, question of treating the issue number 3 as primary issue would not arise. In this context,
ಏನಕ್ಕೆ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಈಗ?
rejection is on the ground that when stamp duty is paid proper. And regarding position, my lord.
What about that maintainability?
Yes, maintainability regarding, my lord, stamp duty is 25 rupees enough. On that ground, my lord, maintainability held that it is maintainable.
Issue notice. Stay of further proceedings in OS number 529 of 2017 pending in the file of Principal Civil Judge JMFC Udupi till next date of hearing.
Bill number 26, SV Prakash.
Pass over.
27, Nataraj Baba K for petitioner.
For the petition, my lords. That's the suit for permanent injunction, my lords. Honorable trial court refused to grant adjournment, madam, my lords. Let's be, I am in the possession of the property, my lords. Let's recent trend in the city is, my lords, I am the lease holder. Respond number 3 and 4 are the owners. They let out property to me, and without intimating us that it is they have borrowed the money in the financial institutions and delivered the possession to us. Now what is happening, my lords? They are the defaulters, and the respond number 1 and 2 are coming to the property and saying that forcing us to vacate the possession.
Who are 3 and 4?
3 and 4 are the financial institutions.
They have any degree?
They said that they have a degree. They have a degree in the sense they are from the cooperative sector. They have a order, and they are coming to the suit scheduled property and disturbing my possession. And in any of the proceedings, matters, they are not make me as a party. Without make me as a party.
ನೀವು suit for
permanent injunctions.
ಏನು application ಏನು ಹಾಕಿದ್ರೆ ನೀವು?
IA not to dispossess, my lords.
What is that order has been passed by the trial court?
Just issued suit summons, my lords.
Where is that?
My lords, annexure A, page 19, my lords. operation portion. Issue emergency notice to IA number 1 and issue summons to the defendants. Returnable 13-3. See, if immediately if they dispossess me, I will be in the street, my lords. That is the only concern, my lords.
Yes. 13/3/2026.
Please.
Just date.
11, my lords.
Let us see on 13th what will happen. If they are appeared,
Please.
otherwise we will direct it to dispose of that matter. Leave this matter on 16th.
Please. Please.
As it is same stage, it will
Please,
come.
please.
16th. Let us see on 13th. Yes.
Cell number 28, Rajaditya Sadashivan.
Yes.
Suit is for bare injunction. I am the defendant before the trial court. Injunction has been granted against me not to put up any construction.
Temporary injunction.
Why not?
Temporary injunction has.
Temporary injunction has been granted. My MA has been dismissed, as against which this petition has been filed. Here, the plaintiff herself has absolutely no title in the property. He has relied on her plaint documents are only one RTC and one order of a land record
What
officer.
is your defense before the trial court?
My defense before the trial court, admittedly, I am the owner of Schedule B property. The plaintiff has fraudulently shown Schedule B to be inside Schedule A property and that she is the owner of Schedule A property. My title to Schedule B property is admitted. Her entire case is that location of Schedule B property is under dispute. Therefore, she is asking for an injunction over the entire Schedule A and Schedule B property. Now, I am being restrained from putting up construction over my own property. There is an injunction where admittedly I am the owner and there is an injunction against me.
Where is that order?
That is at page 27 is the impugned order of the MA court.
What is
Here
that
the
MA?
boundaries are in dispute. Location of Schedule B is in dispute. Schedule A and Schedule B. Now, not one single document is produced by the plaintiff. Not even a sketch is produced along with the plaintiff
You
to
take
show.
ransom. You take notice.
Kindly stay may be granted because I am putting up. Kindly see para 14, page number
The
44.
effect then, what is the final order you want? You want to put up the construction.
I may be permitted to put up construction because there is no hardship committed to the plaintiff. Supposing I am putting up construction in some other place.
We don't know that. Let them come before the.
No, my only request is kindly see para 14. The MA court also makes a finding that nobody knows, the plaintiff herself has not made out a case for boundaries. Page number 44, my lord.
Yes.
Para 14.
Yes.
The
You file
previous
an
paragraph, previous paragraph is a citation.
You file an affidavit tomorrow.
Yes, my lord.
Saying that in case.
I will
if
not
it
claim equity.
File affidavit of your party.
Yes, my lord.
When will you file?
By today afternoon, I'll file it. Tomorrow morning, it may be had, my lord.
Yes, leave this matter day after tomorrow. Yes.
Serial number 29, Iremated Maheshaya.
My lord, appearing for petitioner.
Parvati GB.
My lord, petition by the defendant, my lord. My lord, petitioner filed a suit for partition in respect of a very same property against the respondent, my lord. Thereafter, my lord, the respondent filed a suit for injunction, my lord. My lord, kindly come to the page number 15, my lord.
No,
This
you
is
have filed for partition.
partition, my lord. My lord, my suit is, my lord, OS number 257/2023. 257/2023, my lord. Now the stage is, my lord, evidence. My lord, the suit for injunction filed by the present respondent is, my lord, OS 12/2024. Lord, kindly come to the page number 15, my lord. This is present subject.
Yes, what is that order you are
Subject to
saying?
suit of this property, my lord.
ಆಯ್ತು ಏನ್ ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ?
Well, order 39 rule 1 and 2. My lord, temporary injunction order, my lord, granted by the court against the family members, my lord, in respect of the family property.
No, that order 39 rule 1 and 2.
My lord,
After
yes,
hearing or ex parte,
after hearing, my lord.
hearing granted.
Yes, my lord.
Defendants are hereby restrained from interfering into the peaceful possession of the entire. See, what is your claim before that trial court, Mr. Sources of income, the sources of title. You are saying that it is you are an absolute owner of the property, self-acquired property. It is not a joint family property. What is that material to show that it is self-acquired property? Page number? Page number 11. Yes. Hmm. 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 Yeah, what is your father? Now, what is he doing? What is the income for you to purchase that property, mister? ಎಲ್ಲಿಂದ ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಪ್ರಾಪರ್ಟಿಯಿಂದ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ರ ನಿಮಗೆ ಸ್ವಂತ ಇನ್ಕಮ್ ಇದೆ? ಏನಿದೆ ಸ್ವಂತ ಇನ್ಕಮ್? ವಿಚ್ ಏನ್ ತೋರಿಸ್ಬೇಕಲ್ಲ? Otherwise, it's in a joint family property. Then you can't claim an injection. Tomorrow, Friday. Yes, please this matter on Friday. ನಿಮಗೆ ಏನ್ ಇನ್ಕಮ್ ಇದೆ ತೋರಿಸಿ. Otherwise, it should be presumption that it is in a joint family property. Yes.
Cell number 30, Murli N for petitioner, C. Suresha.
Yes, Mr.
Petitioner is the defendant. But plaintiff filed suit for declaration and injunction. When the matter is posted for cross of DW1, I filed a witness list. That witness list is rejected by the trial court on the ground, witness are not necessary.
Where is that?
Impugned order is page 35, annexure of relevant paragraph, page number 38, He says,
Support of
perusal
the defendant by name, he has shown the federal statement, I lost original sale deed, intended to examine the sub-register with regard into the genuineness document or sale deed, his signature. Further, I am intended to examine one witness of so and so, so and so. Witnesses so and so. Yes.
Plaintiff specifically contending that he never executed sale deed dated 8/7/2020.
Yes.
8/7/24 to 1995, and he never put his thumb to the sale deed. Defendant created the document. In that situation, I filed application.
It's a registered document.
Registered document. Sale deed. To summon the thumb impression register. I stated in the written statement, my original sale deed was lost.
Yes.
Hence, I required to examine the sub-register by summoning the.
No, you can't get a certified copy by applying.
Thumb impression register original vehicle. Matte innondandu witness na examine madak hakidini Anjinappa anta.
Yes.
He is the witness to the sale deed.
Yes.
It is preliminary stage, initial stage. I just filed a list of witnesses.
Further proceedings in OS number 222 of 2021, pending in the file of first additional senior civil judge JMFC Kolar till next date of hearing. Yes.
Cell number 31, Lokesh R.
Petitioner.
Yes.
My lord, I am one of the joint family member along with the respondents, my lord. Excluding me, they have filed a suit for partition, my lord. Page number 47 is the suit filed for partition. Suit was filed on, my lord.
ಆಯ್ತು, ಏನ್ ಅಪ್ಲಿಕೇಶನ್ ಈಗ ರಿಜೆಕ್ಟ್ ಆಗಿರೋದು?
ಅಲ್ಲ ನಾನ್ ಪಾರ್ಟಿನೇ ಇಲ್ಲ, ಅವ್ರು ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಕೊಬಿಟ್ಟಿದ್ದಾರೆ. ಸೂಟೇ ಮುಗ್ದೋಗ್ಬಿಟ್ಟಿದೆ.
ಅದಕ್ಕೆ ಏನ್ ಮಾಡಿದ್ದೀರಾ ಈಗ?
I have sought not to disperse the award amount from KHB, my lord.
What, where you have filed an application? What is that, are you not challenging that compromise degree?
Compromise degree I am challenging here, my lord.
Compromise degree, how can you challenge by filing in a writ?
My lord, one judgment, recent judgment.
No, is it before that Loka Adalat or? Then you have to file under GMCPC, GM, yes. You are challenging that Loka Adalat order. Yes, office is directed to this petitioner seeking quashing of order passed in Loka Adalat. Ellide Loka Adalat order?
My lord, page number 18, my lord. 19 is the order.
19.
18 order sheet, 19. Suit was filed on 25/2 and.
Loka Adalat, mister, it is before the court only. ಎಲ್ಲಿದೆ ಆರ್ಡರ್ ಶೀಟ್ ಎಲ್ಲಿದೆ?
ಆರ್ಡರ್ ಶೀಟ್ 19 ಅಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ.
19 ಅಲ್ಲಿ ಎಲ್ಲಿದೆ ಆರ್ಡರ್? ಒಬ್ಬರೇ ಇದ್ದಾರಲ್ಲ.
Advocate for plaintiff filed advance application, Shri MN had filed wakalat for defendants, case taken on board.
File the
Plaintiffs-
compromise petition, explain the party so and so accordingly allowed.
Allowed.
It is before the court, Mr., not Lok Adalat.
Yes, my lord.
If it is a court, then you have to file an application before the same court.
My lord, when I am not a party.
Even not a party also, Supreme Court said, even stranger can file an application before the same court to recalling that order. Either suit is not maintainable or that.
My lord, problem is that land has been acquired and they are making attempts to withdraw the compensation.
Okay, application haki, you can claim that. Yes, after amendment to that order 23 rule 3A.
Yes, my lord.
Suit is not maintainable. Supreme Court said you have to go and file before the same court. Yes.
Any interim protection may be made.
No, if it is not maintainable, what is the protection, Mr.? Yes.
At least notice may be ordered, my lord.
Maintainable allala andre notice elri bantu. You go and file, Mr. See, independent suit filed by the stranger to the compromise challenging the lawsuit of the compromised degree. Non-maintainable, separate suit challenge the compromised degree. Person questioning the lawful of the compromise must approach the same court which recorded the compromise. The law is clarified. Yes.
Problem is by the time I go there, my lord, they won't receive notices and they'll
Yes.
usurp the
In
amount,
this
my lord.
petition, petitioner challenging compromise degree passed on 17/4/2025 before first additional senior civil judge JMFC Anekal. In view of judgment of Apex Court in 2026 SCC 629, the parties aggrieved by the compromise petition must approach the same court which recorded the compromise. In view of the above, the writ petition is disposed of, reserving liberty to the petitioner to approach appropriate legal forum.
In the event delay, my lord, that may be condoned.
Delay ಏನಿಲ್ರಿ ಅದಕ್ಕೆ, you go and file, Mr.
Second additional ಆಗ್ಬೇಕು ಸ್ವಾಮಿ. First additional ಅಂತ ಹೇಳಿದ್ರೆ second additional ಆಗ್ಬೇಕು.
ಆಯ್ತು, second additional. Yes.
Bill number 32, Ajay JN for petitioner.
Against the denial of ex parte injunction, my lord, what has happened is that I had purchased land, my lords. My father and mother had purchased the land. My lord's father subsequently expired. The land was acquired for the purpose of NICE.
Yes.
The acquisition by NICE has been subsequently struck down, my lords, by a single judge of this honorable court. Thereafter, my lord, I went to get a khata for my property. What has happened is that, my lords, were to turn to page number 162. The defendant in my suit.
You are sued for?
Suit for being put back in possession and for permanent injunction, my lord. I am now today not in possession because what he has done is, my lords, were to just take page.
Seeking put back possession from whom?
My lords, from the defendant. Defendant has now, what he has done is, kindly see page 143, my lords. 143, it's a photograph. I'll show what has happened.
Your land has been acquired for that NICE.
So, my lords, acquired, acquisition set aside. After the acquisition set aside, my lord, I went to get a khata. When I go to get a khata, I find out that somebody else for the same property, he has obtained khata claiming it to be site number 8. Now, my lords, may see page.
Now you are sued for possession.
Sued for possession. Page 143, my lords. My lord,
now what is that order now you are challenging?
My lords, I asked for, my lords, I only asked for this much, my lord. Let him not alienate or let him not put up any construction.
Yes.
Why I say that, my lords, is because I go, he puts up
now
a
what is that order on your IA?
My lords, page, my lords, 211, my lord, 211 and 212, my lords. 212, annexure F, my lords, 212. Absolutely no reasoning, my lords.
212.
212, my lords.
Yes.
My lords will see plaintiff has filed present suit for seeking judgment and mandatory injunction directing the defendants to vacate the civil property, put back the plaintiff in possession and other consequential relief. Along with the plaintiff has filed IA 3 Rule 2 seeking permission to represent case through SPA holder. Considering the submissions and reasons assigned, court decides to allow that application since IA 2 is allowed. Further, plaintiff has filed IA 1 under 13(1) prays to direct the defendant not to alter or change the nature of the property by putting up construction or digging borewell or other physical activities over the property. Considering the plaint and documents, this court is of the view that appropriate orders on IA number 1 can be passed only after hearing both the
parties. You are
parties.
not seeking not to alienate your
I'm sorry, my lord, I'm only.
That is therefore court said that will issue a notice.
No, my lord.
If it is not to alienate, yes.
No, but 1 minute, can I just point out what has happened since the time I filed the suit?
See, admittedly, he is in the possession.
But I don't want him to put up construction.
No, that court has to decide whether he is in his own property or not.
Just 1 minute.
See, your right can be protected, not to alienate. If it is put up tomorrow, if you find that you are the owner, it will be removed and handed over.
My lords, just 1 minute. Kindly see
Because
what,
your suit is dismissed. Will you compensate? What is the loss cost to him?
my lords, I'll point out, my lords, just 1 minute. Kindly see what has happened in the last 3 days. Why I am saying this, kindly see.
Yes.
My lords will see, first photograph my lords are seeing, my lords. My lords may see page 162 for a minute. This was when I filed the suit. Kindly see page 162.
No, that's, he is putting up a construction.
My lords, in 3 days, my lords, I asked myself this question, my lords. I file a police complaint. The moment before filing the suit, my lords, I file a police complaint. When I file a police complaint, he comes and says, no, no, this is my property, etc. Within 2 days, he puts up a borewell. Within 3 days, he has demolished my.
5-story building a Katli Bidi, how will you
My lords,
address you?
my lords, I asked myself this question, my lords. He
Not
puts
to
up,
alienate, will protect you.
but 1 minute, just 1 minute.
Yes.
Status quo, my lords, just 1 minute. Kindly see what has happened. Kindly see what has happened. Kindly see page number 3 for a minute.
Yes.
My lords, first, my lords may kindly see page number 143. First
Yes.
see page 143, my lords.
Yes.
My lords, at page 143 of my writ petition, if my lords were to see, Nandon son shed ittu.
Yes.
Kindly see.
Yes.
My lords are seeing, Nandon son shed ittu, Swami. Site, nandu compound wall ittu, adra ಮೇಲೆ site number 8 anta bardida. Now kindly come to page number 2.
Yes.
My lords, this is as of 6/3, my lords.
Yes.
Kindly see, my lords, the shed is gone.
Yes.
Page number 3, my lords, were to see shed is gone. My lords, then my lords, I file one more police complaint saying that, look, there is a suit pending.
Yes.
Don't put up construction. Thereafter, police come and visit the property also, my lords. Thereafter, my lords, he has now again started construction. Now, my lords, my lords, insofar as I am concerned, my lords, I fully understand that, my lords, insofar as his construction. My lords, till the time IA1 is there, please give a direction saying that let IA1 regarding put up construction or not, let it be decided. Prima facie, he has to establish his title. If he simply puts up a board saying site number 8 and then produces some document.
Even assuming that he is put up in a construction.
Yes, ma'am.
What prejudice will cost to you?
My lords,
Your
I'll tell
land will
my
be
lords,
there.
my lords, no, my lords, I'll tell my lords. There are two things. One is, my lord, once he puts up a construction, he will claim that construction was there before the suit. First thing, because today, my lords, I am producing photograph, etc.
Even assuming that even before that a suit is there, is it be that ground for him to not to?
My lords, then I have to spend money to demolish it. If I succeed, I have to spend money to demolish it.
Yes.
Now, my lords, question is this, my lord.
That will be made clear.
My lords, just
If
one
he
minute.
succeed, he has to give back that.
My lords, instead of that, my lords, let IA number 1 be decided.
We have to see other sides also.
My lords,
He admittedly is in the possession. Till it has to be decided whether he is owner of the properties or not. You are not to put up in a construction.
My lords, why I am saying I am the owner? Let me show my documents.
Yes,
Let
yes.
me show my
Heard.
documents, my lord. Kindly
Heard.
see 1 minute, my lords.
No, Mr.
My lords, then insofar as alienation is concerned, my lords will.
That parties are directed not to create any third party interest in respect of suit scheduled property till next date of hearing. Yes, you take notice.
Dispensation.
Yes. Dispensation, production of certified copies for a period of.
My lords, hand delivery of the order is.
Yes.
Cell number
ಅದು ಎಲ್ರಿ ಮಾರಕ್ ಹೋಗ್ತಾರೆ 2 ದಿನದಲ್ಲಿ.
Swami, what has happened is,
Yes.
I don't know who, my lords, this person is, he has put up a board. I don't know whether he has title or not. He has put up a board. Tomorrow, if I come to know that he's already sold it, then again I have to
Yes,
amend
yes,
the case.
yes. That's granted. Yes.
Cell number 33, V. Shivakumar for petitioner, B. Vakel.
Blood, at the stage of arguments, I filed an application for appointment of a commissioner to ADLR for identification of the property. But the reliefs claimed is at page 57 in the plaint. But there are two properties under the deed of partition.
Yes.
The parents had divided the property by the deed of partition.
Yes.
But we said that we are joint owners in so far as survey number 52/3, 39 guntas, and survey number 52/2, 15 guntas of land, which are item 1, item 2.
Yes.
But the question is whether a commissioner, if appointed, the trial is concluded.
Yes.
And on the basis of the trial, there is only oath against oath.
Yes.
But the court will have to be aided by certain facts in regard to identification of the two properties. But the learned judge gives a reasoning on the ground that I did not file an application at the initial stage. It is not a application on a pre-trial. Not page 26, that the reasoning that is given by the learned judge. Paragraph 9 at page 25, it commences. A perusal of the material on record, but my lords get
Para?
para 9, my lord, page 25. That's the order of the trial court.
Yes.
A perusal of the material on record reveal the evidence of both the plaintiff and defendant is completed and the matter is set down for arguments. When the plaintiffs have all the way contended in their plaint that the suit schedule property continues to be in the possession of the plaintiff, in spite of the fact the defendants had come near the property, confronted them with certain documents, no purpose would be served in appointment of ADLR for conducting survey of the suit property for the purposes of identification of suit properties. Admittedly, the application for appointment of court commissioner is filed at the stage of arguments, not a pre-trial application. So as to contend, the court commissioner's report is necessary for reducing the voluminous oral documentary evidence. Plaintiff who has sought for appointment of court commissioner ought to have explained, indicated as to why court has to exercise its discretion for appointment of the court commissioner, how the evidence on the record is insufficient for just determination of the case. But should I explain it in the affidavit as to why the commissioner is required?
Yes.
The court has to exercise its discretion on the
Why
material.
you want that court commissioner to be appointed?
That the two properties, there are number of other defendants in the case. They have purchased properties by virtue of a sites. I have contended my portion of the property is vacant. That differentiation will have to be established by the court commissioner only.
Yes.
But I cannot place any material on the spot what has exactly happened. That will not prejudice the defendants also insofar as appointment.
What is the suit for?
Suit is for declaration and consequential relief. That's the relief that I have sought for.
Yes, Mr. It is his suit. If it is stayed or if it is delayed, this is effect to him. How it will prejudice to you? Now that this court said at any stage application can be filed. Yeah. 53.
53, my lord, I have.
Yes. Yes. Yes.
He gets a right in the partition because of the year 1968. They want that title to be declared pursuant to the said partition. My case is that after 1968, Odisha got a right, farm sites and sold it in 1975 to one Shiva.
Yes.
Shiva sold it to my father in 1980. This is the background of the case. Now, what he says in paragraph 6 is, on a concerning perusal of the deed of partition, it is apparent that certain litigants representing Tipaya and Mariappa gave misrepresentations and attempted to sell the property in the form of sites and small bids. Thus, sales that were made under the said documents, there was neither possession nor title to be transferred. It needs to be said that the plaintiffs have retained the properties without alienating them, and they are not signatories to all the sales that have been executed. The possession was retained as vacant land. Plaintiffs produced either the photographs to show as documents supported which indicate that none of the properties have been sold nor alienated, and the vacant area is kept intact despite certain constructions on adjoining the properties have been undertaken, not the social property, adjoining property. Whatever portions that were allotted to the grandfather of the plaintiffs on the recent deed of partition have been kept intact without there being any encroachments upon the property. Therefore, plaintiffs are in lawful position with lawful title, right, interest, ownership and possession with respect to the property described. They claim title and possession of any of the relief. The frame of the suit, Lord, I cannot how the idea of the Lord. For a degree of declaration, declaring that the plaintiffs are in lawful title and lawful possession of the recent deed of partition in respect of portions of the property described in the schedule given to the plaintiff.
Yes.
Now, my Lord, they claim possession, they claim title. Having claimed possession and title, now they are asking for an application of any of the application to reach out to them. Page 31, Lord, it should be.
Page 31. Yes.
That for the reasons not being the accompanying affidavit, the plaintiff in the above case respectfully pray that this honorable court may be pleased to appoint the ADLR for conducting survey of the schedule in the property and to identify the property. Now they ask for identification. Having claimed complete possession, vacant land possession, now they are claiming identification.
No, they are claiming declaration.
Yes.
Declaration and possession. They claim that they
declare that plaintiff are in lawful title and lawful possession under the registered deed, partition in so and so.
In the plaintiff said that I am possessed the property. ಯಾರೋ ಪಕ್ಕದಲ್ಲಿ ಕಟ್ಕೊಂಡ್ರೆ ಅದು ನನ್ನ ಸ್ವಾಧೀನ ಏನು ಧಕ್ಕೆ ಆಗಿಲ್ಲ, ನಾನು ಆಸ್ತಿ ಮಾರಿಲ್ಲ, ನನ್ನ ಸ್ವಾಧೀನ ನನ್ನದೇ ಇದೆ, ಹಾಗೆ ವೇಕೆಂಟ್ ಆಗಿದೆ ಅಂತ ಪ್ಲೇಂಟ್ ಹೇಳ್ತಾರೆ. ಅದು ಬೇಸಿಕ್ ಡಿಕ್ಲರೇಷನ್ ಪೊಸೆಷನ್ ಬಗ್ಗೆ ಇಂಜೆಕ್ಷನ್ ಹೇಳ್ತಾರೆ, ಡಿಕ್ಲರೇಷನ್ ಹೇಳ್ತಾರೆ. ಇಲ್ಲಿ ಐಎನ್ ಅಲ್ಲಿ ನನ್ನ ಜಾಗ ಎಲ್ಲಿದೆ ಅಂತ ಐಡೆಂಟಿಫೈ ಮಾಡ್ಕೊಳ್ಳೋಕೆ ಏಡಿಎಲ್ ಆಸ್ ಬೇಕು.
Yes.
The similar circumstances before the report. In fact, they place heavy reliance on the judgment of the law of this on the Karnataka case. I must be
Yes.
which will make it, will make it.
Yes.
There's a guidelines that is given. It's a guidelines that is given there. Paragila. I know that.
The provisions applicable for local inspections, what is impermissible is a delegation of adjudicating.
Yes.
To cite an example, both parties claim to be in possession, he claims possession and I dispute. Both parties claim to be in possession of the disputed property. The local inspection by the commissioner cannot be ordered to ascertain the possession.
Yes.
You are on property illegal and identify amount for it, so that I will go and take possession of the application. This is not possible.
Yes.
ಆಮೇಲೆ ಗ್ರೇಟ್ ಸ್ಟೇಟ್ 2015 so 2026 ಅಲ್ಲಿ ನಾವು ಎಲ್ಲಾವೇ ಡಿಫರೆನ್ಸ್ ಆಗಿದ್ರೆ ಡಿವೋರ್ಸ್ ಆಗಿದ್ರೆ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಕೋರ್ಸ್ ಐಡಿಯಾ
No, but it is his suit, but delay, if it is cost to him. But what is that prejudicial cost to you? Delay.
my title I have been in possession.
No, not on that appointment of the commissioner. By delayed, nothing will cost to you because he.
My property is similar circumstances what this one will do that.
Yes.
Present petition is directed against the order of the trial court dated 9603, whereby I number 13 has been rejected. I had 13 is effectively for appointment of the commissioner was filed on 2/11/2000. The reason why the I has been rejected is on the ground that it is hopelessly related. That is filed at a stage of proceedings when such an I could not have been entered into the proceeding law. The learned judge has pointed out in the order passed of the suit of the year 19 law. The evidence of the treaty was commenced in the year on 4/11/96 and the evidence was closed on 22/99. In the course of these 3 years, if the plaintiff was a learned advocate desired that any commissioner was necessary or desirable, because at this point of time, his application ought to have been made most certainly before the plaintiff.
Yes, Mr. You have admitted that you are in the position, then why do you want that commissioner?
But the question is this, they have disputed in the written statement also. That in course of the written statement, if one can notice, and the trial that is conducted in the case, that becomes relevant.
Where is that disputing your position?
Yes. Not the written statement is produced. I have produced the written statement. Kindly turn to page 61. There are other defendants also. Page 61, annexure D.
They have disputed.
Yes. Yes. No, that's the difficulty that arises.
Okay, impossible to delegation to cite an example. If both the parties claim to be in the possession of the disputed property,
Yes.
local inspection by the commissioner cannot be ordered to ascertain the possession.
Identification of ಏನು ಕಾಣಿದೆ ಅಂತ ಐಡೆಂಟಿಫೈ ಮಾಡ್ತಾರೋ ಅದನ್ನ ನಾನು ಪೊಸಿಷನ್ ಇದ್ದೀನಿ. ಆಮೇಲೆ the law should make any appreciate what is the property that we are.
Question of possession is to be decided by the court. However, if one party allegedly encroached by that another party denies that such allegation, commissioner can be appointed to ascertain whether there is an encroachment or not. In such a situation, commissioner is appointed to find out the nature of the possession. See that para 12, what you are read.
There is encroachment that is alleged. They claim that he is in possession but are encroached upon the property.
No, see, he is claiming that I am possession is the A scheduled property. If that defendant is denied, he is not in the possession. Can that commissioner cannot be appointed to?
Right, it will even benefit them, my lord.
And say whether the property is, whether the measurement of the property is same, the boundaries of the property is same. What is the?
No, even for the possession also they can encroachment.
Measurement ಮಾಡಿದಾಗ ಯಾವ property ಎಲ್ಲಿ ಬರುತ್ತೆ ಎಷ್ಟು measurement ಇದೆ ಅಂತ
No, this court says commission can be appointed to ascertain whether there is an encroachment or not.
The commissioner will report back to the honorable court what is the measurements of the property. Based upon it, the honorable court will have to decide whether there is encroachment.
No, the deciding is the court ultimately. Now, he will go and measure whether that suit schedule properties is there, the petition plaintiff is there or not, that's all. No, even if it is not an encroachment, identification of the position can be done by that commissioner. That is what this judgment said. ಅಷ್ಟೇ ಅವ್ರು ಹೇಳೋದು ಅಷ್ಟೇ.
ಇಲ್ಲಿ ನಾನೇ ಕೂತಿ ಸ್ವಾಧೀನದಲ್ಲಿ ಅಂತ ಮೊದಲಿಂದಲೇ ಹೇಳ್ಕೊಂಡು ಬಂದು ಕೊನೆಗೆ ನನ್ನ ಆಸ್ತಿ ಎಲ್ಲಿದೆ ಅಂತ ನನಗೆ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ, ಅದನ್ನ ಗುರುತು ಮಾಡ್ಕೊಳ್ಳಿಕ್ಕೆ ಕಮಿಷನ್.
No. See, it is saying that defendant is denied that you are not in the position. Therefore, you appoint a commissioner whether I am in the position or not.
That's all.
That is what he is asking. If everybody is admitted, then he can't seek that identify my position. ಅದೇನು ಅಂತಂದ್ರೆ ಸೂಟ್ ಆಗ್ತಾನೆ ಸರ್ವೇರಿಗೆ ಅಪ್ಲಿಕೇಶನ್ ಆಗ್ತಾರಲ್ಲ ನನ್ನ ಲ್ಯಾಂಡ್ ಅನ್ನು ಸರ್ವೆ ಮಾಡ್ಕೊಡಿ ಅಂತ ಆ ತರ ಆದಂಗ ಆಗುತ್ತೆ. This is not that. This is somebody is denied.
That's a question in finality of the case, not that has to be argued. Not at this stage.
Yes. 40? Yes.
ಒಂದು ಒರಿಜಿನಲ್ ಪ್ಲೇಟ್
Yes.
ಇನ್ನೊಂದು ಅಮೆಂಡೆಡ್ ಪ್ಲೇಟ್. Prayer A debit for a degree of declaration declaring the plaintiffs are in lawful title and lawful possession of the respective portion, leaving portions of the property described in the schedule given to the plaintiff. ಇವಾಗ ಈ ಅಮೆಂಡೆಡ್ ಪ್ಲೇಟ್ ಅಲ್ಲಿ ಆ prayer ಅಮೆಂಡ್ ಆಗಿಲ್ಲ, leaving portions ಅಂದ್ರೆ ಡಿಲೀಟ್ ಆಗಿದೆ, ಬಿಟ್ಟಿದ್ದಾರೆ ಕೆಪಿಗೆ. Typographical error. What is sought in the plate? I do not know typographical error. What is it? Typographical ಏನ್ ಹೇಳ್ತಾರೆ? ಶೆಡ್ಯೂಲ್ ಅಲ್ಲಿ ಇರ್ತಕ್ಕಂತ ಪೋರ್ಷನ್ ಅನ್ನ ಬಿಟ್ಟು ಉಳಿದಿದ್ದನ್ನ ನಾನು ಓನರ್ ಆಗಿ ಡಿಕ್ಲೇರ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಇಲ್ಲಿ ನೋಡಿದ್ರೆ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಬ್ಲಮ್ ಅಲ್ಲಿ ಇರ್ತಕ್ಕಂತದನ್ನ ಟೈಟಲ್ ಅನ್ನು ನನ್ನ ಓನರ್ ಆಗಿ ಡಿಕ್ಲೇರ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾರೆ.
No, this. What is that page 57?
57 is amended.
What is that amendment application they have filed?
That I have.
Which is that amendment has been filed? Then we can make out what is that he has sought for an amendment. Where is that application for amendment?
I have not produced it. I can produce that.
You produce that amendment application.
Yes.
ಯಾಕೆಂದ್ರೆ ಇದು ಒರಿಜಿನಲ್ ಪ್ಲೇಟ್ is ಶೆಡ್ಯೂಲ್ ಪ್ರಾಬ್ಲಮ್ ಅನ್ನ ಬಿಟ್ಟು ಉಳಿದಿದ್ದನ್ನ ನಾನು ಓನರ್ ಆಗಿ ಡಿಕ್ಲೇರ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾರೆ.
ಇದು ರಿವರ್ಸ್ ಇಲ್ಲಿ.
ರಿವರ್ಸ್ ಇದೆ.
Let us see what is that.
I'll produce that application.
Yes.
ಯಾವುದು dispute ಅಲ್ಲ ಇಲ್ಲ litigation.
Yes.
ಪ್ಲೇಟ್ ವಾಪಸ್
When will produce that?
Monday I'll do.
Yes. Yes, sir. The request, leave this matter on Tuesday.
Seal number 34, Chetan B for petitioner.
Yes.
For petitioner, no, the petitioner's, my lord, impleading application is rejected by the trial court. My lord,
Now, you are the proposed suit for?
Suit for specific performance, my lord. My lord, much prior to filing the suit, my lord, suit in question, my lord, at annexure E, page number 50, the petitioner herein, my lord, has filed a suit for partition and separate possession on 28/6/2016, my lord. Lord, Kamalamma is the plaintiff. Defendant number 1 is Thimmamma and defendant number 10 is Ravi. My lord, against the mother and my lord, other siblings, my lord, suit was filed for partition. My lord, during the pendency, my lord, and after hearing the matter, my lord, the honorable trial court was pleased to grant interim relief, my lord, that no third party interest should be created. My lord, during the pendency of the suit, my lord, the respondent number 1 has filed a suit for specific performance as against my mother and my brother, my lord.
Who is respondent number 1?
My lord, the mother. Respondent number one, my lord, is a third party to the family,
Third party.
third party to the
No, who
family.
has executed a sale deed in his favor?
My mother, the petitioner's mother, and one of my brother, my lord.
Yeah, after that partition suit.
Yes, my lord, that too during the, my lord, the operation of
Yes.
the interim order. my
Filed
lord.
in a suit for specific for
My
purpose.
lord, in the year 2023, I filed the suit, my lord, for partition in
The
the.
application, why it is rejected?
My lord, on the premise that, my lord, I am not a necessary party. In the suit for specific performance, my lord, I have no role to play. It is only the scope of the suit will be enlarged. My lord, my humble submission is, my lord, I kindly appreciate, even the defendants are not contesting the matter. My mother as well as my brother are not contesting the matter. My lord,
Yes, heard. Issue notice. Stay of further proceedings in OS number 181 of 2023. Pending in the file of 4th Additional City Civil Judge KMFC Hassan till next date of hearing.
Public.
Cell number 35, Rashmi Jat.
Yes.
Your Lordship, here, wife, who is the petitioner, she had filed an application in the family court in a
Yes.
partition suit in
Yes.
OS number 383/2022, instituted against the husband. She filed an application under Order 12, Rule 6 for judgment and admission,
Yes.
based on his admission in the written statement.
Yes.
Your Lordship, here the Honorable Court rejected her application, citing certain reasons. That is in page number,
Which is that page?
page number 31. The impugned order. The
Yes.
impugned order starts from page number 28, Your Lordship. 29, 30 and 31.
Now you
Here,
read.
the Honorable Court cites that
Now you read para 3. Plaintiff has filed in a suit seeking a partition and.
Para 3, the plaintiff has filed a suit seeking partition and separate possession of her half share in the suit schedule premises, the residential apartment, bearing number 006 in the ground floor of Sparta, measuring 3593 square foot of super built up area with one basement car parking at Kosu Road, Madiwala Division, Bangalore. The plaintiff has contended she and the defendant are the husband and wife, and their marriage has been solemnized on 27/9/2004 and registered before the sub-registrar office, Ernakulam, Kerala, under the Special Marriage Act. The plaintiff has contended she was a divorcee with a girl child, and after their marriage, she and the defendant have 2 more girl children. The plaintiff has contended that she and the defendant purchased the suit schedule premises in their joint names, but now the defendant behind their back obtained the bank loan. The plaintiff has contended now the defendant has totally neglected their interest. The plaintiff has contended she and their 3 children are residing even today in the same flat, and the defendant has filed his written statement. Defendant in his written statement has contended that plaintiff has no source of any income and he contributed all the money purchasing the suit schedule. But at the time of registration, he and the defendant have taken the sale deed in their joint names. The defendant has contended that the name of the plaintiff in the sale deed is for nominal sake and he is the absolute owner of the suit schedule property. This court, based on the pleadings of both the plaintiff and the defendant, has already framed the issues. The plaintiff side during the trial have revealed that in the Debt Recovery Tribunal, Bangalore, already the order has been passed for recovery of the entire loan amount. The plaintiff side have furnished the copy of the Debt Recovery Tribunal order. In the said order, it is shown that the defendant number 1 is Miss Bobby Sebastian, wife of Mr. Rajendran, and the defendant number 2 is as shown as Mr. Rajendran, son of Kunyappa Nair. In the petition file herein, the name of the plaintiff is as shown as Miss Bobby Elizabeth Rajendran. There is no clarity whether the plaintiff here.
Yes, you take notice.
Your Lordship, here it is, this application is mainly rejected only on the basis that whether her name, there is a name change, which is not challenged by her husband only, because before her marriage in her PAN card, whatever name was there, that was given. Then thereafter it says that there is a case in the Debt Recovery Tribunal.
Yes,
and
yes, you
under
take
section
notice.
34. But 34, under section
No, that's,
34,
we'll hear, you take notice to that respondents.
it is purely a question of law actually.
Yes, notice has to be served to him.
Yes, much
Yes. Issue
kindly
notice.
a short notice.
Yes,
short-
issue emergent
The
notice.
reason being, there is already an attachment warrant by the city civil court in the very same property
Yes.
for a debt of the husband, and the warrant has been issued, the delivery warrant has been issued in 2021 itself.
Yes.
Because of her obstruction petition, and we also filed an application under order 21 rule 58. Due to the family, this partition case, that application was rejected.
Yes.
Hence, there is an urgency and hence
Yes,
short
emergent notice.
and hand delivery also.
Yes, in addition, petitioner is also permitted to take out hand summons to respondent. Yes.
Respondent lawyer, your lordship, because he is absconding. In fact, he has about 37 warrants from
No,
the
hand
magistrate.
summons to that lawyer. You can serve a copy.
Yeah,
Yes.
to the lawyer in the
Addition.
trial court, respondent's lawyer.
Petitioner is permitted to serve a copy on the counsel appearing for the respondent before the trial court.
Cell
Yes.
number 36,
Kindly a
Party,
date.
Sandana Gowda.
You serve it and move that matter.
Achu.
Yes. Yes. Yes, but it.
Lord, the respondents 1 to 4 are the owners of the property in question.
Yes.
The property came to be acquired by the fifth respondent for Upper Tunga project.
Yes.
Then, my lord, the award came to pass to the land action officer.
Yes.
Meanwhile, the response 1 to 4 owners have executed registered agreement and GPA in favor of the petitioner hearing. And authorizing him to conduct the proceedings regarding the land action matters.
Yes.
That to conduct the cases,
Yes.
LAC cases and execution and all. The petitioner has filed miscellaneous appeal before the senior civil judge, seeking direction against the land action officer to refer the matter to the reference court under section 18(3)(b) of the act.
Yes.
The said application came to be allowed.
Yes.
Thereafter, the matter has been referred to the civil judge,
Yes.
that reference court. Reference court, after conducting inquiry, has allowed the reference and determined the market value of the land in question. That is, my lord, in LAC 14.
Yes.
After passing the judgment by the reference court, the response 1 to 4 have filed the execution petition and executing the decree passed by the reference court
Yes.
without giving my lord, the agreed share to the petitioner hearing.
Yes.
The petitioner has filed application under Order 21 Rule 101 as objector. The execution court, without conducting inquiry on my application, posted it for a memo of, accepting memo of calculation.
No, see, execution petition is filed by whom? You have.
The respondents 1 to 4 have filed.
No, the case has been prosecuted by you.
By me.
But in execution, they have filed.
Please.
Yes. Then you have filed an application as an objector.
Please.
Yes.
That registered agreement.
Issue notice. Stay of further proceedings.
Lord, sought for direction not to disperse the amount deposited in execution.
No, staying further proceedings in execution
Please,
itself.
please.
Yes. Stay of further proceedings in execution petition 25 of 2022 pending in the file of Principal Senior Civil Judge JMFC Shimoga till next date of hearing. Yes.
Cell number 37 adjourned. Cell number 38, Shekhar Badigar.
Yes. Yes.
My lords, this is the defendant's writ petition, my lord.
Yes.
My lords, I had filed an application for amendment of the plaint, my lords, that was rejected by
No,
order.
suit for
Suit for partition and separate position, my lords.
partition and separate position. You have filed an amendment of what?
Amendment of, amendment of insertion of paragraph number 6A to C, my lords.
In that written statement.
Please, my lords. in
What
our
is
written
that you want to insert?
My lords, few parties, my lords, they were within the same family. They were not made as the parties, and few properties.
Where is that impugn order?
My lord, impugned order is at page number 18, my lords.
Yes, what is the reason given for
My
rejection?
lord, reason given is the suit is of 2015, and at the stage of evidence, you have filed as amendment application.
What is the reason for delay, madam?
My lord, there were previously, there were two advocates, my lords. They had given NOC on, because some allegations that were made against that advocates, my lords. Then the another advocate was, we filed wakalat on 4/7/2024, my lords. And subsequent to that only, on 6/8/2024, we filed the amendment application, my lords.
Is it the reason?
The trial court.
If advocates are,
My lord, even the
where is
trial,
that your application for reasoning of delay?
my lord,
Where is your application?
please, my lord. My lord, it's at, it is at page number 44, my lords.
Yes.
ತಿದ್ದುಪಡಿ ಮಾಡಬೇಕಾಗಿರುವುದು.
Where is that? Why you have not filed that application
My
on
lord,
this?
in that Pramana Patra, my lords,
Yes. ಎಲ್ಲಿ ಹೇಳಿದ್ದೀರಾ?
About the advocate, we have not mentioned, my lords,
then?
but in the order, we have mentioned.
No. Where is that reason why you have not filed all this delay, madam?
Please, my lords.
This is all dragging that matter.
But my lords, we filed wakalat on 4/7/2020.
No, that is not immaterial.
Please, my lords.
Even last date when that judgment, pronounced for judgment, some advocate come and file an wakala saying that I am filed today, it can be granted. There is no that. Have you explained by filing an affidavit saying that these are all the advocates who have given instruction, he has not filed? Then we can see whether delay is proper or not. Nothing is there. Where is that explanation?
Lord, that explanation is not mentioned.
Then what is wrong in the trial court order, madam?
My lords, in paragraph number 2 of the affidavit, my lords, my apologies, my lords. Para 2 of the affidavit, my
Page?
lords, page 48. May I read, my lords? ನಾನು ಹೇಳುವುದೇನೆಂದರೆ ಸದರಿ ಈ ದಾವೆಯನ್ನು ವಾದಿಗಳು ನಮ್ಮಗಳ ವಿರುದ್ಧ ದಾವಾ ಸ್ವತ್ತುಗಳಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಭಾಗಾಂಶ ಹಾಗೂ ಇತರೆ ಪರಿಹಾರವನ್ನು ಕೋರಿ ಘನ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಹೂಡಿರುತ್ತಾರೆ. ಸದರಿ ದಾವೆಯಲ್ಲಿ ನಮ್ಮ ಪರವಾಗಿ ನಾವು ಕೊಟ್ಟ ಮಾಹಿತಿಯ ಆಧಾರದ ಮೇಲೆ ಲಿಖಿತ ಹೇಳಿಕೆಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತೇವೆ. ಸದರಿ ದಾವೆಯ ವಾದಿಯ ಅಡವಿಚಾರಣೆಗೆ ಬಂದಿರುತ್ತದೆ. ನಾವು ಮೊದಲು ಶ್ರೀ ಚಾಂದ್ ಪಾಷ್ ಎಂಬ ವಕೀಲರನ್ನು ನೇಮಿಸಿಕೊಂಡಿದ್ದೆವು. ಅನಿವಾರ್ಯ ಕಾರಣಗಳಿಂದಾಗಿ ಅವರು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಬಾರದ ಕಾರಣ ನಾವು ಪ್ರಸ್ತುತ ವಕೀಲರನ್ನು ನೇಮಿಸಿರುತ್ತೇವೆ. ಪ್ರಸ್ತುತ ವಕೀಲರು ನಾವು ಸಲ್ಲಿಸಿದ್ದ ಲಿಖಿತ ಹೇಳಿಕೆ ಹಾಗೂ ಇತರೆ ದಾಖಲೆಗಳ ಬಗ್ಗೆ ತಕರಾರನ್ನು ನಮ್ಮಿಂದ ಪಡೆದುಕೊಂಡಾಗ ವಾದಿಗಳು ಸಿದ್ದಯ್ಯ ಹಾಗೂ ಜೀರಗುಂಡಯ್ಯನವರ
ಯಾವ ಡೇಟ್ ಏನು ಹೇಳಿಲ್ಲ, ಸುಮ್ಮನೆ ಅಡ್ವೊಕೇಟ್ which date when you have heard issue notice stay of further proceedings in OS number 200 of 2015 pending in the file of additional senior civil judge Ramnagara till next date of hearing. Yes.
Obliged.
Cell number 39, Shailashri.
Yes. Yes, madam.
I have filed an application seeking further stay of proceedings in OS 1551 of 2015.
Why?
Because it's a suit for partition, my lord. I'm the defendants 2 to 5 in the said suit, Your Honor. The suit was filed in the year 2015. 2017, I filed a in detail written statement mentioning all the, I took all contentions in my written statement, my lord. The plaintiff, after the matter is posted, now the stage is for cross-examination of PW1. They come up with an application in the year 2025, that is last year, my lord, with seeking amendment of the pleadings. The reasoning given by the amendment of plaintiff is, after filing of the written statement, that is we, the defendants herein, we came to know the existence of so many contentions they took. They came to know aware of the contentions through my written statement. The written statement was filed in the year 2017.
No, what is that amendment they have sought, madam?
My lord, that is the amendment. There is an existence of a decree and as well and
No,
another
suit for partition.
suit for partition.
What is that amendment they have sought?
My lord, kindly page number. Prayer as well as pleadings, my lord. Page number 40.
ಎಲ್ಲಿದೆ prayer?
Prayer is. Page number 38, my lord. 38.
ಆಯ್ತು, ಅದ್ ನಾವು ಹಳೆ ಸೂಟ್ ನಮಗೆ ಬೈಂಡಿಂಗ್ ಅಲ್ಲ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಸೂಟ್ ಒಂದೇ ಅಲ್ಲ ಸ್ವಾಮಿ, ರಿಜಿಸ್ಟರ್ಡ್ ವಿಲ್ ಒಂದು ಎಕ್ಸಿಕ್ಯೂಟ್ ಆಗಿದೆ. ಅದನ್ನ ನಾನು 2017 ಕಂಟೆನ್ಷನ್ ತಗೊಂಡಿದ್ದೀನಿ. ಅದನ್ನ ಅವರು ದೇ ಕುಡ್ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ಅಮೆಂಡ್ಮೆಂಟ್ ವಿತ್ ಇನ್ ಆಫ್ಟರ್ ಸಮ್ 6 months or 1 year. ದೇರ್ ಇಸ್ ನೋ ದ ರೀಸನ್ ಏನ್ ಹೇಳಿದ್ದಾರೆ ಅಂದ್ರೆ, ಯುವರ್ ಆನರ್ ಮೇ kindly see the affidavit, my lord, page number 40. I submit that after filing of the written statement by the defendants, plaintiff came to know that one ಅಂತ ಹೇಳ್ತಾರೆ.
ಯಾವಾಗ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿದ್ರು?
2017 ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದು 25
Stay of further proceedings in OS number 1551 of 2015 pending in the file of 7th additional senior civil judge Bangalore Rural District, Bangalore till next date of hearing. Yes,
Cell number 40, Vinayaka S. Pandit.
yes.
I'm for the petitioner.
Yes.
Suit for eviction, my lords. I am the defendant,
Yes.
tenant. I have filed my written statement.
Yes.
Now, by an application, the plaintiff filed an application seeking striking off of my written statement.
Yes.
The trial court has passed an order striking off my written statement.
Why?
That is under challenge, my lords. Kindly have annexure A, that is the impugned order. Their application was premised on the fact, on the contention that I have not paid rents. Our suit is only for eviction. Arrears of rents ilva illa. On the contrary, I have filed along with written statement payments of rents even after filing of suit.
Yes.
Suit ಹಾಕದ ಮೇಲೂ ನಾನು ರೆಂಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಜೊತೆ ಹಾಕಿದ್ದೀನಿ. By way of this order, my lords, my defense is struck. The consequence of this is ನನಗೆ ಎವಿಡೆನ್ಸ್ ನಡೆಸಕ್ಕಾಗಲ್ಲ ಇವಾಗ.
Yes. Now you have handed over the possession.
That is also already given. Possession is also handed over.
Then what is the suit now for?
Suit, my lords, kindly have the prayer, my lords. Suit prayer at 25, page 25.
25. Yes.
A. Decree for eviction of the defendant and directing the defendant to vacate and hand over possession. This is already satisfied because I've already handed it over.
Yes.
B. Decree directing the defendants to pay mean profit damages for illegal occupation of the premises. That is the second prayer.
Yes.
Third one, permanent injunction restraining the defendants. Ad barode illa, nan possession kot mele.
Or issue notice. Stay of further proceedings in OS number, commercial OS number 808 of 2023, pending in the file of 89th Additional City Civil and Session Judge, Bangalore, till next date of hearing. Yes.
That's okay.
41, Ravi HK.
Yes, Mr.
Lord, the petitioners have called in question the order of the executing court ordering for police protection for the purpose of execution of delivery warrant. My Lord, kindly see page number 66, my Lord, in a writ petition which is pending before this honorable court.
No, you are that judgmentator.
Judgmentator. Kindly see page number 66, my Lord.
Yes.
In a writ petition involving the very same subject matter, very same parties, my Lord, this honorable court has directed at page number 69
Yes.
that there shall be an interim order of disposition of petitioners from the land in question. Lord, despite the operation of the order of this honorable court,
Execution petitions.
Lord, this writ petition was filed earlier to the judgment passed in the suit for redemption of mortgage,
Yes.
which was filed by the decree holders. This honorable court said they shall not be dispossessed till the writ petition is disposed of. The trial court is aware of it. The respondents herein are aware of it. Despite the same, my Lord, they sought for police protection for the purpose of execution of delivery warrant.
What is the degree passed by the trial court?
For redemption of mortgage, my Lord. Against which, my Lord, I have filed RA, which is pending consideration. And during the operation of the order passed by this honorable court and pendency of the appeal,
Yes.
this order has been passed, my Lord.
Lord, issue notice, stay of further proceedings in execution number 108 of 2023, pending in the file of first additional civil judge, Nanjangud, till next date of hearing.
Grateful.
Yes.
Cell number
Lord,
42.
notice in respect of respondent number 5 may be dispensed with because he is sailing with the petitioner.
You give that memo.
Yes, my Lord.
Cell number 42, G. Balakrishna Shastri.
Yes.
Petitioner being aggrieved by the dismissal of impleading application, my lords, has filed this writ petition.
Who are you?
Lords, I am the complainant before the municipal corporation. My lords, my neighbor, without leaving any setback, has built, and without, there was some civil litigations, compromise agito, and even he's not following the compromise
No,
Hmm.
but judgment of this court said that you are not necessary party.
No, my lords. Judgment of this court says that we are necessary. There are a lot of judgments. This honorable court, my lords, made.
Then which
And
has
my
to
lords,
follow?
annexure H, my lords, the respondent number 1 had filed a complaint against me. Other, against us an order was passed. We filed MA. She also filed an impleading application. That was dismissed. She filed a writ petition and it was allowed. Order is produced as annexure H. Page 52 is the order portion. Same facts apply to our case.
What is this?
They are
one?
neighbors. 52, 53 and 54 gives the reasoning.
No, what is that judgment of this court?
This court, my lords, para 6 and 7 may be seen, my lords. It is not in dispute that the proceedings before the tribunal that emanated pursuant to the notices issued by BBMP under section 321 of the KMC Act, and such notices were issued against the owner of the property pursuant to a complaint registered by the petitioner. This fact is not in dispute. The tribunal ought to have permitted the petitioner to come on record as a party respondent.
But idrikita munche judgment ide. Munche judgment ida nodidira?
This latest judgment.
No, that is division bench judgment also ide. BV Nagaratna justice.
But in this judgment, lots of Supreme Court judgments are quoted. In the light of aforesaid judgments of the apex court, the division bench and the coordinate benches.
Section 321 has been considered.
Please.
Why you are not necessary party has been held. Yes.
No, my lords, kindly.
Issue notice.
My lords, judgment post agide 13th ಗೆ.
Yeah, further proceedings.
Grateful.
In what is that MEI? It is pending before that
district court.
Yes, MEI 15 of 2025. 6th additional district and session judge Mysore till next date of hearing.
Great.
They may dismiss the suit also.
My lords.
They may dismiss the suit also, Mr. What you can do it by impleading, Mr.
My lords, writ petition now, MA now hakidrali, it was allowed. Now the respondent in this, in my complaint, in their complaint, sorry, they have filed a writ petition against me.
I agree
Now
that.
If we are not impleaded, we will not have any rights to file a writ petition.
No, it may, their suit may dismissed.
My lords,
Now you want to implead in that MEI.
MA. Corporation has held that respondent number 1 has violated.
No, that MEI is filed before where?
MA is filed before the district judge, stating that the order of the corporation is wrong.
Yes, that MEI. MEI is filed by that encroacher.
Encroacher, yes.
That MEI may be dismissed, corporation order may be confirmed.
It may be allowed because no annexure J,
Yes.
they have not filed any objections.
Yes.
43 Ravi HK for petitioner, Mali Patil.
Yes. Yes.
This is the writ petition filed by the defendant.
Defendant.
Yes, against the rejection of the order at annexure K.
Suit for?
Blood suit for partition filed by the plaintiffs, my lord,
Yes.
and separate possession.
Annexure
Blood,
K.
we are the defendants, my lord.
You have application filed for?
Now, my lord, this application was filed under section 151 CPC, my lord, permitting him to examine the additional witnesses. Lord, the reason for additional witnesses now arisen is this. Lord, after filing the suit for partition and separate possession, we are for the defendants. Our case is that earlier there was already partition and there was also a will.
Yes.
Lord, subsequently, we have come to know those two documents.
Yes.
By producing those two documents before the honorable court,
Yes.
we have requested the honorable court to permit us to examine the witnesses to those documents before this honorable court. So that application came to be rejected. We were not aware of those witnesses earlier to that because we were not, able to trace those documents earlier to that. Therefore, we did not file these two names, my lord, witnesses in the list of
Why it
witnesses
is
before the
rejected?
honorable court. Now, my lord, that application, now the matter is, my lord, at the stage of evidence now. It is not at close. But in fact, even this honorable court has come to
No,
conclusion.
what is the reason for rejection?
Lord, reason, my lord, we were not aware of these witnesses. We were not aware of these.
No. What is the reason for rejection by the trial court?
Rejected. Lord, rejected on the ground that it is at the belated stage.
Yes, Mr.
And
what
one more,
prejudice-
one more reason, my lord. Earlier to this, my lord, another application came to be rejected for one reason, my lord. Say earlier application we filed under order 16/1, blood wherein, see, summons will be issued by the court for the examination of the court witnesses.
Yes.
But here we are requesting the court to allow us to examine our own witnesses before the court
What
to
prejudice
prove these
will cause?
documents. And one, my lord, one more reason. Similar application was filed by the plaintiffs, which came to be allowed with cost of rupees 2,250. But our application has been rejected.
ಆಯ್ತು really what is that? What is that prejudicial cost, Mr. If it is?
Lord, your lordship may kindly see, Lord, annexure E, page 41.
Yes.
Please to permit him to examine the additional witnesses mentioned in below, so and so. My lord, that application, my lord, has came to be dismissed, my lord, by order at annexure page 50.
50?
Hereby application so and so and so and so dismissed. 57. This order, my lord, application is filed, my lord, under order 16 rule 192. Again, my lord, by the same relief, they filed another application under the 150 page, my lord, 58 annexure H.
No, that, what is that you are reading that? What is that application earlier filed is allowed?
It is dismissed.
Ah.
Again, one more application was filed for the same relief. Only provision is, my lord, section 151.
ಈ ಡಿಸ್ಮಿಸ್ ಆರ್ಡರ್ ಆಗಿದ್ದು ಏನ್ ಮಾಡಿದ್ರು?
ಏನು ಮಾಡಲಿಲ್ಲ ಅವರು, ಹಾಗೆ ಮಾಡಿದ್ರು. They filed one more application, now that annexure H, my lord, for the same relief. And this order is at, my lord, page number.
Where is that earlier application annexure?
Yes, my lord. Page number, my lord, kindly see, same order, same application. Reason, my lord, at page number 75.
Application page.
Application, my lord, at page number.
Annexure E.
Yes, my lord,
Kumar.
page number 58. 58, annexure H.
No, earlier is annexure E.
Annexure E is annexure H.
Dismissed.
Now the court has given the reason, my lord, page 75.
Aita, annexure H application is filed now. What is that?
H is filed, my lord, for the same relief.
Aita, order ellide.
Order at page number 75.
Yes. Yes.
It is very important, my lord, page 75, my lord, para number 12.
Yes.
It is very important to note that earlier the application filed by the application under order 16 rule 192 CPC with the same prayer wherein in the affidavit annexed to the application has stated that even though they were advised by their counsel due to inconvenience and inadvertence, they could not file the witness list well in advance. It is very important to note that when the application was
Yes,
dismissed by the
earlier
court,
application is
the
dismissed,
applicant
Mr.
take.
Earlier application.
Said earlier, that's what I mentioned, earlier
No,
application.
they have to challenge that earlier application.
Yes.
Said earlier application was filed by mistake under Art 16 rule 1, which pertains to the summoning of the witnesses through the court.
No. You see that same parties you want to examine. You see that?
Same.
Maybe quoting a wrong provision will not.
Wrong
vitiate.
provision, we filed an application. Subsequently, my
No, even if you filed in a wrong provision, it will not vitiate that. Now that what is the prior sought in that earlier?
lord, prior is also different. Your last may kindly see in the application now filed.
No, first application you see.
Now,
Affidavit.
first application, my lord.
Pray this honorable
Ah,
court
yes,
please to
page
permit him to
41
examine
first-
that additional witnesses.
Yes. my lord,
Now
pa-
annexure H.
Yes, yes. My lord, page 41 earlier application.
Yes.
That was only to, my lord, to permit him to examine the additional witnesses mentioned below.
Yes.
My lord, see earlier. Now the, my lord, see present application is, now my lord, these witnesses were not mentioned in the list of witnesses filed. See,
No.
list of witnesses are to
No,
be
you
filed.
see earlier application.
Yes.
Same party. B. Kumar.
Well, same, but provision of law was made, my lord, say that was only made, my lord, because provision of law was made.
The court has given a reasoning and rejected. By changing the provision, same prior court cannot be given, Mr. Then you are overcoming that court order without challenge.
No. Earlier, your last may see order 6, your last may kindly see order
You
6.
forget about that provision.
Order 6, your last may kindly
You
see.
forget about the provision. Earlier, you have filed an application to permit you to examine that list of the witnesses.
Yes, my lord.
Now also seeking the same and same parties. Earlier it is rejected. Suppose.
We were required to.
No, if this is accepted, after that, another some time, you can file an application under the other provision, can seek for. It is overcoming that earlier order.
No, what has happened, my lord?
Yes, you see
Earlier,
that.
I ought to have filed this application under section 151, requesting the court to permit us to examine the private witnesses, not through court. Court witness, not court witnesses. My lord, order say, see, 16 rule 1 applies to, my lord, court witnesses.
May please
So
to
that
permit
application
him
came
to
to be
examine that
rejected.
additional witnesses.
Since it was, my lord, see,
Please to
under the
recall
wrong
the statement.
provision, my lord, we filed the present application under the inherent powers.
That additional witness mentioned below. Early the court witness anta. You said that has been additional witness aste.
That is to summons the witnesses by the court, see, who are all required to be examined.
No, you
Summoning
read-
and
you
see
read that
attendance of
prior-
witnesses.
For the reason to accompany affidavit, appellant most respectfully praise this honorable court. Please to recall the stage of examination, list of the witnesses, permit that appellant defendant number 1 to examine that additional witness mentioned below. What is that prior you have sought in that earlier?
But see,
Maybe please to permit him to examine that additional witness, same prior.
same prior, Ladi, here you last me kindly see. Permit, see, to examine the additional witnesses mentioned below. That was the first application made.
Now see that second
Now you
application.
last me kindly see. So in the affidavit,
Not affidavit, see the prior, mister.
the prior in the application, of course, my lord. So first application, may be pleased to permit him to examine the and examine the additional witnesses mentioned below.
Same prior you have sought.
Yes. Well, now we have filed an application for recalling the stage of the examination of the witnesses. That present application, blood, your last may kindly see it is.
The annexure H.
Annexure H.
Same prior.
One second. Yes, H as page 58, my lord.
No, he has not even sought for setting
Is to
aside that
recall the
earlier
stage of-
order.
Is recall the stage of examine the list of witnesses and permit the applicant defendant number 1 to examine the additional witnesses mentioned below. So recalling and also permitting. See
Same
now,
additional witnesses examine ಮಾಡಕ್ಕೆ recall ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರು. ಅವಾಗ್ಲೂ ಅಷ್ಟು additional witness. Yes, how can that one court has rejected? Maybe
16
wrong
ನಲ್ಲಿ-
unless you are challenged.
ಅಲ್ಲ 16 ನಲ್ಲಿ summoning of the witnesses is application.
See that prior, you make.
ಅನ್ನ ಅರ್ಥದಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ. ಅಲ್ಲ ಒಂದು you last me kindly see.
Yes.
But see here all that we are
Maybe
seeing.
you are entitled, but court has given a finding that order is final. Without challenging that, you are filing an another application. It is contrary to that court giving in another order. Then it is.
ಅಲ್ಲ ಅಲ್ಲಿ ನಮ್ಮಲ್ಲಿ ಲಿಸ್ಟ್ ಆಫ್ ವಿಟ್ನೆಸ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತಕ್ಕಂಥ ರೀಸನ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಬ್ಲಡ್ ಹಿಯರ್ ಸೋ ಫಾರ್ as examining filing of the list of witnesses, examine the witnesses is concerned. Blood this
No,
honorable
you-
court
you have a right, but wrong, if it is wrongly rejected, if you are not challenged, then you cannot file an another application saying that pass in another order.
not under the same provision of law.
No, provision is not necessary. You see that prior.
Yeah, so summoning means witnesses are already there, but they will have to summon out of 16.
Yes, yes.
Blood here these two witnesses were not on record. We
Yes.
were not part of the list of witnesses at
Yes,
all at
yes.
any stage.
Yes,
Blood
we'll
their
come back.
objection.
230.
One request, my lord. Serial number 41, since it's a matter of delivery warrant, I request for hand delivery, my lord. I'll give a memo, please.
Serial number 123 wala.
120.
P wala. My petition.
What you want? 123, you are appearing for?
Petitioner.
Yes, at the request of petitioner, leave this matter after 2 weeks. 125, at the request of petitioner after 2 weeks. Yeah, have you informed other side? Interim order extension ಆದ್ರೆ you have to inform, mister. Yes. ಯಾರು ಗೊತ್ತಿಲ್ಲ ಅಂತ you can't say that, mister. Where your colleague, yes. 51. Yes, filed in a memo seeking leave of this court to withdraw, dismissed as withdraw.
ಅಲ್ಲ ಅಡ್ಜರ್ಮೆಂಟೇ ಕೊಟ್ಟಿಲ್ಲ. ಇಂಟಿಮೇಟ್ ಮಾಡಿ ಬಂದು 2:30 ಹೇಳಿ.
ಕಂಟಿನ್ಯೂನಾ
ತಗೊಳ್ಬಿಡಿ.
ತಗೊಬಿಡ್ಲಾ?
ಯಾಕಂದ್ರೆ ಇಲ್ವಲ್ಲ ಈಗ. ಬೇರೆ ಬೇರೆ ಇದೆಯಲ್ಲ.
Sir.
ಹದಿಮೂರು ನೋಟಿಸ್.
Sir, 123, one date. 123.
ಈಗ ತಗೊಂಡ್ರಲ್ಲ 2 weeks ಅಂತ.
ಅದೇ one date.
ಡೇಟ್ ಕೊಡಲ್ಲ.
Date ಇಲ್ಲ.
ಅವರೇ ಪರ್ಟಿಕ್ಯುಲರ್ ಆಗಿ ಅವ್ರ ಡೇಟ್ ಕೇಳಿದ್ರು ಮೇಡಮ್
ಅದೇ.
ಕೊಡ್ಲಿಲ್ಲ. ನೀವ್ಯಾರು?
ಪಿಟಿಷನರ್
14%. ಸಾಹೇಬ್ ಇದ್ದಾಗ
ಇದು 230 ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾರಲ್ಲ ಈಗ
230 ಬೇರೆ ಬೇರೆ ಇದ್ದಾವೆ, ಬೇರೆ ಬೆಂಚ್ ಇದೆ.
ಹಾ ಬೆಂಚಾ
ನಾಳೆ ಕೊಡ್ಬೋದು ಸರ್ ಬೆಳಿಗ್ಗೆ
ಹಾ ಕೊಡಿ. ಸಾಹೇಬ್ರು ಇದ್ದಾಗ ಬಂದು ಕೊಡ್ಬೇಕು.
ಬೆಳಿಗ್ಗೆ ಟೈಮ್ ಮಾತ್ರ
ಹೌದೌದು. ಅಲ್ಲ ಮಧ್ಯಾಹ್ನನೂ ಕೊಡ್ಬೋದು, ಬಟ್ ನೀವು 14% ಇದ್ದೀರಲ್ಲ ಒಬ್ಲೈಜ್ ಮಾಡಲ್ಲ ಬೆಳಿಗ್ಗೆ.
ಕರೆಕ್ಟ್ ಆಗಿದೆ ನೋಡಿ ಸರ್.
ನಾವು ನೋಡೋಷ್ಟಿಲ್ಲ, ನೀವು ಅಲ್ಲಿ ಯಾರು ಅಡ್ವೊಕೇಟ್ ತೋರಿಸಿ, ನಾನೇ ಎಲ್ಲ ಹೇಳಿ ಕೊಟ್ಟಂಗೆ ಆಗುತ್ತೆ.
ಹಾ ಸರಿ ಸರ್.
ತ್ರಿಲೋಕಿನ ಜಡ್ಜ್ಮೆಂಟ್ ಇದ್ದಾರೆ
ಏನ್ ಇಶ್ಯೂಗೆ?
ಆರ್ಡರ್ 23 ರೂಲ್. ಯಾಕಂದ್ರೆ ನೀವು ಒಂದು ಕಾಪಿ ಕೇಳಿದ್ರಿ, ನಮ್ಮ ಹತ್ರ ಇತ್ತು.
ಹೌದಾ? ಇಲ್ಲ ಇಲ್ಲ
ಚೇಂಬರ್ ಅಲ್ಲಿ ಇತ್ತು.
ಆಮೇಲೆ ತಗೊಂತೀವಿ. ಆಯ್ತು ಅಲ್ಲೇ ಗಿರೀಶ್ ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಒಂದ್ ನಿಮಿಷ ಇದೊಂದು ಫೈಲ್ ಕೊಡಪ್ಪ, ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಇರುತ್ತೆ ನೋಡಿ, 8264 ಒಂದು ಫೈಲ್ ಕೊಡಿ. ಒಂದು ಸೈನ್ ಮಾಡಿಸ್ಕೋಬೇಕು, ಅವ್ರು ಹೇಳಿದ್ದಾರೆ. ನಾಳೆ ಬರ್ಬೇಕು ಬೆಳಗ್ಗೆ. ಹಂಗಾಗಲ್ಲ ಸರ್, ನಮ್ಮಲ್ಲಿ ಮೆಮೊ ತಗೊಳಲ್ಲ, ಸಾಹೇಬ್ರು ಬಂದಾಗ ಕೊಡಿ. ಇಲ್ಲ ಏನ್ ಮಾಡಕ್ಕೆ, ನಮ್ಮ ಪ್ರೊಸೀಜರ್ ಬೇರೆ, ಅವ್ರ ಪ್ರೊಸೀಜರ್ ಬೇರೆ, ನಮ್ಮ ಪ್ರೊಸೀಜರ್ ಬೇರೆ. ಸಾಹೇಬ್ರು ಒಂದೊಂದು ಕೇಳ್ತಾರೆ, ನಮ್ಮ ಹಾಕೊಂಡು ಅಲ್ಲಿಂದ ಮಾಡಕ್ಕೆ ಸೈನ್ ಮಾಡಿಸಿಲ್ಲ ಅಂದ್ರೆ ಕೊಡಲ್ಲ ಅವ್ರು. ಈಗ ನಮ್ ಕುತ್ತಿಗೆ ಬರುತ್ತ.
ಸರ್ ಮಧ್ಯಾಹ್ನ ಮಾಡ್ಬೋದು.
ಬೇರೆ ಬೇರೆ ಬೆಂಚ್ ಎಲ್ಲ ಇದೆ, ನಾಳೆ.
ಸರಿ ಸರಿ. ಆಗಲ್ಲ ಸರ್ ರೀಚ್
ಗೊತ್ತಾಗಲ್ಲ ಸರ್, ಹೇಳಕ್ಕಾಗಲ್ಲ, ಬೆಂಚ್ ಕೊಲಾಪ್ಸ್ ಆದ್ರೆ ಗೊತ್ತು.
Court officer? Court officer?
ಕನ್ನಡದಲ್ಲಿ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
Court officer? Court officer? Court officer? Court officer?
Union number 66 ಆರ್ಡರ್ಸ್ ಇದೆ ಅದರಲ್ಲಿ ಕೋರ್ಟ್ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರು ಅದು ಅನ್ಕ್ಲೇಮ್ಡ್ ಅಂತ ವಾಪಸ್ ಬಂದ್ಬಿಟ್ಟಿದೆ ಅದಕ್ಕೆ ಒಂದು ಮೆಮೊ ಹಾಕ್ತಾ ಇದ್ದೀನಿ ಆಮೇಲೆ ಒಂದು ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಒಂದು ನೋಟಿಸ್ ಅಲ್ಲ ರೆಡಿ ಮಾಡಿ ಎಲ್ಲ ಬಂದಿದ್ದೀನಿ ನಾನು
ಸರಿ 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 ಥ್ಯಾಂಕ್ ಯು ಫಾಲೋ ಅಪ್ ಮಾಡ್ತೀನಿ ಹಾಂ
ಎಲ್ಲ ನೋಡಕ್ಕೆ CCTV ಕ್ಯಾಮೆರಾ ಔಟ್
which at present road is in the Ibrahim ಬಂದಿದೆ ನಿಮ್ ಕಾರಲ್ಲಿ ಬರೋದಾ? Does he know where your car is? So go from there into what? Officing from the Dispossession. ಅಲ್ಲದೆ ಅಕೌಂಟ್ ಸರೆಂಡರ್ ಮಾಡೋದು ಒಂದು ಜಾಗ ಇದೆ ಸರ್.
Hello, court officer. Hello, court officer. Hello. Hello. Sir, court officer, sir.
ಹೇಳಿ.
Sir, audible?
Audible.
Okay, sir.
ಹರಡಂತಿ. ಫಸ್ಟ್ ಸೆಂಟೆನ್ಸ್ ಹರಡಂತಿ.
ಸಬ್ಮಿಟ್ ಮಾಡಿ ಸಾಹೇಬ್ರು ಏನಾದ್ರು ಅಲ್ಲೇ ಹಾಕ್ತೀನಿ ಅಂದ್ರೆ ಹೋಗಿ. ನನ್ನ ಪ್ರಕಾರ ಇಲ್ಲ. ಇಲ್ಲ ಸರ್, ಈಗ ಬೇರೆ 230 230 ಇದೆ ಬೇರೆ ಬೇರೆ. ನೋಡೋಣ 230 ಮುಗಿಲಿ, ಆಮೇಲೆ ಸಾಹೇಬ್ರು ಹೇಳ್ತಾ ಇದೀನಲ್ಲಪ್ಪ. 230 ಮ್ಯಾಟ್ರ್ಗಳಿದ್ದಾವೆ, ಅದೆಲ್ಲ ಆದ್ಮೇಲೆ ಕೇಳ್ಬೇಕು. ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೋ ಗೊತ್ತಿಲ್ಲ.
Disposal on it also.
ತೆಗಿಯೋಣ ಬಿಡ್ರಿ, ಇನ್ನ ಟೈಮ್ ಐತಿ. ತೆಗಿಯೋಣ ಬಿಡಿ, ಇನ್ನ ಟೈಮ್. ಆ ಮೆಮೊ ಹಾಕಿದಾರ. ಶ್ರೀಧರ್ ಒಂದು ಕೊಯ್ರಿ ನೋಡಿ, ಶ್ರೀಧರ್ ಒಂದು ಕೊಯ್ರಿ. ಕೊಯ್ರಿ 38230 of 25 ಕನೆಕ್ಟೆಡ್ ಇಲ್ಲ. ಕನೆಕ್ಟೆಡ್ ಬೇಕಷ್ಟೇ. WP 38230 25. ಅದೇ ಮೇನ್ ಆದ್ರೆ ಕನೆಕ್ಟೆಡ್ ನಂಬರ್ ಹೇಳಿ, ಅಥವಾ ಕನೆಕ್ಟೆಡ್ ಅದಾದ್ರೆ ಬೇರೆ ನಂಬರ್. ಕನೆಕ್ಟೆಡ್ ಇದೆಯಂತೆ, ಹೌದಾ? ಕನೆಕ್ಟೆಡ್ 32974. ನಾಳೆ ಇದೆ ಅಲ್ಲ?
ನಾಳೆ ಇದೆ. ನಾಳೆ ಇದೆ ಅಂತ ನಾವು ಯಾರು ಹೌದಾ ನಾಳೆ ಇದೆ ಅಂತ ದೊಡ್ಡ ಗಲಾಟೆ
ಓಟ್ ಹಾಕಿದ್ರೆ
ಹೌದಾ ಸರ್
ಹಿಂದೆ ಬರ್ತಾ ಇದೆ.
ಇಲ್ಲ ಇಲ್ಲ ಸರ್ ಅದು ಡಿವಿಷನ್ ಬೆಂಚ್ ಇದೆ ಗುಲ್ಬರ್ಗಾದಲ್ಲಿ.
ನಮ್ದು ಓಟ್ ಹಾಕ್ಬೇಕಪ್ಪ.
ಆಯ್ತು ಸರ್ ಆಯ್ತು.
ಇಲ್ಲಿ ಮಾತಿನ ಮೇಲೆ ಎಲ್ಲ ನಂಬಿಕೆ ಇದೆ. ನಾನು ಅದೇ ಮಾಡ್ಬೇಕಾಯ್ತು.
ಸರ್ಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ.
ಸರ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀನಿ.
ಓಕೆ ಸರ್ ಓಕೆ.
ಇವತ್ತೇ ಅನ್ಬೋದು. Kalburgi bench matter, pronouncement of judgment, serial number 1, Sridhar Prabhu for appellant, VK Nayak.
Fair for the appellants, my lords.
Yes. The appeal filed by the petitioner appellant is hereby dismissed. Consequently, the judgment and decree dated 25/11/2024 of the learned principal judge family court Kalburgi in MC 301/2026 dismissing the petition filed by the petitioner shall stand confirmed. Yes, thank you.
Yes,
Thank
yes,
you,
brother.
Please, my lord.
Principal bench matter, pronouncement of orders, serial number 126, Shamir Sharma for petitioner, Kutika Raghavan.
Writ petition is allowed. Impugn intimation dated 25/4/2025 wide annexure A is quashed.
Okay.
On the idea. Now put it. Yes.
This 230 matter.
What is this, Mr.?
Well, what happened was, it appears it is a parted matter by His Lordship Justice Krishna Kumar. I don't know why the office did not notice all these things.
Yes. Learned counsel for the party submits that matter has been heard by so and so.
Website al ತೋರಿಸುತ್ತೆ parted ಅಂತ ಹೇಳಿ.
Yes. Matter was heard. Matter was parted before so and so. Let's post this matter before so and so. Next date of hearing. When do you want?
Monday ನಾಳೆ ಮಾಡ್ಬೋದಾ?
ನಾಳೆ ಒಂದು ದಿನ
Madam, ನಿಮ್ಮಿಬ್ಬರಿಗೆ ಕನ್ವೀನಿಯಂಟ್ ಯಾವತ್ತಿದೆ?
Friday my lord at 2:30.
Friday.
No, there is an urgency. You have there is a stay order against me. Friday at 2:30 my lord. Same 2:30.
Yes.
Break.
Continue. Yes.
Serial number 43.
There is an interim order maybe.
Yes, interim order granted, extended till next date of hearing.
Serial number 43, Ravi HK for petitioner.
Yes, I make one submission, but I am advising him to challenge the earlier order also.
Yes.
And this matter may be taken 3-4 days after that.
Yes, of the request
Along
is
with
this
that,
matter next week.
In the meanwhile, let them not proceed because today it is set down for arguments. Otherwise, I will lose the opportunity of examining the witnesses.
No, see, you go and request there. I can't pass any order. Otherwise, it is entertaining that order, Mr. If it is
At least,
only, you have to verify and make a submission that you request before the trial court that matter is pending there. We can't pass. If it is passed an order, I'm entertaining that, granting an interim order. Next week, verify what we best we can do. Yes, this matter next
let
week.
them not say, hear the arguments are posted for this one.
You go and
So
request.
we will make a request, madam.
No, but if I pass an order, nothing but entertaining this petition.
Let my learned friend also let cooperate.
No, that is for you both side. Yes. Yes. Is this matter next week? Yes.
Serial number 44, P. Sheshagiri Rao for petitioner. Ashwini Patil.
Respondent.
Yes.
Petitioner. Minutes, the defendant is before this honorable court. It's a commercial suit, not.
Yes.
Now the order impugned, not the trial court notes at page 18 for a moment. Page 18.
84.
18.
Suit for?
It's a suit for money suit.
Yes.
Defendant is before this court. The order Binod says.
Yes.
I had been placed ex parte. Now Binod, I file an application thereafter. Binod, I am permitted to come on record with an observation that page 18, para 10 for a moment.
Yes.
Does my lordships get this date 22/4/2025 in para 10 Minot's fifth line?
Yes.
The court Minot's holds that it appears it is also pertinent here to mention that as the defendants have not claimed the summons to RPAD with a order dated 22/4, defendants lose their right to file written statement. Now pause here for a moment. Pause here for a moment. I shall take my lordships to the order sheet here, which is annexed along with it. Page 46 for a moment.
Yes.
Minot's plaint ಅಲ್ಲಿ ಸಮನ್ಸ್ ಕಳಿಸ್ತಾರೆ 22/4/2025. Now does my lordship see that? May I take my lordship to the endorsement which is there? Defendant 2 Vilasa Biga 124 RPAD not claimed.
Which year? Which date? Which date?
22/4.
22/4.
Yes. And
Prativadi Villasa Biga.
Yes, please. Suit summons put up with file D1 D3 Vilasa Biga Vapas. Does your lordship get it?
Yes.
So there are two notings 4 and 5 and 4 and 3 anta bardiyare. And your lordship will see D1 D3 D4 Vilasa Biga Vapas. Does my lordship get it there minutes? Then minutes adu ಕೆಳಗಡೆ ಅದು ಮೇಲ್ಗಡೆದಲ್ಲೂ D2 ದು ಪ್ರತಿವಾದಿಯ ವಿಳಾಸ ಬೀಗ ಮನೆ ಬೀಗ ಹಾಕಿತ್ತು. Minutes again the matter is posted for 13/6 for issuance of suit summons to D1 to D4 through court process RPAD email. Next date 13/6 minutes. PF paid issue suit summons D1 to D4.
Yes.
And also through counsel appearing on defendants in criminal appeal bearing number so and so. There appears to be some other criminal appeal minutes where parties are in litigation, so they wanted to serve the counsel. Next date minutes 15/7. Criminal appeal ಅಲ್ಲಿ advocate ಇಸ್ಕೊಳ್ಳಲ್ಲ ಅಂತ affidavit ಹಾಕ್ತಾರೆ. ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡಕ್ ಹೋದ್ರು ಇಲ್ವೋ ಗೊತ್ತಿಲ್ಲ, ಯಾರು ಕೊಡಕ್ ಹೋದ್ರು. Then minute 18/8. Minutes this is substituted service by way of affixture. Now kindly see minutes. After this, next page 18/9/2025. Your lordship will see I am placed ex parte for the first time. Does my lordship get it?
No, what has happened to that affix?
They say that
Summons issued to the defendant 1 to 4 to the class no address written unserved with that endorsement not claimed. appears that counsel appearing for the defendant. See, there is the records.
Yes,
Someone's issued to that defendant 1 to 4 to that last known address written unserved with an endorsement not claimed.
ನಾಟ್ ಕ್ಲೇಮ್ ಮನೆ ಬೀಗ ಅಂತ ಹಾಕಿದ ನಮೀನ ನಾನು ಹಿಂದೆ
No, ಆಮೇಲೆ ಮತ್ತೆ ನೋಟಿಸ್ ಹೋಗಿದೆ.
ಅಲ್ಲ ಅದು ತಾವು 46ನೇ ಪುಟದಲ್ಲಿ ನೋಡಿದ್ರೆ ಗೊತ್ತಾಗತ್ತೆ ಯಾಕೆ ಅನ್ಕ್ಲೇಮ್ಡ್ ಆಯ್ತು ಅಂತ. ಎರಡು ಕಳಿಸ್ತಾರೆ, ಒಂದು RPID, ಇನ್ನೊಂದು ಸೂಟ್ ಸಮನ್ಸ್ ಟು ದಿ ಪ್ರೋಸೆಸ್ ಆಫ್ ದಿ ಕೋರ್ಟ್ ಬೇಲಿಫ್. ಕೋರ್ಟ್ ಬೇಲಿಫ್ puts up a right report saying that ಮನೆ ಬೀಗ ಹಾಕಿದೆ. That is why it is unclaimed. Of course, a postman will not write so much minutes. Your lordship.
No. Law is that.
Yes.
If it is postman wrongly written, you take an action in accordance with law. Now, Supreme Court said, if it is
unclaimed,
it's served endorsement with not claimed.
Not claimed.
Not claimed means you have refused to take, therefore it is held sufficient.
Two separate
Kindly see, if that were to be the case, when am I placed ex parte for a moment?
Yes.
The records would speak for itself.
Yes.
48 for a moment.
Yes.
Does my lordship get the order sheet on 18/9?
Yes.
Hence, D1 to D4 placed ex parte. Because Minots affixtures were put near the house, and that is when Minots have been placed ex parte.
Not affixture. No, is it, there is an endorsement to show that you have refused to take the notice?
No.
That is what that endorsement says.
No, kindly see. Endorsement to 46ನೇ ಪುಟದಲ್ಲಿ ಇನ್ನೊಮ್ಮೆ ನೋಡ್ತೀರಾ ಸರ್?
You will secure the records and see that.
ಆಗ್ಬೋದು.
Have you filed that I have not refused, this endorsement is wrong? Have you stated in the
No, the endorsement is perfectly right. The endorsement is perfectly right.
What is that endorsement?
46 ನಲ್ಲಿ 22/4/25ರಲ್ಲಿ
No, I am asking that in 47, court has observed that
yes,
written unserved with an endorsement not claimed. Have you made a statement? This is wrong. This is not happened with that affidavit. I will secure the record. If it is true, then we will dismiss.
Kindly see. Kindly see.
Yes.
In fact, kindly see, my lords. ಅಲ್ಲೇ ಇನ್ನೊಂದು ಕೆಳಗಡೆ ಸೀಲ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ 13/6ರಲ್ಲಿ. ಇನ್ನೊಮ್ಮೆ ನೋಡ್ಬೋದಾ ಸ್ವಾಮಿ? 13/6ರಲ್ಲಿ ಆಫೀಸ್ ನೋಟ್ ಇದೆ ಎಡಗಡೆಗೆ. D1 to D4 ವಿಳಾಸ ಬೀಗ.
ಅವತ್ತಾಯ್ತ್ರಿ.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಅದನ್ನೇ
ಮತ್ತೆ ನೋಟಿಸ್ ಹೋಗಿದೆ 8ಕ್ಕೆ.
ಇಲ್ಲ ಇದೇ ನೋಟಿಸ್ನೇ ಅಲ್ಲಿ ಹಾಕಿರೋದು.
Mr. Counsel,
Allah
has made this order.
Correct.
You make an affidavit. This is wrong.
Yes, I'll file an affidavit. Your lordship may have it tomorrow.
Yes, file it. Yes.
Not may kindly come to
tomorrow.
before that.
Now, the point is not that.
Page number 33 minutes.
The ex parte order has been recalled.
Then why you are arguing and showing this, Mr.
What I wanted to point out now, my lord, the court says, look, I am taking your date of ex parte to 22/4, and hence, my lord, this ex parte have been placed on, if your lordship 18/9 for a moment.
Yes.
Page 48 for a moment, if your lordship sees, I have been placed ex parte only on 18/9.
Yes.
Should not, from the date of appearance, I am not entitled to file my written statement within the outer limit of 120 days. Now, what the trial court does not say, it says that you may come on record, but your right to file your defense is expired. This is the order passed by the learned trial judge. Annexure A, not for one moment.
Yes.
This is the order which starts at 16. And may I take my lordship's notes to page 17 for a moment.
Yes.
Thereafter to be on para 6 plots.
Yes.
Thereafter to be on a safer side, and as a matter of abundant caution, the plaintiff has filed application of 5 Rule 20 seeking summons by way of affixture against the defendant on 18/8/2025. Said application came to be allowed and summons were issued through substituted. Now your lordship got it.
Yes.
On being satisfied that the summons were duly served by way of affixture, the defendants were placed ex parte on 18/9. Thereafter, immediately the next date on 16/10, the defendant number 1 to 4 have filed their present application seeking setting aside of the order, ex parte order.
Yes.
Then, my lords, the chronological events would clearly manifest that the defendant.
No, it's all right. What is the law on that point? If it is ex parte is set aside,
yes,
whether time will be extended.
5 Rule 2. 5 Rule. If your lordship could just take over to order 5 for a moment. Now, my lords, what 5 Rule 2 says is, when is from the date of service, from the date of service of these summons.
Yes.
And what is the mandate of 5 Rule 2? This is what is.
Yes.
Every summon shall be accompanied by a copy of the plaint. When the copy of the plaint is served on the defendant, that is when, my lords, the outer limit would start. It is not from the date when I appear, even in the commercial court.
Yes.
From the date of service, because not the law mandates that the moment the plaint is supplied by way of a summon to you,
Yes.
you are in knowledge of the suit claim, and from that date, the right to file your defense would emerge
Yes.
and
Now,
culminate.
when the
within-
summons is served,
Not summons is not served. Affixture, substituted service.
no, that you have refused to take the summons.
Refusal ilve illa. ವಾಪಸ್ ಹೋಗಿದೆ ಅದು ಆ summons.
No, that there is an order sheet shows that, Mr.
ಇಲ್ಲ ಅದನ್ನ ಬರ್ದಿಲ್ಲ. Refusal ಅನ್ನೋ ಪದ ಇಲ್ಲ. ಮನೆ ಬೀಗ ಆಗಿದೆ.
Not claimed under entry.
Not claimed is unavailability, my lords. If a man is not there in that residence.
You see that recent Supreme Court judgment.
Yes, my lord.
Not claimed is also and not refused.
It's not claimed, cannot be
Yes,
interpreted.
yes, you see that judgment.
So I have it here.
Please, it cannot be deemed to be refused.
You ask Supreme Court, Mister.
No, that's
What
all.
is this?
That's all. That's
It
all.
cannot be that. Yes.
My lords,
Now, my lords.
the address, my lords, is the same. My lords, may kindly come to page
Now,
number
my lords,
33.
That the point here, my lords, is only to this. Now, whether I should be, my lords, should my right of defense,
Yes.
should my right of defense
It
be
written as an unclaimed is not a proper service or incomplete service. In opinion of this court, it is not a proper and correct. The word refusal can be interpreted in synonymous to that word unclaimed. This is what
not
should-
claimed and unclaimed?
Yes.
Not claimed, unclaimed. It may not. In stricto sense of words, what I am trying to point out is,
Yes.
I am not here to seek the setting aside of the ex parte order. That has been granted. That is not under challenge. Now, when does the right to file a defense emerge?
Yes.
Or it is available? Upon service of summons under order 5 rule 2 or supply of the plaint.
Yes.
Let us say, for example, I come at a point of time when the matter is almost at the stage where plaintiff has completed evidence. I come to know.
No,
Then-
see,
Yes,
in that commercial
yes,
suit is concerned.
yes. 120
That
days.
act is concerned.
Yes.
There is a specific time limit has been given. Once you have knowledge that there is a case, it's enough. Limitation is
That's,
start.
that's right, Minots. Now, when is the, now kindly see.
You
what
may,
does-
if that would be the case, everybody will say that I will not take notice because summons is not served, because I can take our own time.
No,
That
no,
is
not
not the
that,
law. Yes.
Not that.
My lords, may kindly come to page 33 for a moment, my lords. Their own application for recall has the same address, my lords, on which the summons has been effected. My lords, it's gone thrice.
Yes.
The RPD has gone twice. It has not been claimed. I tried to serve, my lords, their counsel who represents the criminal appeal. My lords, the checkpoints case has been where they have been convicted.
Yes.
My lords, they don't accept that summons.
Suit for?
My lords, this is the suit for recovery of money.
Yes.
My lords, the same. My lords, may kindly compare the address at page number 33, the affidavit.
Might your lordships come down to this order 8 minutes, where it has been amended for the purpose.
What is that dispute?
Money recovery.
No, that, what is
This
that
is a lease,
transaction?
my lords, it's a lease deed where, my
It
lords,
is,
they were a
it's a
tenant.
landlord-tenant dispute.
Yes,
And he says there are arrears.
yes.
That is his claim.
No, these are all in Bangalore.
This
Please.
is all in Bangalore.
Yes.
This is all in Bangalore.
Yes, yes.
And kindly see, Manoj, there are other litigations pending.
No,
The,
that we,
the conduct of the
See-
plaintiff, I am just explaining. There is an appeal pending, Manoj.
that is not the conduct of you. No, I think court should not have been set aside that ex parte order.
I'll just point, Manoj, illenagide.
Thing is that
Yes, please.
you show me any judgment
Yes.
that even after that expiry of the date, court can relax and grant in it.
Your lordship may pass it over. We'll furnish it. We'll pass it.
Yes.
Let it be passed.
My lords, I have a
Because,
judgment to the
my lords,
contrary,
the
my lords,
date
of the
is
Supreme
fixed.
Court.
Yes.
Which
Not
says, my lords,
120
in
days
Bangalore-
from the date of appearance is what the Supreme Court has said.
Yes,
120 days from the date of appearance.
yes,
And if I am in, my appearance is to be taken on record.
yes.
This order of the trial court, it will lead to oppression.
Commercial Court Act.
my lords, my learned friend cannot, my lords, take three separate stances. My lords, either it is the date on which it is unclaimed, or my lords, when the affixture is effected, or my lords, when they appear. My lords, it cannot be that, my lords,
From
they
the
watch
date
what
of
happens with the
affixture, my lords,
matter.
I am in
That
time.
provision?
My lords, order 8, rule 1, my lords, as amended.
Order 8 rule 1, that proviso, my lords, may I read that for a moment, my lords?
My lords, what it says, order 8, rule 1, my lords, the defendant shall, within 30 days from the date of service of summons on him,
Yes,
present the written statement, then my lords, my lords, 27
yes.
of the General Process Act.
yes, Paso, yes.
Please.
No, where did you read that? Provided that where the defendant fails to file the
Yes,
written statement.
pass over, Mr. Pass over. Call the
Please,
witness. Yes,
Cell number 45, T. Sheshagiri Rao.
yes,
Minutes. It's a 6 rule 17 minutes where a suit was filed for the relief of declaration.
yes,
And this is based on a joint development agreement, my lords, which was not registered.
Yes.
My lords, we sought for, my lords, a relief that I would want to have that joint development agreement registered. And that is the substratum of the
For
amendment.
application for order 6 rule 17.
My lords, your lordship want to see the application. Lords, does my lordships get the page 113? Lords?
No, you have filed an application for amendment.
Yes, plaintiff.
Yes.
Now that's the crux of the issue. 113, your lordship will find the
Stay of further proceedings in OS number 6231 of 2020, pending in the file of 12th additional city civil and section judge, Bangalore, till next date of it. Yes.
Till number 46, Ravi Shankar, yes.
Okay, for petitioner.
Yes.
I was the plaintiff before the court. I
Yes.
filed a suit for ejectment.
Yes.
Suit was decreed and I took the possession.
Yes.
In the decree, there was a direction for the defendant. He had paid an advance of 10 lakhs. And there was in the decree, there was a direction that he is entitled to recover that amount. Now, in the meantime, he filed an execution. I filed an application along with the statement of objection. Now, I kindly turn to
Now, where is the degree?
decree annexure A, my lord. Page number 8. I was the plaintiff, suit for ejectment.
What are
of
the
a
degrees possible? Order degree that plaintiff.
landlord is
landlord
decreed in
hereby-
part, so and so, so and so.
hereby
Then it
directs
is further
with
order,
so
page
and
number 10 only. It is
Further
further
order
order decreed and made clear the plaintiff is entitled for 70,000 per month as a rent from the defendant. The defendants are entitled for a secure deposit of rupees 10 lakh.
10 lakhs.
To enforce this 10 lakhs or your execution. Now, in the meantime, I took the possession of. Now, your Honor kindly turn to page number 11 and 12. There is schedule ಅಲ್ಲಿ ಏನೇನು what was given ಅಂತ ಅದಲ್ಲ lease agreement ಅಲ್ಲಿ ಇತ್ತು ಅದೆಲ್ಲ incorporate ಮಾಡಿದೆ.
ಹೌದು.
Then you Honor kindly turn to the objection, statement of objection I filed. Page number 20.
Yes.
ಅದರಲ್ಲಿ ನಾನು ಕೆಲವು ಕ್ಲೈಮ್ ಎಲ್ಲ ಹಾಕಿದ್ದೀನಿ. ಅರಿಯರ್ಸ್ ಆಫ್ ರೆಂಟ್ ಇತ್ತು ಅಲ್ಲ, ಅರಿಯರ್ಸ್ ಆಫ್ ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ಬಿಲ್ಲು, ವಾಟರ್ ಚಾರ್ಜಸ್ಸು, ಆಮೇಲೆ ಸರ್ಟನ್ ಐಟಮ್ಸ್ ವಾಸ್ ನಾಟ್ ಫೌಂಡ್, ಅದೆಲ್ಲ ಟೇಬಲ್ ಹಾಕಿ ಐ ಫೈಲ್ಡ್ ಅಬ್ಜೆಕ್ಷನ್. ಸಿನ್ಸ್ ಅಬ್ಜೆಕ್ಷನ್ ವಾಸ್ ನಾಟ್ ಫೈಲ್ಡ್ ಅನ್ ಆಪ್.
You ಡಿಗ್ರಿಲಿ ನಿಮಗೆ ಪೊಸಿಷನ್
ಹೌದು,
ಮತ್ತೆ ಯು ಆರ್ ಎಂಟೈಟಲ್ ಫಾರ್
ಅಷ್ಟೇ ಪೊಸಿಷನ್
70,000.
70,000 ಅದ್ರಲ್ಲಿ ಹೇಳಿದೆ.
ರೆಂಟ್.
ಹೌದೌದು, ನಾನು ಅದಕ್ಕೆ ಅಪೀಲ್ ಹಾಕಿದ್ದೀನಿ. ಕಾಸ್ಟ್ ಕೊಟ್ಟಿಲ್ಲ. ಕಾಸ್ಟ್ ವಾಸ್
there is no degree against that.
ನನಗೆ ಹೇಳಿಲ್ಲ. ನಾನು ಐ ಆಮ್ ನಾಟ್ ಎನ್ಫೋರ್ಸಿಂಗ್. ಐ ಆಮ್ ಆಲ್ರೆಡಿ ಐ ಟುಕ್ ದಿ ಪೊಸಿಷನ್.
Now he is enforcing for 10 lakhs.
10 lakhs ಅಷ್ಟೇ.
Now that you have to deposit amount of 10 lakhs has to be returned. That's all.
ಅಷ್ಟೇ. ನಾನು ಐ ಫೈಲ್ಡ್ an objection under section 47. Last may kindly see the 47. Section 47. Objection not filed ಅಂತ ಆಗಿತ್ತು, ಅದಕ್ಕೋಸ್ಕರ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದೆ. Along with an application I filed objection. Application is rejected. Section 47. CPC. All questions which are arising between the parties to the suit in which decree was passed or the representative relating to the execution, discharge or satisfaction of the decree shall be determined by the court executing the decree and not by a sub. So it has to be ನಾನು ಡಿಸ್ಚಾರ್ಜ್ ಆಗಿದ್ದೆ ಅಂತ ಬೇಕಾ 10 lakh ಇದೆಯಲ್ಲ.
ಆಯ್ತು, ಏನ್ ಆರ್ಡರ್ ಮಾಡಿದಾರೆ ಈಗ?
ಅವರ ಅಪ್ಲಿಕೇಶನ್ is rejected now, seeking permission ಅಂತ.
Where is that order?
Page number 31, my lord.
ಏನು, what is the ground for rejection?
Ground there is no provision for filing objection to execution ಅಂತ. Para 5, you last may kindly para. On hearing of the both side, I have bestowed my attention to the order sheet so and so, so and so. The case was adjourned from 36 to 25 on 1725 and JDR remained absent. There was no representative objection to main petition was taken. Admittedly, there is no mandatory provision.
ಆಯ್ತು, ಅಷ್ಟು ದಿನ ಏನ್ ಮಾಡ್ತಿದ್ರಿ? 23/4/25 ಅಬ್ಜೆಕ್ಷನ್
ವೆಕೇಶನ್ ಇತ್ತು, ಬಿಫೋರ್ ವೆಕೇಶನ್ ಇತ್ತು. ನಾವು ಅದಕ್ಕೆ ಟೇಬಲ್ ಹಾಕಿದ್ದೀನಿ. ಯಾಕೆ ಯಾವ ಡ್ಯಾಮೇಜ್ ಆಗಿತ್ತು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅದಕ್ಕೋಸ್ಕರ.
ಕೇಸ್ ವಾಸ್ ಅಡ್ಜರ್ನ್ಡ್ ಆನ್ 13/6/2025.
13/6 ಆಗಿಂದ 17 ಹೋಯ್ತು. 17 ಗೆ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ 17 ಆದ್ಮೇಲೆ ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಹಾಕಿದ್ದೀನಿ. ನೆಕ್ಸ್ಟ್ ಡೇ 18 ಗೆ ಹಾಕಿದ್ದೀನಿ. 17 ಇಂದ ಜನ ಆಗಿ 18 ಹೋಯ್ತು. ಅದು 18 ಗೆ ನಾನು ಹಾಕಿದ್ದೆ. ನೆಕ್ಸ್ಟ್ ಸಿ ಮೈ ಲಾರ್ಡ್, ಪೇಜ್ ನಂಬರ್ 17. ಇಟ್ ವಾಸ್ ಫೈಲ್ಡ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ 18 ಗೆ ಹಾಕಿದ್ದೀನಿ ಇಮಿಡಿಯೇಟ್ ಆಗಿ.
ಮತ್ತೇನ್ ಹೇಳಿದಾರೆ?
Now the application is dismissed.
Reason for JDA is that council instruction to secure the certain documents. First regarding the actual document which were intended to be sought to dismiss. Yes. How? Now that according to you, how much amount you test be deducted for 10
ಅಲ್ಲ
lakhs?
17 ನನ್ನ ಪ್ರಕಾರ 17 lakhs ಅಂದ್ರೆ ಅವರೇ 7 lakhs ಕೊಡ್ಬೇಕು ನನಗೆ. ಇವರೊಮ್ಮೆ ಕೈಲಿ ಟೇಬಲ್ ಹಾಕಿದ್ದೀನಿ.
Stay of further proceedings in commercial execution number 463 of 2025 pending in the file of 89 additional city civil and session judge Bangalore. In addition, petitioner is also directed to take out hand summons to that respondent number 1 and 2 this matter on 15th April. Yes.
For orders, serial number 47, S. Kalyan Basavaraj for petitioner, Manjunatheshwarache.
Appearing for petitioners, your lordships have taken and I've served, taken steps for service of summons to R2, but however, it's not being served. If I could point out in the RFA as well, at page
Steps
number
to be
8,
taken in service of notice to R2.
I have taken the steps, Your
Now
Honor.
you paper publication, take paper publication now.
Definitely.
My lords, in the RFA, my lords, he has not appeared held sufficient, my lord, not represented in the RFA also, my lord.
No, that is true, but now that order is in his favor without service. No,
Yes,
RFA order is in his favor, is it
They
not?
went to Supreme Court SLP was dismissed. Again, they have filed a suit on same subject matter, filed a suit.
No, see, that is merit is different. Mr.
Yes,
Venkatesh, now
Yes,
respondent number 2, he is a beneficiary under that RFA, is it not?
No, my lords, I am the beneficiary. I am the purchaser of the property.
Who is
I am,
who is R, who is
he is
R2?
told he was a agent of the respondent number 1. That's all. Property
So
sold
he is
to
not
us.
necessary. He is not necessary party.
Not required, my lords. They were knowing
Is it?
it.
Then they have to say whether he is required necessary party or not, madam.
I'll take paper publications, Your Honor. One date may be given.
My
If
lords,
not,
1 year they have filed this petition on 11/3/2024, my lords. This review petition. We are in 2026. 2 years
Is there
over. Even before the
is there any
registrar
stay?
review objected.
No, there is no stay here.
Yes, my lord. By showing this, they are troubling the development activities.
How can that, Mr.? There is
Yes,
no
that
stay.
has been done. One suit has been filed. What has happened? My lord, RFA was dismissed. Went
Yes.
file SLP. SLP was dismissed. Then they
Yes.
filed the OS. Then they filed this RP.
Yes.
For last 2
There is
years.
a last chance.
Yes,
You
my
have to file an application, madam. We'll have
date
it.
will be given, my lords.
please.
Any short date on 10th. By the time you have to file an application. Is this matter on 10th April? Yes.
Grateful.
Serial number 48, A.V. Gangadharappa for petitioner,
2 days time to take steps for respondent number 2.
2 days time is granted.
Interim order may kindly fixed.
Lord, date may be
Order
fixed.
granted. Yes.
And for the respondent number 1, my lord, kindly date may be fixed, my lord.
Yes. Leave this matter on 15th. Yes.
15th of March,
April.
April.
Yes.
serial number 49, Sachin B.S.
15th of April.
Yeah, 15th April. Yes.
49, Sachin B.S. for petitioner,
Petitioner, my lord, someone has filed wakalat for the respondents. I have also given hand summons. Served, my lord. Hand summons is also served. My lord, this is a plaintiff's petition, my lord, it's a suit for partition.
Kodri hand summons servagide. 1 to 3.
Yes, my lord.
He is filed wakalat for whom?
My lord, it's 1 and 2, it's showing in the website as 1 and 2.
Of notice to 1 to 3. Hand summons self service agide. Where is that?
Let's have filed, it's causes also head/s Santa.
Hand summons party serve ಮಾಡಿದಿರಾ?
Please, my lord, sir.
ಮತ್ತೆ ಯಾಕ್ರಿ ತೋರಿಸ್ತಾರೆ?
ಅಂದ್ರೆ ಮುಂಚೆ ನೋಟಿಸ್ ಇಶ್ಯೂ ಆಗಿತ್ತು, they were served and unrepresented. On the last occasion, notice was ordered. Again, we have taken steps. Once already it has returned as served.
No, is the court has permitted you to take out hand summons?
That is also served and acknowledgement is filed, my lord.
Petitioner permitted a hand summons service ಆದ್ಮೇಲೆ ಮತ್ತೆ ಯಾಕ್ರಿ? Who is that Umesh HH as appearing for whom?
My lord, is appearing for respondent number 1 and 2.
1
and 2. In the website it is showing he has filed it for 1 and 2, my lords.
My lords, the case is
Where
this.
is he?
No, my lords. First time
That,
is.
it will make an confusion in that advocates that it is still awaiting for service. Office making all this. Kariri on there. Kariri on there. Register person. Yes, Mr. We'll have it some other day.
Please, my lords.
Today some exception is there.
Please, my lords.
If councils are not there, yes.
A date may be fixed, my lords.
Yes, none appear, leave this matter. On second,
Please, my lords. Interim order may kindly wait.
interim order extended till next date of it.
Grateful.
Serial number 50, SV Bhatt for petitioner,
For the,
Patricia Gonsalves.
for the second respondent, hand summons was ordered on the last occasion.
Hmm.
Earlier, he was served but did not represent himself. He is the person who has filed the application before the trial court. A hand summons is served, acknowledgement is produced. And his name has to be shown in the cause list.
Hmm.
His name is not shown.
No, hand summons is served.
Yes, my lord. Day before yesterday it was served, my lord, 2 days back. I think his name has to be shown in the cause list and then
Yes.
date may be
Filed an hand summons
Short,
copy
maybe.
served acknowledgement in R2 by advocate for the.
R.S. Murali. His name is R.S. Murali.
ಆಯ್ತ್ರಿ ಅವ್ರ ಹೆಸರು ತೋರಿಸ್ಬೇಕಲ್ರಿ hand summons sir. That's about register judicial ಬರುತ್ತೆ. Correct.
My lords, may I make few submissions? My lord, this application that is IA number 19, which was filed before the trial court, is in collusion with all the defendants. I am for the respondent number 1. Respondent number 1 is the plaintiff in the original suit. She has filed a suit for partition against all her brothers. That is, defendants 1 to 4 are her brothers.
Yes.
Now, defendant number 1 and 2 are before this court, challenging the order passed in IA number 19 to amend the written statement so that
What is the suit for, Mr. Bhatt?
partition.
There is a suit for partition filed by the first respondent. Right, against all of us. All of us may not have jointly filed the written statement. On an earlier occasion, the fourth respondent has made an application, IA number 15, to transpose himself as one of the plaintiff.
Yes.
Kindly see that order that has been passed by the court. It is at page number 67, my lord.
67.
67. Adರಲ್ಲಿ it starts the next paragraph. In respect of IA number 15, that is the application earlier filed. From the written statement, it discloses that defendant number 1 to 6 have jointly filed the written statement and taken contention that there was a new partition taken, new partition taken in the family of plaintiff and defendant, and suit properties are not joint family property, and now the matter is posted for further evidence of the defendant. At this stage, defendant number 4 has come up with an IA stating that advocate gave NOC and some papers to him, and then he came to know that the written statement is a bald one and not prepared on the instructions of defendant number 2, got prepared on the instructions of defendant number 2 without stating his defense, even though he is entitled for a share in the suit property as the member of the undivided joint Hindu family. Further, he has contended he has not signed the written statement, and signature found on the written statement has been forged by the defendant number 2 with an intention to swallow all the properties belonging to the undivided Hindu family, joint family.
No, that this application is filed for what?
Now, the present application is filed.
This order which is you read.
Yes, my lord.
It is
It's an application under Order 6, Rule 17 for amendment of the written statement, whereby the written statement jointly filed by all others is sought to be amended.
Yes.
And the honorable court, kindly see the order that your lordship would get the order at page number 74. One line order.
Now that, see, earlier application is allowed. You have been permitted to file a separate written statement.
No.
Now, what is that?
His application has been rejected on the ground that you have already filed the joint written statement along with others. You have now come up with an application saying that it's a forged one. No, it is not forged one. It has compared everything, then passed the order saying that it is on the similar ground. Now, amendment application is not to
You
be
see
made.
that page 69.
Yes,
Order,
madam.
what is
Page
that?
number 69. Page number 69.
Here filed by the plaintiff. under
IA number 15, my lord. IA number 15 filed by the defendant number 4 under R1 Route 10 of CPC to transpose himself as plaintiff number 2 is hereby rejected. His application on the same ground has been rejected earlier. Now he wants to amend the written statement. The fourth defendant makes an application to amend the written statement, and the trial court, my lord, on one adjournment has been granted. Next day, without any reasons, application has been allowed. You will let me kindly see the page number 74. Advocate for the plaintiff files objections to IA number 18. I am the other defendants, my lord. I am appearing for other defendants. We are the affected parties. Advocate for plaintiff submitted no objections to allow the application. Though they filed the objections to IA number 19, no objection. He says no objection. Plaintiff says no objection. That is the first respondent. Advocate for defendant number 2, object, no representative. Objection to IA number 1 is taken as not filed. Heard, IA number 19 is allowed. That's all.
You have filed an objection.
No, I have not filed any objections. I was, there is no representation on my behalf. Noting my absence, the court simply say accepting their statement to the effect that they have no objection. Plaintiff has no objection.
Plaintiff has no objection. You have not filed any objection.
No,
then court is accepted.
I wanted to file an objection, but even otherwise also court ought to have seen as to whether a joint written statement filed by both the parties, all the parties together, could have been amended by one person, taking away different contention. That is not permissible under law. This one court, on an earlier occasion, has said that such a joint written statement cannot be.
Yes, madam.
My lord, my contention is that
she is only a plaintiff. She has no right to say in this
For the
matter. For the
plaintiff,
reason,
you are not defendant number 4.
no, she is
Where
not.
defendant number 4?
That is the reason why hand summons was ordered. I served the hand summons. His name has to be shown. A date may be fixed so that if he appears.
Not contesting, yes.
Cause list.
My lords, I want to bring to the court's notice that all these defendants are brothers who are denying my share as a sister in joint family property, and in collusion with each other, they filed one of the application to delay the proceedings. This is a 2013 matter, and I have filed my objections in that.
When you have filed an hand summons, Mr.
Just 2 days back, I have filed the hand summons. I think he required.
That will allow this petition and permitted him to file an objection and hear and pass an order.
Please, Miller.
Instead of pending.
Yes,
that would.
And my lords, you can, in my
what is-
objections,
Madam,
that the ad interim order
You
of
just
stay.
hear me. You are in a plaintiff.
Yes.
You said no objection. It is that application which is filed by the 4th respondent. See,
Yes.
instead of dragging the matter, I said that it will be allowed. Let him file an objection.
Yes,
Court
madam.
hear and pass an order.
Please,
Say
Miller.
that.
Please, Miller.
Yes.
Within time bound manner, it
The
can
stay
be
should
done.
be vacated, my lords.
What stay?
Ad
Automatically,
interim stay has
it
been.
automatically goes, madam.
And the matter was posted for final arguments. This order, ad interim order, was obtained on 19/9/2024.
see,
They
now-
remained quiet when the matter was posted for argument. After 4 months, they come and file the stay order.
Application for seeking an amendment of that this thing.
Written statement,
Written
joint written
statement.
statement.
Will be heard after giving an uppers to all the parties and pass an order.
Please.
Yes. Where is that service of notice, Mr. Or could realize? Yes, afternoon on 11/3 to show us why the rule is late ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ afternoon 11/3 ಅವ್ರ ಹೆಸರು ಕರೀರಿ yes 4 R4 R2 here
ಇಲ್ಲಿ R2 ಹಾಕ್ತಾರೆ. ಅಲ್ಲಿ ಡಿಪೆಂಡೆಂಟ್ ನಂಬರ್ 4, ಇಲ್ಲಿ RS ಮುರಳಿ R2 ಹಾಕ್ತಾರೆ.
Murali, respondent number 2. Respondent number 2, RS Murali.
yes In this petition, petitioner called in question order dated 25/7/2024 passed by National City Civil and Session Judge Bangalore on IA number 19 in OS number 3674 of 2013, whereby IA filed by the fourth defendant, respondent number 2, respondent number 2 herein.
Who is the fourth defendant?
Fourth defendant in the suit under Order 6, Rule 17. Plaintiff has filed in a suit for partition and separate position. On service of summons, the defendant has filed common written statement. Thereafter, the fourth defendant has filed this application seeking amendment of written statement. The trial court has allowed that application on the ground that plaintiff has no objection and other defendants, the petitioner defendant has not represented. The impugn order dated 25/7/2024 is not a speaking order. The court has not given any reason for that allowing that application filed by defendant number 4. On this short ground, that writ petition has to be allowed. Order dated 25/7/2024 is required to be set aside. Accordingly, writ petition is allowed. Otherly, respondent number 2 served by hand summons, none appear. Trial court is directed to reconsider that application number 19 filed by that defendant number 4 under Order 6, Rule 17 in accordance with law.
After giving the opportunity to
After giving an opportunity to all the parties. Yes.
to file the statement of objections also.
That's all left to you, Mr. Please, you may not file
And
it, you
suit
may
be
not.
disposed of as early as possible without any further.
Next
time.
hearing date itself.
Because
we'll
it's
file it.
already posted for final arguments, my
No,
lord.
that IA has to be decided now.
Yes, but a time limit
As
may be.
expeditiously as possible, dispose of that application by end of April. Yes.
Apply.
ಕೊಡಿ. See, ಇದರಲ್ಲಿ ಬರೀ ಎಕ್ಸಾಂಪಲ್ 2 ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಸರ್ವ್ ಆದ್ಮೇಲೆ ಅಗೇನ್ ಸೇಯಿಂಗ್ ದಟ್ ಅವೈಟಿಂಗ್ ಸರ್ವಿಸ್ ಆಫ್ ನೋಟಿಸ್. ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ. ಈಗ ನಾವು ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಆಗಿದೆ ಅಂತ ಡಿಸ್ಪೋಸ್ ಮಾಡಿದ್ರೆ ಅಡ್ವೊಕೇಟ್ ಮೇ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡಿಂಗ್ ದಟ್ ಟುಡೇ ಇಟ್ಸ್ ಫಾರ್ ಎನ್ ಅಗೇನ್. ಇದರಲ್ಲಿ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಸರ್ವಿಸ್ ಮಾಡಿದ್ದಾರೆ, ಇಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ, ಆದ್ಮೇಲೆ ಪಾರ್ಟಿ ಹೆಸರು ತೋರಿಸ್ಬೇಕು ತಾನೆ, ತೋರಿಸಿ. Who is that you get just issue a memo. This is what happening in all cases. Issue ಮಾಡಿ. This is yes. ಅವೆರಡು ಮ್ಯಾಟ್ರದ್ದು ನಂಬರ್ ಕೊಡಿ 4950.
Cell number 51 disposed of. Cell number 52 Vishwanath R. Hegde.
Yes, filed on a memo seeking leave of this court to withdraw. Dismissed as withdraw.
My lords, I have 13 other identical matters, my lord. I filed a withdrawal memo in all those matters.
Tomorrow.
Serial number 53.
Tomorrow. We'll post it on tomorrow. ನಾಳೆ post.
Please, my lords.
53 withdraw.
All withdrawal ಒಂದು ಅದಕ್ಕೊಂದು ಮೆಮೊ ಇದು ಮಾಡ್ಬಿಟ್ಟು ಬೇರೆ ಲಿಸ್ಟ್ ಮಾಡಿ.
53 withdraw.
53 same order.
54 Jagadish DC for petitioner Mohammad Niaz. 54 Jagadish DC.
Awaiting service of notice.
Number 16.
Yes.
Respondent number 11, my lord.
Others are notice awaited.
Yes.
Await service of notice to respondent number 1 to 10, 12 and 13. Interim order is there.
Yes, my lord. I filed IA, my lord.
IFR?
Vacating stay.
IA is not there.
I filed, my lord.
Interim order granted earlier is extended till next date of hearing. You are appearing for respondent?
11, my lord.
Learned counsel appearing for the respondent submitted that has filed an IA for vacating office to verify and put up. Yes.
55 disposed of, 56 HR Ananta Krishna Murthy.
Non-compliance of office objection, Mr.
Separate WPs have to be filed. Common order is passed. I filed a common WP. All of them are interlinked. One is for,
Court fee is paid.
court fee is paid.
No, that all application you have to pay 100 rupees.
Pay, I have paid the court fee.
Only 100 rupees you have paid.
I'll pay the court fee deficit fine.
ಎಲ್ಲಿದೆ ಎಷ್ಟು
ಕಟ್ಟಿದ್ದಾರೆ.
ಎಷ್ಟು ಕಟ್ಟಿದ್ದಾರೆ ಅಂತ ಕೇಳಿ.
Just 500 rupees is paid now, but note ಇಲ್ಲೇ ಇರ್ಬೋದು ಅಷ್ಟೇ.
Receipt, where is that payment of receipt? Yes, learned counsel for the petitioner submits that. Court fee of rupees 500 is paid, office to verify and proceed further. Yes, what is it?
For the petitioner with National Seeds Corporation,
Yes,
they filed a suit for recovery of the amount.
yes.
In this behalf, a complaint was lodged before the police. They have filed a charge sheet. They were convicted in the trial court.
Yes.
At page 93, your lordship may turn to page 93. I wanted to produce the judgment rendered by this honorable court.
No, that suit for
Suit for recovery of money.
Now,
There
that, what is that
mis-
application you have filed?
To mark these documents, criminal appeal 93.
Where is your application?
Lordship may turn to page.
Where is that order for rejecting that application? Which is that impugn order, Mr.
At page 191. The reasons,
Yes, what are that applications you have filed?
one is for production of documents.
Hmm.
One is reopening, recalling and permitting the plaintiff to examine, mark the documents.
Hmm.
The trial court has said, page 196,
Why you have not produced that?
the document was not available. The judgment was rendered in 24.
Is it a commercial suit?
No, this is not a commercial suit.
Yes. Or issue notice. Stay of further proceedings in OS number 9764 of 2006 pending in the file of 31st Additional City Civil and Section Judge Bangalore till next date of it.
Much of it.
Cell number 57, Jagadish HT for petitioner. 57.
Yes, week's time is granted to comply of subjection.
58, Balagangadhar GS for petitioner. Mahadeva Prasad.
To the respondent number one, please.
Awaiting service of notice to respondent number 1. Office objection ಏನದು ನಿಮ್ದ statement of objection.
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದೀನಿ.
Yes.
ಪೋಸ್ಟಲ್ ಸರ್ವ್ ಮಾಡಿದೀನಿ. ರೀಚ್ ಆಗಿದೆ ಇವರು.
Yes. So received that.
ನಿನ್ನೆ
Yes.
ಸಾಯಂಕಾಲ ಬಂದಿದೆ.
Yes. Awaiting service of notice to R1. Yes.
59, Adinarayanappa.
Interim order may be extended.
Interim order extended till next date.
Milods, I am on record, Milods. Caveat.
Yes. No, that first time it is coming. Notice is already issued.
It is already issued, Milods.
Then there is an interim order is already granted. You have to file application for vacating.
Now, Milods, if Milods can dispose it of, if Milods can hear and dispose it of dispose the matter.
To hear, notice has to serve to all parties.
They have sought for dispensation, Milods.
Not dispensation. Where is that?
Dispensation ಮಾಡಿದೆ 213.
I remain, I am the plaintiff, Milods. ನಾನು ಬರೀ respondent ಆಗಿರ್ತೀನಿ. Defendant number 2 and 3 ಅವರು dispensation ಕೇಳ್ಕೊಂಡಿದ್ದಾರೆ respondent. So I am the only contesting.
Extended. 1 week time.
No, that R1 is necessary party.
ಒಕ್ಕಲದ ಹಾಕಿದೆ ಅವರೇ ಹಾಕಿರೋದು.
I have filed caveat.
You are appearing for R1.
R1.
But awaiting service of notice to R1 ಅಂತಾರಲ್ರಿ.
I have filed my objection.
Wait, mister. Awaiting service and ಇದಾರಲ್ಲ. Yes. So and so is undertaken to appear for respondent number 1. Yes, now that question of awaiting service is not necessary. Others is dispensed. Yes, what do you say, mister?
Next day. 1 week time granted.
Yes. When do you want, mister?
Any date next week, please, my lords.
In the meantime, we file an vacating, otherwise matter will not reach, Mr.
Yes, my lord, I'll do that.
Yes, reach this matter on 1st April. Please, interim order granted earlier is extended till next date of hearing.
Grateful.
59, Adi Narayanappa.
Yes. Challenging the
What is that office objection, Mr.?
office objection, small decree copy, typed copy of the decree.
There are 8 office objections.
In the urgency is this matter.
You complain, tomorrow we will have it. If there is or day after tomorrow.
Day after tomorrow, it is there for acceptance of the
Then you-
Lok Adalat compromise.
Hmm.
Because the
No,
first
you complain
respondent-
office objection. When do you want? Tomorrow. Tomorrow.
Tomorrow.
Yes, reach this matter tomorrow. In the meantime, petitioner is directed to comply office objection.
Cell number 60, Abhimanyu Arjun.
I appear for the respondent number 1 and 2 in this matter.
What is that office objection, Mr.?
My lords, online, I'm not able to find the office objections, my lords. If there's any, I will
My lord,
comply it, my lords.
If I may make a submission, my lord, even otherwise the petition can be disposed of. Emergent notice issue ಮಾಡಿದಾವೆ ಅಂತ ಹೇಳಿ they have come for some protection. I am a landlord.
Interim order ಕೊಟ್ಟಿದ್ದಾರಾ ಇಲ್ಲಿ?
ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದು ಏನಂದ್ರೆ if I'll just point out what has happened and I will concede on terms. ವಾಪಸ್ ಕೆಳಗಿನ ಕೋರ್ಟ್ ಕಳಿಸ್ಬಿಟ್ಟು 30 days disposal ಕೊಡ್ಬೋದು.
Yes, what is that you are challenging?
My lords, we had filed 3 IAs, my lords. They were trying to dispossess us. One
IA
is
suit for?
Suit for injunction, my permanent injunction.
You have filed an petition.
He is a tenant.
The plaintiff in the.
What are the IAs you have filed?
My lord, one is not to dispossess me from the business place. Second is not to cut electricity and water. Third, my lord.
That is not true, my lord. If I may just point out, that is the
Let's go through the IM.
page 124, if your honor may kindly.
In respect of the suit submitted. Yes, this interim order will be continued till the disposal of the application will.
With a direction to dispose it off within the next 30 days. Next date of hearing is on 16th of March.
Yes, we'll say
Allinda
that
30 days.
End of April, they have to dispose of that application.
Please.
Sorry.
But ಏನಂದ್ರೆ they have filed 3 IAs. What I wanted to point out is 3 IAs ಹಾಕಿದ್ದಾರೆ. ಅದರಲ್ಲಿ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ is not he's a tenant, not to evict ಅಂತಾನೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಾರೆ. ಅದೊಂದು ಅದಾದ್ಮೇಲೆ ಇನ್ನೆರಡು and it's an unregistered lease deed. They are claiming 5 years on an unregistered lease deed, unstamped. ಇದೆಲ್ಲ ಆದ್ಮೇಲೆ there is no allegation in the entire.
What are the IAs you have filed?
Page 124, if your honor may kindly see, that is IA number 1.
IA number 1 ಏನದು?
Page number 124.
124.
Please, my lord.
What is that IA?
ಇದರಲ್ಲಿ restrain the defendants, their agents, and any persons claiming to have under them from dispossessing or in any manner evicting the plaintiff from the scheduled property. This IA 1. Then the second IA is at page 135. Illi, it is my property, I am the owner, and they claim saying not to make any alterations or additions or changes to the existing structure standing on the scheduled property. They are only in ground floor. And even otherwise, my only thing is there were 3 IAs filed. ಇಲ್ಲಿ ಎಲ್ಲೂ ಕೂಡ ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ವಾಟರ್ ಅಂತ ಒಂದು ಅವರ್ಮೆಂಟ್ ಇಲ್ಲ. ಇಲ್ಲಿ ಬಂದ್ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಯಾವ್ದೋ ಒಂದು ವಾಟ್ಸ್ಆಪ್ ಮೆಸೇಜ್ ತೋರಿಸ್ಬಿಟ್ಟು ನಮ್ಗೆ ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ಕೊಡ್ತಾ ಇಲ್ಲ, ವಾಟರ್ ಕೊಡ್ತಾ ಇಲ್ಲ ಅಂತ ಹೇಳಿ they have taken an interim order. They had the liberty to file 3 applications. 3 application ಅಲ್ಲೂ ಎಲೆಕ್ಟ್ರಿಸಿಟಿ
ಕಟ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ನಾವು either ways ಮಾಡ್ತಾ ಇಲ್ಲ. My only thing is they have made that ಅಲ್ಲ ಅದಕ್ಕೆ they have made that submission. No, the observations made herein should not come in the way ಅಂತ let there be a finding. ಯಾಕಂದ್ರೆ 3 application ಅಲ್ಲೂ ಹೇಳಿಲ್ದೇ ಇರೋದನ್ನ ಒಂದು ಹೇಳಿಲ್ಲ ಆರ್ಡರ್ ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. They should not use that there before the trial court ಅನ್ನೋದಕ್ಕಷ್ಟೇ.
This writ petition, petitioner seeking direction to the trial court to ಏನಲ್ಲಿ ನೋಟಿಸ್ ಆಗಿತ್ತು ಅಷ್ಟೇನಾ?
Emergent notice ಮೇಲೆ they have come before. We have already appeared there.
Yes. Seeking direction to that trial court to dispose of that application filed by that plaintiff under order 39 rule 1 and 2. Plaintiff has filed suit for
injunction.
Suit for injunction. Along with that plaintiff, he has filed IA 123 under order 39 rule 1 and 2. The trial court has refused to grant ex parte interim order. Therefore, the petitioner is before this court. You are after service you are coming before or waiver?
After service, my lord.
Yes. Now that the defendant respondent has appeared before this court through that counsel. Since application filed by the plaintiff is not disposed of, is pending before the trial court. It is suffice for this court to dispose of this writ petition, directing the trial court to dispose of all three applications, dispose of that application filed by the plaintiff under order 39 rule 1 and 2.
IA 1 to 3 ಅಂತ ಬಂದ್ಬಿಡ್ಲಿ.
IA 1 to 3. Since defendant is already appeared and filed their objection.
No, we will file our objections.
Yes. Defendant is already appeared, directed to dispose of that application on or before end of that April. The interim order granted by this court will continue till that disposal of the application. It is made clear that trial court has to consider that application in accordance with law without influencing any observation made by this court.
Date 30th April ಅಂತ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಆಗ್ಬಿಟ್ಟು.
End of April ಅಂತ ಅಂದ್ರೆ 30.
ಅಲ್ಲ, ಅದು-
ಅದಕ್ಕಿಂತ ಮೇಲೆ ಏಪ್ರಿಲ್ ಬರುತ್ತಾ
ಅಲ್ಲ ಅದಕ್ಕಿಂತ ಮೇಲೆ ಅಂತಲ್ಲ, there is a specific date ಅಂತ.
Yes.
Oblige,
Cell
wait
number
for.
61, Boregowda HK for petitioner, connected matter, Lingaraju Kya.
Yes.
Except for respondent number 1 in the connected matter.
Yes.
I accept notice for respondent number 1 in the main matter as well, my lord.
Yes.
My lord.
Taking notice to R1.
Respondent number 1, notice has been dispensed with in respect of respondent number 2 to 6.
Yes.
Matter is-
Respondent so and so is undertake to appear for respondent number 1 in connected matter. Second matter service agide. Yes, Mr.
Yes, my lords. Notice has been issued. Kindly extend interim orders, my lords.
Let's-
Now
In the
she is
connected
taking
matter.
notice.
I
Yes.
take notice, my lord, for respondent number 1, let them on.
Yes. Yes. When do you want?
My lords, I am ready, my lords. My suit has been stayed before the trial court. My lords, the issue is that the written statement has been rejected because it has been filed after 120 days.
120
What is-
days.
is-
That is that issue. It has to be pending now consideration.
But there's no interim order as far as there's a challenge to the constitutional validity.
Yes.
Is
No
the-
interim order will be granted to validity, but interim order has to be granted on that consequential order.
Consequential, please, my lord, but since it has to be,
But that has to be decided. Therefore, I said Advocate General to, I think all matter has to go before that other bench. Because it should be only under 226.
But
Let us see.
please,
Yes. Leave this matter on 7th April. Yes.
it's under the preliminary hearing.
Same stage. If you
Yeah,
want,
that's-
you file an application for vacating. It will come early. Yes.
My lords, interim, kindly extend interim
Interim
order.
order
my lord.
extended till next date of.
Obliged, my lords.
My lords, can it be on an earlier date, my lord, 7th April? My suit has been stayed, it is on a limited issue.
Can't in all cases, unless it is decided, we can't do anything, madam. Yes.
Please.
Cell number 62 adjourned, cell number 63 Prashant UT. 63 Prashant.
Lords, I appear for petition in this case, my lords, please. Matter
Furnishing a
pertaining
PF,
to
you have not
judgment.
furnished the PF.
My lords, I have already finished, my lords, please.
What is the
In
state?
fact, I have served even on the trial court advocate as well, please. I have placed the acknowledgement for having.
Interim
served.
order is there.
Yes, please, my lords.
Yes, we'll continue. The service is not complete.
Kindly fix some date, my lords, please.
No, you take a hand summons.
No, that's what I have served the hand summons, my lord.
Hand
please.
summons.
On the trial court advocate, please.
No, no.
I have also,
Mr. Trial Court Advocate Service is not hand summons, Mr.
please.
You can serve only.
I'll serve the response as well.
Court notice cannot be served to that advocate who is nowhere concerned.
Please.
He can serve a copy, that's all.
I have served the copy on the
But
trial court
it
advocate.
is option for him whether he has to appear or not. You take hand summons to the party.
Please, my lords.
Yes.
Kindly fix some date, my lords, please. There is some urgency.
They will fix the date. When giving an hand summons, office will fix the date. Yes. Week's time is granted to pay the process. In addition,
No, I have already furnished the process, my lord.
yes, learned counsel for the petitioner submitted that needful has been done. Office to verify and proceed further. In addition, petitioner is also permitted to take out hand summons to the respondent. Interim order granted earlier is extended till next date.
Let it be, my lords, posted immediately after my lord service, please.
ನೀವು ಇವತ್ತು ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ತಗೊಂಡ್ರೆ 10 days ಟೈಮ್ ಕೊಡ್ತಾರ ಡೇಟ್ ಕೊಟ್ಬಿಟ್ಟು ಅಪಿಯರೆನ್ಸ್ ಹಾಕೊಡ್ತಾರೆ ಎಸ್
Cell number 64 Bhargav G.
awaiting service of notice to respondent interim order earlier if any is extended till next date.
Great. 65 adjourned, 66 CN Kamath.
Yes.
The respondent number 1 is the only contesting party. But it is returned as unclaimed. I have producing.
No, respondent number 1 is served now.
Yes, my lord. The unclaimed and the one bit is there. As for regarding respondent 2 to 5 are the who are the tenants, my lord. I am filing a memo to dispense in notice.
Yes, notice to respondent number 2 to 5 is dispensed at the risk of that appellant.
My lord, the suit, my lord, I had filed an application after the decree of the suit, my lord.
Yes.
My lord, now what has happened is, my lord, the suit of the plaintiff was decreed.
Yes.
Confirmed by this honorable court and the Supreme Court, my lord. After that, my lord, I had filed an application under section 153 for the amendment of the boundaries. The trial court has rejected the application saying that the identity of the property is changed.
No, suit is filed by?
The petitioner who are the decree holders, my lord, are the plaintiffs in the trial court. The suit of the plaintiff was decreed.
No, you are that
Plaintiff, my lord.
you are the plaintiff. You are suit
My
for-
suit was decreed, my lord.
Suit for?
Suit for declaration and possession.
It is declared.
Yes, my lord.
Amele?
That degree was challenged before this honorable court by the respondent one, my lord, in the RFA, my lord. RFA was dismissed, against which, my lord, they went before the Supreme Court, my lord. The order of the trial court was confirmed, my lord. My lord, now after the amendment, my lord, I filed an application under section 153.
After that? No, the suit
Then
is-
I filed the execution, my lord. The execution court had issued delivery warrant, but the Amin gave us a report saying that the schedule has been changed. Then I filed an application under section.
Should be filed an amendment in that scheduled in that execution after the degree is confirmed by that. Is it permissible, Mr.?
Yes, my lord.
Where
No.
is that? Show me.
My lord,
that
this
law.
honorable court, my lord, under similar circumstances. has,
How can that, Mr.? If you taken a degree for A property, it is confirmed by the Supreme Court. Then you file an amendment saying
My
that
lord,
I
no,
want
what
B.
has happened? The topography of the schedule has been changed, my lord. I have produced the endorsement saying that the
Only
topography.
that judgment, can it be seek for an amendment of boundary after the degree has been
Yes, my lord,
confirmed?
I have got that judgment. This honorable court, my lord, has held that under section 153, after the decree, my lord, the trial court, the execution court, as well as the trial court can permit the application to be amended, my lord.
No, see, amendment under 151.
153A, my lord, after the decree has happened,
See,
you have
if
to
there is
file an
any
application
clerical
under
error and all,
153.
it can be done. If it is confirmed by that court, can it be filed an amendment under order 6 rule 17 for in that execution?
But I'm not changing the schedule, my lord. The boundaries, my lord, has been, topography has been changed, my lord.
No, see, if you want that, you have to get it corrected in the degree itself. Execution court cannot.
ಅಲ್ಲ
do that.
ಎಕ್ಸಿಕ್ಯೂಷನ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನಾವು
ಹಾ,
ಡೆಲಿವರಿ ವಾರೆಂಟ್ ಇಶ್ಯೂ ಆದ್ಮೇಲೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ OS ಅಲ್ಲಿ ನಾವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತೀವಿ.
You have
ಆ
filed it
ಅಪ್ಲಿಕೇಶನ್ ರಿಜೆಕ್ಟ್ ಆಗೋಗ್ಬಿಟ್ಟಿದೆ.
in the OS, you have filed an
OS
application.
ಅಲ್ಲಿ ಒರಿಜಿನಲ್ ಸೂಟ್ ಅಲ್ಲಿ.
Where is that?
Lord, the application is in OS number. Lord, the order sheet, my lord, is page number 21.
Where is that impugned order?
Page number 21, my lord, 8659 of 2021. Order dated 3/12/25, my lord.
21.
Yes, ma'am. Lord, the trial court gives an observation saying that I am changing the identity of the property and the execution, I cannot amend the application.
Order 6 rule 17 is not maintainable.
Hello, order 6 rule 17 read with 153A, my lord. Now 153A, after the decree, I can only amend it under 153A.
What is that amendment can be permitted? You can change all nature of the suit itself.
No, I am not changing the nature of the suit. I am only changing the boundaries of the scheduled property.
The boundary is nothing but
But
changing.
because the topography, my lord, has been changed. 1958 schedule is not present at the present. my
Yes,
lord.
we'll hear that. Now that service is complete.
Yes, ma'am.
Yes.
Lord, the memo be taken on
Filed
record
in a memo
because-
for dispensation of notice to respondent number 2 to 5.
my lord, now
The risk of
the respondent number 1 notice issued by this honorable court has
Yes,
also
yes.
returned as
respondent
unclaimed.
number 1 is served. Office is directed to show the name of respondent number 1. Post this matter in B group. Yes.
ಅಲ್ಲ ಅದಲ್ಲಿ 16th ಗೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಕೆಳಗಡೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಪೋಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
We'll stay further proceedings.
Proceedings is stayed, my lord.
Yes.
ಅಲ್ಲ
Interim order
date ಕೊಟ್ರೆ-
granted earlier is extended till next date of year. Yes.
ಅಲ್ಲ when memo for having unclaimed ಅಂತ ಬಂದಿದೆ ಅಂತ.
This matter on 16th B group. Yes.
My lord, the memo for unclaimed ಅಂತ ಬಂದಿದೆ.
ಆಯ್ತು, ಅದು ತೋರಿಸಿದ್ದಾರೆ ಆಫೀಸಲ್ಲಿ. It is served ಅಂತ ತೋರಿಸಿದ್ದಾರೆ.
Okay.
Yes.
67, Anup Arnali for petitioner.
Awaiting service of notice to R3. You will take notice. Yes. Shiv Kumar Okay, advocate undertake to appear for R3. Office is directed to show his name. Yes, 21. R2. That's what I said. We will undertake to file R3 also. Vacating ಯಾಕೆ ಹಾಕಿಲ್ಲ?
Not counter claim, my lords, amendment application. Amendment of counter claim, let them file wakalat, I'll argue, my lords.
Yes.
It's a covered matter.
Yes.
We have not filed counter claim. We have filed amendment of counter claim. There's a difference.
Yes. You file an application for vacating also. Next date. Yes. Undertake to appear for R3. Yes. This matter on 15th. Yes.
Interim order may be extended.
Interim order extended till next date. File application, file matter. Don't take that date. File an application, move for vacating, then I will give a date. Yes.
68, Sanjay Sukumaran.
Awaiting service of notice to respondents. Yes. Compliance of office objection. What is this?
I've complied, my lord.
You have already complied?
Yes, my lord. 2 IAs have been arising out of a common order for which I've paid the process memo on 5/3/2026. It has to be.
To 4 office objections.
4 office objections are there, Mr.
My lord, I will comply.
Yes. Awaiting service of notice to respondent. Interim order granted earlier is extended till next date of hearing, subject to condition. Petitioner has to comply office objection. Otherwise, interim order will not continue.
Yes, my lord.
Yes.
69, Nataraj G.
Awaiting service of notice to respondent. Interim order granted earlier is extended. If any, nodi interim order idava ans.
Yes.
ಅವರು ಟೈಪ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ನೋಡ್ತಾರೆ ಹೇಳ್ತಾರೆ.
70, Umesh MN.
Debate to appear for the petition.
Awaiting service of notice to R2 and R3.
Please.
Yes, interim
order to be
extended till next date of hearing.
Great.
Serial number 71, Vasant Kumar, petitioner.
21, my lord, I filed wakalat, it's been allotted to me.
Yes, office objection.
There are some office objections, I'll come, would your lordships have it day after, my lord?
Yes, 2 days time is granted to comply office objection. Yes.
72, Manjunath G. Kandekar.
For the petitioner. ಅದು 39 rule 1 and 2 after hearing ಅಲ್ಲ ಫಸ್ಟ್ ಇಶ್ಯೂನ್ಸ್ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡುತ್ತೆ ಕೋರ್ಟ್ ಆನ್ 27/11 ಹಿಯರಿಂಗ್ ಆಫ್ ದಿ ಡಿಪೆಂಡೆಂಟ್ಸ್ ಇಸ್ ಆಲ್ಸೋ ನೆಸೆಸರಿ ಅಂತ 29th ಅಡ್ವಾನ್ಸಿಂಗ್ ಮಾಡಿಬಿಟ್ಟು ಎಂಟ್ರಿ ಮಾಡ್ರು ಪಾಸ್ ಮಾಡಿ ಇಟ್ ಇಸ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ರೋಡ್
ಆಯ್ತು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಏನಿದೆ
ಅದನ್ನೇ ಅಪೀಲ್ ಮೇಂಟೈನಬಲ್ ಹೇಗೆ ಅಂತ ಇಟ್ ಇಸ್ ನಾಟ್ ಆಫ್ಟರ್ ಹಿಯರಿಂಗ್
appeal maintainable. No, is even ex parte order is also appeal is maintainable. That's what Supreme Court said.
My submission now, so far as it is after advancing the matter, the order.
No, whatever that, if order is passed, even ex parte also, appeal is lies. That's what the Supreme Court. You verify that there is a Supreme Court judgment. Yes.
Or in the meantime,
comply office objection. Yes, week's time is granted to comply office objection.
Serial number 73, Sundararaman MU for petitioner.
My lord, I pay for the petitioner.
Yes. Yes. So
They are the contesting applicants.
Yes. So and so is undertake to appear for respondent number 6 and 7. Memo for acknowledgement is served before the trial court. IA for so and so. Yes.
No, my lord, this is only with respect to certain documents we plaintiff in a suit for ejectment.
Yes.
At the time of evidence,
interim order is there.
My lord, no interim order, my lord.
Yes.
My lord, it's just 2 minutes. I just have.
Yes. He wants you to be an opposing for him. Therefore, he has dragged you. Yes. 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 When do you want?
My lord.
What is the suit for?
Suit for eviction. In this, my lord, we produced essentially 3 sets of. One is we produce a probate because, my lord, after we filed the suit, they said, no, who are you? You are not. My landlord was so and so, but you have succeeded. You are his son. I don't know. So we produce a copy of the probate.
Yes.
For mean profits, we produce 2 lease deeds in the property in Commercial Street.
Yes.
We produce 2 lease deeds. And not to show how the proximity of that premises, we produce a Google map to support that. These, and one more letter, my lord, from the original lessee to say that I am surrendering the tenancy. These are the 6 documents that we have produced. Now the court says, no, my lord, after having, if my lord kindly looks at the application.
Yes.
Kindly see the application.
No, that, when is the next date?
Monday.
Then we will have.
Monday.
I don't know why my learned senior is contesting the matter.
I'm not, I have to continue the suit against others, even if, my lord, but this.
No, there are other,
There are other tenants. But they have not filed objections to my application.
Notice 1 to 5 is dispensed.
Yes.
In fact, number 9, who would be respondent number 9 before the Honorable Court, even they are contesting in the suit.
No, see,
They
if
can
you want to
contest it.
settle, you settle it. If others is not settled, we'll hear for them also.
Yes.
We'll have it on, what is that, next is 16th, huh?
16th.
Yeah, you will have it on 8th. Yes,
My
8th.
lord, on
8th.
16th of this month, my lord.
16th of
16th is Monday. 16th Monday, my lord.
Monday.
Monday.
Yes, we'll have it day after tomorrow.
16th of March.
Huh.
In the trial court. Let the settlement take place.
And then we'll have it 17th. 17th.
18th.
Yes, 18th. Yes. Read this matter on 18th. So and so is undertake to appear for respondent number 6 and 7. Yes.
So 18th, my lord?
18th. Yes.
Serial number 74, A.L. Mariappa.
Yes. What is that office objection, Mr. Murray?
Petitioner.
Office objection is.
Office objection, the office raised the objection, I filed the,
What is the report fee?
2 IA is filed, my lord, by the plaintiff.
Court fee has paid 200.
2 separate court fees paid, my lord.
Yes.
I paid separate court fee,
Yes.
200 rupees court fee paid, my lord.
Yes. What is this?
My respectful submission, my lord. Kindly tell the annexure came, my lord, page number 84, 54.
Suit for?
Suit for declaration and permanent injunction is filed by the plaintiff.
Yes.
After commencement of the evidence, my lord, that too, that is a different side evidence. They filed the one application for impleading order 1 rule 10-2.
Yes.
And also another application out of 6 rule 17 CPC, page number 54, my lord, annexure K, my lord. That is the impugned order, my lord.
Yes.
Kindly peruse the point for consideration. A short order has been passed, even though I cited the Supreme Court judgments, not at all cited. And also, my lord.
No, you have filed an application for
No, no,
impleading.
the plaintiff has filed this suit. I am for the defendant, my lord.
Oh, yes. What is that, your objection for impleading? Who is that impleading applicant?
Impleading upon my brothers, my lord. In our family, they executed some release deed, my lord. Against that, my lord, they want to implead that our brothers, my brothers, and also to that effect, filed the amendment application, my lord. My respectful submission, my lord, kindly peruse the annexure C, my lord, page number.
This is not impleading, this is amendment.
One is amendment, one is for the impleading application.
What is that amendment they have sought?
Amendment sought for that is annexure. Annexure H, my lord, page number 45, my lord.
Yes.
This is the amendment they sought. That is 7A. My permitted to that a more than one page amendment is they sought, and also another prayer is sought, my lord. My respectful submission, my lord, kindly peruse the
Absolute owner of the suit should be.
my lord, annexure C artist.
What is the stage in the suit?
Stage now the further evidence of the plaintiff side, my lord.
Yes, or issue notice, stay of further proceedings in OS number 769 of 2022 pending in the file of
Vascotet.
here civil judge JMFC at Vascotet till next date appeal. Yes.
Office objection may be
accepted. Office objection is
made. 75, Vinay N. 75.
Yes. What is that office objection, Mr.
Office objection is not a common petition is filed in respect of not 3 applications. It's a common order. And other one is with regard to marking of the document. The same suit, additional court fee is paid.
Submission is accepted. Office objection.
Not the,
is forward. Yes.
The question is, but there is no caveat. Therefore, I don't think my learned friend would have any voice. Lord, the suit is filed not.
Yes, yes. What is that urgency, Mr.?
Lord, urgency is not. Documents are marked in evidence. Lord, despite objections, printouts, copies are marked in evidence. And despite the objections being raised, the court says, subject objections, it is marked. And this honorable court has time and again held, my lord, that it cannot be marked like that. Secondly, my lord, applications are filed for production of additional documents. It's a commercial dispute. It's a contempt filed in a commercial dispute. This honorable court, my lord, has also held, and so a commercial dispute is concerned, you cannot produce documents as and when you want. So 3 different applications are filed, one after the other, for production of additional documents. And the trial court simply allows the application.
What is the next date?
13th, my lords.
13th means,
This Friday.
tomorrow. Tomorrow, yes, tomorrow, yes. Leave this matter tomorrow. Yes.
Lord,
I think-
ಕೇವೆ ಟು ಹಾಕಿಲ್ಲ ಅವರು.
See, in my court, if anybody wants to assist, assist. Yes.
Yes. Please.
If there is any urgency, then I will not give an, audience to him because he has no.
Very well.
But there is any time, let him, yes,
Very
tomorrow. Leave this matter tomorrow. In preliminary hearing, yes.
Great.
76, B.M. Siddhappa.
Complied the office objection, my lord. These matters are similar to that of serial number 2021, my lord.
Trial court ranking to be stated in the cast title. D1 at the
Complied,
plaintiff
ma'am.
not made a party to the writ petition to be clarified. Who is not the party?
That is
Defendant number 14.
land acquisition officer. He is not the party, contesting party, or he has not filed
Now,
any.
why you have made him party here if he is not a party before?
Because
ಇಲ್ಲಿ ಮಾಡಿಲ್ವಾ?
ಅಲ್ಲ ಮಾಡಿದ್ಮೇಲೆ ನಾವು ಡಿಲೀಟ್
ಇಲ್ಲಿ
ಮಾಡಬೇಕು.
ಮಾಡಿಲ್ವಾ? You are not made him as a party.
ಇಲ್ಲಿ ಮಾಡಿಲ್ಲ ನಾನು.
Yes.
ಅದಕ್ಕೆ ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ ತಗೊಂಡ್ರು.
Yes. What is this matter?
Similar to that of serial number 2021 morning, I have argued your lordship.
ಏನಾಯ್ತು?
Should notice and stay.
ಯಾವ್ದ್ರಿ ಅದು?
Serial number 2021.
What is the stay?
The stay is further proceedings for in suit, because here
These
the
are all same matter.
application has been filed for framing of the issues, the saying that suit is not maintainable for non-inclusive of all the joint family property.
Yes,
The application
stay
is
of
filed
further
with the dependent number 12. Without
24 of 2021. Pending in the file of senior civil judge Kadur till next date of it. Yes. Submission is accepted, after submission is over.
77, B.M.
77 also I complied the office objection, paid the court fee.
Court fee has to be paid, Mr.
Paid.
When? Today. When it is paid?
Was
Mr.
paid on March, 4th March.
ನೋಡ್ರಿ 4th March ರೈಸ್ ಮಾಡಿ. Yes. Yes, Mr. What is this?
This is also similar. madam.
All
4
same.
suits I have filed.
Yes,
The-
submission is submitted that office objection is complied. To verify, proceed further. Heard that issue notice, stay of further proceedings in OS 269 of 2021, pending in the file of senior civil judge Kadur till next date of hearing. Please.
78, Anjanaya AB.
Non-compliance office objection. Mr.
ಅದು
Khan.
maintainability ಅಂತ 2 years my lord. So the consequential relief is has been
Court
paid.
fee ಕಟ್ಟಿದಾರ? ಅಷ್ಟು ಅದೊಂದೇನಾ? Yes.
So in this case, my lord, the appellate court has allowed permitted the respondent number 1 and 3 to produce the additional evidence. The honorable court.
No, suit for?
Suit for partition and separate positions, suit has been dismissed by the trial court. So the respondent 1 and 2 filed the appeal. Before the appellate court, after filing the appeal, they filed an seeking additional documents to lead additional evidence, my lord. So that application has been opposed by me because of the whatever the evidence they are proposed to be adduced in this. Already I have produced in the before the trial court. The trial court, by considering all the evidence whatever produced by me and them, the the opinion has been drawn by the appellate court that the suicidal properties are not the ancestral properties. So the honorable appellate court allowed that application. Unfortunately, my lord, did a mistake that it is not specified for confining the evidence, whatever the additional evidence, they are not formulated at the point for consideration. And it is also against the rule 29 without formulating and specifying confining the additional evidence. The honorable appellate court allowed that application. That's why I filed an application seeking to rectify that mistake. So IA number 4, seeking under 41 rule 33. The honorable court dismissed my application by holding that whatever the order passed under Article 41 Rule 27, it is an appealable. No, it is not an appealable because of it is not remanded. Still, it is continuing today. That matter has been posted for cross of PW1 before the appellate court.
No, order 41 rule 27 order.
Yes, ma'am.
You can file writ petition.
ಅದು ರಿಮ್ಯಾಂಡ್ ಮಾಡ್ಲೇ ಇಲ್ಲ ಸ್ವಾಮಿ, ಇವತ್ತಿಗೆ ಇದೆ ಪೆಂಡಿಂಗ್ ಇದೆ, ಕೇಸ್ ಇಟ್ಕೊಂಡವ್ರೆ. ಸೈಡ್ ಮಾಡ್ಲಿಲ್ಲ ಕೇಸ್.
Application, not remand. They have filed an additional evidence that has been allowed that can be permitted in the appellate court itself. Appellate court ಅಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ಮಾಡಬಹುದಲ್ಲ, ಏನ್ ಕಳಿಸಬೇಕು?
ಮಾಡಬಹುದು ಸ್ವಾಮಿ. ಪ್ರಾಬ್ಲಮ್ ಏನಂತಂದ್ರೆ ಸ್ಪೆಸಿಫೈ ಮಾಡ್ಲಿಲ್ಲ ಯಾವ್ದ್ರ ಬಗ್ಗೆ ಎವಿಡೆನ್ಸ್ ಮಾಡಬೇಕು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು, ಎಷ್ಟು ಕನ್ಫೈನ್ ಮಾಡ್ಬೇಕು ಅಂತ ಮಾಡ್ಲಿಲ್ಲ ಅದ್ರಲ್ಲಿ. ಅದ್ರ ಆ ಮಿಸ್ಟೇಕ್ ರೆಕ್ಟಿಫೈ ಮಾಡಿ ಅಂತ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿನ್, ರಿವ್ಯೂ ಮಾಡಿ 33 ಕೆಳಗಡೆ ಮಾಡಿ ಅಂತ.
Where is that it has to be confined? Which
provision says? 29 ಮೇಲೆ. Sorry, Article 41 Rule 29 CPC. Whenever additional evidence is permitted, the appellate court, wherever additional evidence is allowed to be produced by an appellate court, the court shall record the reasons for its admission. Then Rule 28, mode of taking additional evidence. Wherever additional evidence is allowed to be produced, the appellate court may either take such evidence or direct the court from whose decree the appeal is preferred or any other subordinate court to take such evidence and to send it when taken to the appellate court. Rule 29, points to be specified and recorded. Where additional evidence is directed and allowed to be taken, the appellate court shall specify the points to which the evidence is to be confined and record on its proceedings the points so specified. In this case, it is not specified.
Where is your application? You have filed an application under which provision?
Yes, under 33 rule. IN number 4, my lord.
That order 41 rule 33.
Yes, my lord, page number 46.
Order 41 rule 33, what it says?
So,
appellate court shall have the power to pass any degree or make an order which is to be passed. No, that how your application is maintainable?
That application. Yes, my lord, because of non-specifying the.
You challenge that order. If it is non-specified, that you challenge that order is wrong.
ಎರಡು ಇದಾವೆ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ, ಎರಡು ಇದಾವೆ.
Where is that too?
The prayer B is with regard to 41 rule 27. The
You have challenged that order 41 rule 27.
Yes, my lord.
Yes.
The first relief. The next consequential relief is the B. The quasi impugned order dated so and so dated passed on IN number 2 filed by respondent owner under 41 rule 20 read with section 150 CPC.
Yes, issue notice. No, that is passed in 2022.
ಅದು ಅವಾಗೆ application for various reasons that application was keep pending.
When your application is disposed of?
ಇದು ಮೊನ್ನೆ ಫೆಬ್ರವರಿ 3ನೇ ತಾರೀಕು ಆಗಿ.
ಅಲ್ಲಿ ತನಕ ಏನ್ ನಡೀತಾ ಇತ್ತು?
ಅದು ಇಯರ್ ಅಂತಾನೆ ಬರ್ತಾ ಇತ್ತು. ಸೊ 2-3 ಸತಿ ಆರ್ಡರ್ಸ್ ಪೋಸ್ಟ್ ಆಯ್ತು, ಆಗ್ಲಿಲ್ಲ. ಮತ್ತೆ ಪ್ರಿಸೈಡಿಂಗ್ ಆಫೀಸರ್ ಚೇಂಜ್ ಆದ್ಮೇಲೆ ರೀರಿಂಗ್ ಆಯ್ತು.
Stay of order dated 16/2/2022. Passed on IA number, what is that IA?
IA
number 2.
41 rule 27.
41 rule 27 till next date of hearing. Yes. Submission is accepted, office objection is over.
79 Lokesh Addi.
Yes, what is that maintainability, Mr.?
Petition filed by impugned order on the 39 rule 1 and 2, not only night.
Appeal hakbekala ni?
I may be permitted to withdraw.
Yes.
It's liberty to file MFA.
Yes. Office has raised an maintainability that writ petition is not maintainable since appeal is provided under order 43 rule 1 or counsel for the petitioner has filed a memo withdrawing that. Memo is taken on record, dismissed as withdrawn with liberty to approach appropriate legal.
Cell number 80 Balakrishna Shastri Ji.
On complaints and
to a week's time I began to comply office objection.
Week's time is granted to comply office objection.
Great.
ಆಯ್ತು, ಅವ್ರು ಮಾಡ್ಲಿ ಬಿಡಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಮುಂದೆ ಹೋಗುತ್ತೆ ಅಷ್ಟೇ. Yes.
81 R.S. Umesh.
Petitioner.
Yes.
This petition is arising of the common order. I paid court fee for 300 rupees.
You paid.
One is reopen, recall and production of documents.
Yes. Submission of.
I filed the applications on
Verified, yes.
6/2/26.
Suit for?
I have filed the suit for bare injunction, wherein the respondents have filed a suit for declaration. The evidence is recorded in.
No, there are two suits.
Two suits.
You filed an injunction.
I filed a suit for bare injunction at annexure A.
No, that both the suits are clubbed.
Clubbed together, and evidence is recorded in 3575 of 2001. I have obtained the documents under the RTA on 29/1/26 is at annexure L1, page 97. Immediately after that, I filed an application for production and for recall on 6/2/26.
No, why you have applied only in 2026? What is the reason?
Reason is that I was under the impression that entire extent of 3 acres and odd was acquired and it has been given to the plaintiffs. Then I come across that there is an reacquisition by the BDA for the purpose of formation of the road. Then 5 guntas which were in my custody, my possession, that was not given, handed over to the possession is handed over to the, neither to the plaintiff nor to the.
No, when did you come to know that?
I came to know about only in the year 26. That is in the month of November. Then I applied for it under RTA.
Where is that? Have you stated that?
Yes, please. In page 97, please. L1. The documents were supplied on 29/1.
Documents supplied ಸರಿ ನಿಮಗೆ ಯಾವಾಗ knowledge ಬಂತು ಅನ್ನೋದನ್ನ ಎಲ್ಲಿ ಹೇಳಿದ್ದೀರಾ?
ಇದಲ್ಲಿ ಇಲ್ಲ, ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ಹೇಳಿಲ್ಲ. ನಾವು ಇಂತ ಸರ್ಟನ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಬೇಕು ಅಂತ ಹೇಳಿದಾಗ RTA ಅಲ್ಲಿ ಹಾಕಿದಾಗ ಸಾಕು.
No, in that affidavit we have
in affidavit we have stated that
in affidavit you have filed an application.
Yes, please.
Have you stated that?
Please. In page 77, please. 76 and 77. We have narrated the things what happened in the proceedings, and in page 77, parrot 12, no suffice the society representing that it needs land for establishment so and so, so and so, wherein the said prestige group constructed luxurious. Then after that, when at para 13, they have stated that ಕೆಳಗಿಂದ 5ನೇ lines, 6ನೇ line. So also the fact that the disputed portion of 5 guntas falls within 17 guntas acquired by CITB. The proceedings accordingly, the plaintiff's claim does not sustain as ownership of the social property of 5 guntas west with the CITB. Presently, BDA and the plaintiff cannot maintain a suit as made. The plaintiff apprehending that if the setbacks are disclosed, certainly it would not succeed in the suit. It cleverly suppressed the setback which goes into the root of the case. Then I applied for the RTA.
ಅಲ್ಲ ನಿಮಗೆ ಯಾವಾಗ ನಾಲೆಡ್ಜ್ ಬಂತಂತ ಏನು?
After the cross examination of the
ಏನು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಏನು ಹೇಳಿದ್ದಾರೆ?
With regard to the reacquisition of the land by the BDA in respect of
stated in this application.
Application ಅಲ್ಲಿ ಹೇಳಿಲ್ಲ.
ಮತ್ತೆ that is what that you have to state. Now problem is that why delay? See,
only after
you can say
that I have not clearly mentioned in the affidavit.
Then where is that
then
order?
I made an application.
Where is that impugned order?
Impugned order is at annexure N. In page, it starts from 129. The reasoning given by the court below is that I would have filed these documents before the court before the framing of the issues.
No,
127.
Then you have to say, I was not aware, I came to know only when that cross examination.
That specific government is not made in the affidavit.
Where is that cross examination they have raised on?
I have not put the, I have not furnished the cross examination portion.
Produce the copy.
And in the meantime, the matter is posted for defendant's argument by 15th.
Day after tomorrow, you produce that.
Please.
Yes. Release this matter day after tomorrow in preliminary released. Yes.
Cell number 82, SC Vijay Kumar for petitioner.
Subjection with regard to, I have not served the copy to the caveat, I have served the copy to.
Served, that's only. Yes.
The
petitioner has served and copy to that caveat, else office objection is ruled. Yes.
This is a plaintiff writ petition. The plaintiff filed an application for inclusion of another property. Suit for partition.
Yes.
At the time of, after the cross examination of DW2, I filed, since the DW2 in the cross examination, he stated that at the time of execution of the release date by the plaintiff and defendant number 1 in favor of the defendant number 2, the property value is.
Why it is rejected?
It is rejected only on the ground that it is barred by limitation.
Partition suit inclusion of property.
Please.
Where is that?
Page number 65, para 7. May I read it?
Yes. No, that you have denied that it is not a joint family property. Challenging that release date.
Please.
Then how can it?
You should kindly see, you should, in the cross examination, he says the DW2 clearly admits that at the time of execution of the document, he mentioned the value of the property rupees 1 lakh. But actually the value of the property as on that date.
Forget about value. You have pleaded that you have executed a release date.
Please.
Now what is that amendment you are seeking for?
I am seeking for, it is not binding on me because.
Then you have admitted that you are reversing that.
I am not disputing that. But what happened is, as on the date of the execution of the deed, it is mentioned in the release date, the value of the property is 1 lakh. In the cross examination, he clearly admits that as on the date of the execution of the document itself, the value of the property is 10 lakhs.
How it will make difference, Mr. For challenging that order, if that value they say something else.
He has played fraud in obtaining the document. He has by mentioning value below value. He has played fraud on the plaintiff. I will read that portion. Cross examination.
Para 15. Yes. Yes.
This was the state of affairs. The second defendant, without knowledge of the plaintiff, behind her back with the sole intention to deprive the rights of the plaintiff of the suit. Executed a guilty dated 23rd of April 2003 in favor of the third defendant in respect of first and second court. Fact of execution of the guilty by the second defendant in favor of the third defendant came to the knowledge of the plaintiff in year 13. At that time, the plaintiff demanded for partition of joint family properties left with deceased Rajshekhar, that is her father. It is submitted at that time, defendants 2 and 3 agreed to give the share of the plaintiff in the two property, subject to she having relinquished her rights in respect of the agricultural land in 93 parties and 2 acres, situated in Sourcewell village, Karnataka district, which was inherited by the deceased Rajshekhar in the partition effected by him and his brothers in favor of the third defendant. Next paragraph. It is submitted that plaintiff deleting the word the defendants 2 and 3 with the intention to make share future property as executed the release deed in respect of the agricultural property along with the daughter Rohini, Ravi and the first defendant on 9/10/2013 in favor of the third defendant. Then she says that I executed this release deed telling that I will get a share in the property here in Bangalore. I released the property. I was not given the property in Bangalore. She didn't challenge it. She filed a suit for partition only of the Bangalore property.
Yes.
And this happened. We filed a written statement. Trial is over. It is now posted the stage of argument. At that stage, they asked the an application for amendment. They request this court to see the amendment application. What is their so-called allegation of fraud? This application for amendment is at page number 52.
Yes.
Relevant portion that they want to add one paragraph. They want to say it is not acted upon because I did not get the RTC changed to my name. It is submitted to the father plaintiff Rajshekhar was having agricultural property survey number 93 Bharti, 2 acres situated at Social District, which was inherited by deceased H.C. Rajshekhar in the partition effected by now the RTC of the property still stands jointly in the name of Suvarna Rajshekhar, wife of H.C. Rajshekhar and R. Within the third defendant. It is subject in respect of this property, plaintiff defendant number 2 and R. Shrimurthy first defendant have relinquished their rights by way of the relinquishment deed on 9/10/2013 in favor of the Unfortunately, this document is not acted upon, which is evidence of the RTC party. Now they want this deed to be set aside, the prayer now declares that the relinquishment deed is not binding on the share. The court said it is filed in 2013, suit is filed in the year 2019, application for amendment is filed in the year 2025.
Is there any limitation?
Yes, to challenge it under Article 59. It is 3 years from the date of knowledge.
Your Worship,
Even if it is under an application for amendment, applying the judgment of the Supreme Court, the court said that I cannot allow an application wherein it is beyond or it is barred with the law of limitation.
No, that if
Even
it is,
allowed, I will have to allow it, assuming that you are challenged it today. Still it will be barred by limitation. Relied on the judgment of the Supreme Court. Now please see the include order, the relevant portion. Page number 65, paragraph number 7 of the include order.
yes.
Admittedly, H.C. Rajshekhar is the father of the plaintiff and defendant 1 and defendant 3. It is not a dispute that the plaintiff D1 and D2 have executed the relinquishment dated 19/2013 in favor of defendant number 3. But the plaintiff has been content that the same is not acted upon. As the release date dated 19/2013 was not acted upon, they are also entitled to a legitimate share in the property bearing 93 acres. As stated above, relinquishment deed is executed on 19/2013. Suit was filed on 29th of May 2019. Plaintiff has filed the application to include the property bearing 93 acres on 29th of 2025. It shows that after a lapse of 12 years from the date of the execution of the release deed, plaintiff has been challenging the same. Plaintiff and defendant number 1 and 2 are part of the relinquishment deed dated 19/2013. If the said deed was not acted upon, the plaintiff would have challenged the same in the period of limit. At this junction, relevant to refer to the judgment of the Supreme Court reported in source. The apex court has said this one of the conditions for amendment is subject. A prayer for amendment is generally required to be allowed unless by the amendment a time bar scheme sought to be introduced in which the fact that the case would become time bar becomes a relevant factor of consideration. In view of the ratio later of the above decision, it's clear that generally all amendments are required to be allowed unless the case made to the case is part of the limitation. And discussed about the lease deed case in the executed on 19/2013. After lapse of 12 years from the date of the execution, the plaintiff has sought leave from declaration of the on the share of the plaintiff. Plaintiff here is the party to the lease deed dated 19/2013. In the plaintiff had an intention to challenge the execution date in 19/2013. The challenge is said to be real to the date of execution. She has failed to challenge the same. Even if the plaintiff is permitted to amend the plaintiff as stated in the application, the same will permit the amendment from the date of the application, not from the date of the suit. Therefore, the plaintiff is permitted to amend the plaintiff as not to in the application. No purpose to be served. In view of the ratio enumerated in the
Yes, Mr. What you say for the limitation?
Worship,
last submission. I was not instrumental in drafting the claim. She herself said
No,
she has
even if it is there.
She voluntarily referred to this deed, said I have executed this. I was supposed to get on account of execution, I was supposed to get a share in the property in Bangalore. I was not.
No, if it is not time barred, she can challenge whether it, how can you go?
Worship, I have alleged fraud against the defendant number 2 in the my application. Your Worship, kindly see the page number 55. Your Worship.
I think even fraud alleged also, you have to.
From the, I have came to knowledge about the fraud played by the defendant number 2. Immediately I filed this application.
No, when you have come to knowledge?
During the cross examination of the DW2.
What is that you came to know that? No, when you have filed in a suit itself, you came to know that. Why you have filed in a suit? When you have given a release deed, subject to that, they will give a share.
Please.
If they are denied to give the share, therefore you have
No,
filed
no,
a suit.
no. They are not denied the share. My contention is that as on the date of the execution of the release deed, the share value of the property as mentioned in the deed is only 1 lakh rupees. But during the cross examination, he admits that as on the date of the.
That is not the fraud, Mr. That is
Please,
you have accepted.
intentionally.
I will promise you saying that I will give some other property, you give this release deed, then that has not given, you can say that fraud. See, earlier you have agreed for 1 lakh, now it is 10 lakhs. Therefore, it's-
Now, not now, Your Worship, as on that day itself, it is mentioned.
No, as on that day, even if it is 10 lakhs, if he has agreed for 1 lakh, that you
No,
can't say that fraud.
he himself, DW, Your Worship,
You
kindly
show
see.
me, show me any judgment that this can be challenged. What is the limitation for that? Can it be challenged after limitation?
Please,
That is what the-
I have it on day after tomorrow, I will place the judgment.
That is the only a point of law
Please.
that you have to be answered. Yes.
Please, Your
Yes. At the request of petitioner, leave this matter of 2 weeks.
Allah,
2
2
days.
weeks, Padaswami.
2
Day
days. 2 days, yes.
Please.
Bill number 83, Shrikant MP for petitioner.
This objection is, my lords, more than one application, one writ petition, my lords. The common order is passed.
paid
Sufficient court fee has been paid.
Yes.
Not the urgency is this, not the, my lords, we are the LRs of the defendant.
Yes.
My lords, suit for specific performance. After we, my lords, entered appearance, we adopted the written statement and also filed 3 applications, my lord.
Yes.
That is IA 7, 8 and 9. IA 7 for, my lords, recalling the evidence of PW1. My lords, for reopening the evidence, and my lords, for rejection of plaint under Order 7 Rule 11D. The court considers application of Order 7 Rule 11D and my lords dispose it out, dismisses the application, which is challenged in a CRP before this honorable court. Though we tried to, my lords, have the other side as directed by this honorable court, my lords, he did not take, he evaded, my lord, the notice, and my lord, the matter is now pending, my lords, for consideration. In the meanwhile, my lords, as the matter was posted for the evidence of defendant, though we brought to the notice of the court at that time, note that the cross-examination is still pending. But that was not being considered, my lords. Every time we pointed out. Constrained, my lords, we filed 2 more applications. Order, that is, my lords, IA 10 and IA 11. IA 10, we said our applications which are pending, that is IA 7 and 8, are to be considered. And my lords, we sought for reopening of the, my lords, the order for our consideration of our applications. The trial court, my lords, what happens is, my lords, when a colleague is present, matter is posted for, my lords, objections on the application. My lord says that, my lords, you have to cross-examine today itself, without, my lords, there being any objection. And my lords, when a junior colleague, my lord, is present before the court, his signature is taken that, my lord, he is not willing to cross-examine on the same day. My lord, rejects IA 10 and 11. IA 7 and 8, my lord, are still pending, my lords, as on today.
IA
7 and 8, which are for, my lords, reopening. And my lords, cross-examination of PW1 is still pending today. My lords, in spite of saying that, my lord, it cannot be done. Now the matter is, my lords,
where is that order? Which is that order?
My lords, the order, your lords, may kindly have a look at, my lords, annexure H 129, my lords.
No, you said that unless it is recalled, I can't cross-examine. Why? You can cross-examine that.
My lords, on the same, my lords, the matter was posted for objections, my lords, on IA 10 and 11.
IA 10 and 11 for what?
My lord, colleague, that is IA 10, my lords, for consideration of 7 and 8. My lords, that application was, my lords, posted on that day for objections of the other side. Because, my lord, the senior colleague was not there, my lord, he said we cannot examine, cross-examine the same day. Please.
You submitted that applications are all recalled and reopened, even the evidence would not, because today is submission is recorded.
That is what, my lords, I'm trying to
submitted that even if that applications are allowed or recalled and reopened PW1 evidence, he would not cross-examine the PW1 today.
On the IA 10 and 11 were not the application, my lords, for cross-examination.
Where you have stated that your junior's signature has been taken forcibly. Have you stated?
My lords, I have said so, my lords.
Where is that?
My lords, in the writ petition. Lords, may kindly come to, my lords, para 44, my lords.
Yes, read.
Lords, in the circumstances, the petitioner felt that there was non-consideration of their case while adjourning the matter by taking cross-examination in its nil. Application for recalling the order dated 10/11/25 was preferred along with the same, since IA 7 and 8 preferred by the petitioner along with 7.
Para 44.
44, my lords, page number 44. Sorry, 29, page number 44. I'm sorry, my lords.
Yes. 29.
Please, my lord. And my lords may have a look at.
29 is page 7.
My lords,
Para 7.
para 29, my lords, page number 44.
44.
Facts, my lords, have stated that the application was rejected. In grounds, if your
Yes.
lords,
Yes.
in grounds, if your lordships come to my lords, as specifically stated. May take my lords 51, my lords, page number 51, para 47.
Yes.
Be that as it may, the petitioners moved IA number 10 and 11 before the court below, which were filed for seeking for consideration of their applications IA 7 and 8, and to recall the order dated 10/11/25, since the matter stood posted for the evidence of the defendants, that is the petitioner here. In view of the petitioner's cross-examination of the respondents was very much necessary in order to substantiate their stand. However, the court below by order dated 10/2/25 has rejected the application in spite of pointing out that applications 7 and 8 are pending, construing that the application is recalled for PW1 and that he would not cross-examine the PW1 on that day. When the matter was actually listed for objections on the applications, the trial court observes that there is an effort to protract the proceedings and observing that even on that day, the petitioner was not ready for cross-examination. IA number 10 and 11 were dismissed while posting the matter for defendant's evidence, that is petitioners has a last chance by 24/2/2026. On the said date also, when the issue was brought to the notice of the court, the application IA 7 and 8 are pending. The court below treats the defendant evidence as nil, directing listing of the matter on so and so, and on that day was adjourned to 7/3/26. My lords, I've said, my lords,
You have not said that your signature has been taken forcibly. Where is
lords,
that? That is what you are arguing now.
part 53, my lords, have specifically said.
Yes.
It is submitted that your lords may have it. Due to the fact the civil division petition is pending and so that the matter was posted for objection to the application, a submission was made. It was brought to the notice of the court below on 10/2/26 that they may not be ready to cross-examine on the same day. The court below strangely takes the signature of the colleague of the advocate on record on the order sheet and rejects the application.
Yes, heard. Issue notice. Stay of order dated.
My lords, all the impugned orders and my lord, further proceedings, my lord, now the matter is posted for judgment on 16th, my lords.
Stay of further proceedings in OS number 1610 of 2020, pending in the file of 13th Additional City Civil Judge, Bangalore, till next date of hearing.
My lords, may seek for, my lords, hand delivery of the.
Yes.
Please.
Submission is accepted of submission. Yes.
84 Dastagir JA for petitioner, Manjunatha KV.
Petition in this case, my lord.
What is that of subjection?
Lord, the two applications has been filed, my lord. For that, my lord, the objection was raised.
Have you paid court fee?
Yes, my lord, I have paid, my lord.
How much?
Yesterday, 200 rupees paid, my lord. Earlier, I have paid 200 rupees. Yesterday, I have paid 200 rupees, my lord.
Yes.
My lord, recall and reopen application filed by me, my lord, which came to be rejected.
Suit for?
Suit for specific performance of contract, my lord.
You are the plaintiff or defendant?
I am a defendant, my lord. I am a subsequent purchaser, my lord.
Yes.
My lord, the order is at page number 11, my lord.
Yes.
On 24/2/2026, my lord, Sri DJ files NOC Wakalat of defendant number 5 and application number 151 of CPC and 18/17 of CPC, which number.
What is that application? Who has filed application?
My lord, the defendant number 5, my lord, that is petition before this number court filed application.
Application for?
For recall and reopen of cross of PW1, my lord. Considering the same, my lord, the trial court was rejected the application on the ground that, my lord, already sufficient opportunity has been given. For that reason, my lord, even though the defendant was failed to cross-examine, my lord. My lord, what happened in this case, my lord, earlier occasion, my lord, IA number 4 and 5 has been filed by the erstwhile advocate, my lord. He sought for a date, my lord. Considering the same, my lord, the trial court was rejected the applications, my lord. Thereafter, my lord, the NOC has been given by him, my lord. Subsequently, application has been filed, my lord. The matter is for set down for tomorrow, my lord, for arguments. If the court permits, my lord, I'll cross-examine tomorrow itself.
Not cross-examine. Whom you want to cross-examine?
PW1, my lord.
PW1. When that evidence of PW1 has been closed?
Lord, it was closed.
23/1. 25. Yes. Why you have not cross-examined on that day?
My lord, earlier advocate was not cross-examined, my lord. Earlier advocate was not cross-examined.
Not the ground, Mr.
My lord,
Advocate
yes,
is
my lord,
not, you won't file any case against that advocate. In all cases, advocate
my
is
lord,
not, why you have engaged the
I'm
court?
seeking a mercy of this honorable court, my lord. Without fail, my lord, tomorrow the matter, my lord.
Have you given a complaint against that advocate before the bar council? Saying that he has not examined that?
My lord,
No, that if that is the case, in all cases, everybody is saying that advocate is not. Why advocate has been engaged?
my lord, the recall application was filed.
Instead of that, they
Yes, my
are,
lord.
see, instead of solving your problem, they are creating the problem. Then why that advocate has to be engaged then? All cases, everybody is making an allegation as advocates. Then you
My lord.
given a complaint to that bar council.
My lord,
Then
you-
it will be set right, Mr.
my lord, on 17/2/2026 orders, my lord.
Have you stated in that
Yes, my
petition that,
Yes, my lord.
where is that?
My lord, which can be seen at page number 33, my lord.
Hmm.
Para number 3, my lord.
30?
Page number 33, para number 3, my lord.
Hmm.
I submit that the case is set down for a cross of PW1 on 12/3/2025. My advocate engaged in other matter in the High Court of Karnataka. He could not able to come and cross-examine the PW1. Hence, considering the request made by the associate advocate, the Samar Court was pleased to close the cross of DW1 as a nil and posted the case for evidence of defendant. Thereafter, thereafter, my lord, I have filed a recall application.
When you have filed an application?
My lord, I have filed application. My lord, on 17/2/2026, my lord, applications for filed by the earlier advocate, my lord. Subsequently, my lord, on
23/1/2025, it is closed.
Yes, my lord.
Your counsel is held up in somewhere. Yes, next day he has to file an application.
He filed application, my
When
lord.
it is filed, I am
My lord,
asking.
it was filed on 9/12/2026, my lord. He filed application, my lord.
In 12?
9/12/2026, my lord.
9/12/2026 ಎಲ್ಲಾಗಿದೆ?
Sorry, 2025, my lord.
9/12/2026 1 ವರ್ಷ ಏನ್ ಮಾಡ್ತಿದ್ರು?
He filed application, my lord.
What were you doing for 1 year, mister? ಅವತ್ತಾಯ್ತ್ರಿ, next day application ಹಾಕ್ಬೇಕಲ್ಲ. Why you have waited for 1 year?
On
No, see, on 23/1/25, PW1 evidence is closed. When he has filed an application? Where is that?
Hello.
Huh? 18/6? What has happened that application? Then again, 25/9 it is closed. Yes, mister, what you say all this?
My lord, the instruction is that, my lord, earlier advocate, the thing was happened, my lord. For that reason, my lord.
Filed an application again and again, but he has not done it.
My lord, for that reason, my lord, I'm seeking a mercy of this honorable court, my lord. If they present tomorrow, my lord,
No, Mr. See, after hearing that posted for an orders, tomorrow is for a judgment.
No, my lord, it is for arguments, my lord.
Arguments.
My lord.
Again that you have to be reopen everything. When the suit will be decided?
My lord, with condition, my lord, I will cross-examine tomorrow itself, my lord.
Most of the cases, Mr. You are creating that delay in that.
My lord, that sit down for arguments, my lord, even.
For a purchaser, what is there in that?
My lord, for a bona fide purchase is concerned, my lord, I have to cross-examine him, my lord.
What cross-examine you can do?
My lord, for that reason, my lord, tomorrow, my lord, tomorrow the case is there, my lord.
You pay 50,000 rupees cost, I will permit it to cross-examine.
Lord, that is huge, my lord.
Otherwise, there is no limit. These are all that method to drag that matter, Mr.
No, my lord.
No, earlier opportunity has been given by the court. That too you have filed after 6 months. After again 3 months, PW1 has been present. You are not cross-examined. What will you do? Otherwise, the next tomorrow you will also do same thing.
No, my lord. Tomorrow.
At the cost of 50,000 rupees, I will permit.
My lord, that is a very huge amount, my lord.
No, Mister. Where is that property situated?
Property situated at Banandanhalli village, my lord.
What is that value of the property?
The 24 lakhs, my lord.
Yes. You pay the 25,000 rupees cost,
my lord,
and cross-examine. Today is that matter.
Tomorrow, my lord.
Tomorrow you ask that PW1 to be present. You ask to cross-examine. Proceed with condition that you have to deposit 25,000.
My lord, huge amount, my lord.
No, Mister.
My lord.
Yes. Then I will close it. Third.
My lord.
No, Mister, there is no end of this.
My lord, if I default, my lord, tomorrow will be the last chance may be given, my lord.
No, Mister, this is not that, Mister. 1 year because of you. 1 year because of you that not cross-examination, it has been urgent, Mister. 1 year, suit unnecessary. Making all allegations that courts are not disposing, suits are pending by years together.
No, my
This is
lord.
all created by advocates only.
No, my lord.
Yes, Tali. Yes. You go and file against that advocate who has not acted upon. Yes. This petition is filed challenging order dated 24/2/2026, passed on IN number 6 and 7 by Third Additional Senior Civil Judge, Bangalore, Rural District, Bangalore, filed by defendant number
Defendant number 5, my lord.
defendant number 5 for recalling and
Recall and reopen the stage of plaintiff.
opening that evidence of PW1. Plaintiff has filed a suit for specific performance of contract. The defendant number 5, who is the purchaser, on service of summons he has appeared. You have filed a written statement.
Yes, my lord.
He has filed a written statement. On 23/1/2025, when that evidence of PW1 has been completed, the defendant number 4 has not cross-examined that PW1, hence evidence of PW1 has been closed. Thereafter, after 6 months, application has been filed for recalling and
reopen, my lord.
yes, recalling and reopening of the evidence of PW1. Court once again has permitted, has allowed that application on 18/6/2025, permitted to recall and permitted to cross-examine the PW1. Again, that PW1 has present on 25/9/2025. Again, that defendant number 4 has not cross-examined that PW1. Therefore, the evidence of PW1 has been closed. Again, this application has been filed for recalling and reopening of that evidence of PW1. The trial court has dismissed the same. Now that matter is posted for arguments. In spite of giving a sufficient opportunity, the defendant number 5 has not cross-examined that PW1. There is no any ground has been made out for allowing that application, and there is no error in order passed by the trial court. Accordingly, writ petition is dismissed.
Court may be imposed, my lord. I may be permitted to cross-examine.
Yes.
I request for a
Yes, in spite of, in the interest of justice, to give one more opportunity, the petitioner, defendant number 5 is permitted to cross-examine PW1 on day after tomorrow.
Tomorrow, my lord.
Tomorrow will be present. And tomorrow, that counsel appearing for petition plaintiff has assured that tomorrow that PW1 will be present before the court. The defendant number 5 is permitted to cross-examine the PW1 tomorrow, or if courts has any problem, then court can fix a next date. On that day, without fail, he has to cross-examine the PW1 with condition that he has to pay 25,000 rupees cost to that plaintiff on the day, and to see, tomorrow court can fix the date. On the day court fixed for cross-examination of the PW1. Yes, if he paid cost, he can be permitted to cross-examine the PW1. Otherwise, order passed by the trial courts for closing that evidence will be holds good.
My lord,
Yes.
I request for reduce of the cost, my lord.
No, Mr. It's all that Bangalore properties. This is the things which are doing. 1 year parties wants to come here and you have dragged 1 year without cross-examination. That's a purchaser. See that? Yes. No, now it is for only a argument. Is cross-examination is over, then arguments only.
My lord, evidence is there, my lord. Others also not examined, my lord. Now, my lord, my vendors went with a plaintiff, my lord.
Trial court is directed to dispose of the suit as expeditiously as possible, not later than 6 months from today. Yes.
Serial number 85, Sarvamangala for petitioner.
For petitioners in this matter, my lord.
Yes, what is
Raise
that?
for short accommodation.
Yes, week's time is granted to comply of subjection.
Much of.
86, Bhaskar Gowda NM.
Yes, Mr.
What
What
is
is
the copy to the?
that is the only office objection.
My lord, the other office objection, please, my lord, written statement. I'm producing it right now. It's a written statement. And the other office objections, please, my lord, are minor. I'll comply. There is an urgency, please, my lord.
Paginations to be correctly shown. So yes, tomorrow you comply it. Yes.
Now itself, now.
Yes, you do it. Comply it. If there is an urgency, why you are not complying that?
Lord, yesterday I filed the writ petition.
Yes.
Now itself, my lord,
Is
is
this matter
permitted.
tomorrow?
Preliminary hearing.
Subjection is complied. Yes.
Please.
87, Balakrishna Shastri G for petitioner.
Lord, the office objections regarding maintainability is 2 IAS. One writ petition is filed. I have paid
Yes.
200 rupees court fees.
Paid court fee is paid.
Court fees is paid.
Yes. Yes.
Lord,
What is
the
this?
petitioner, Lord, is the
Office objection is complied. Submission is taken on record. Office objection is over. Yes. Yes.
Lord, orders on 2 applications are stayed. Lord, annexure A is the order in execution proceeding where the learned executing court allows the AN directed removing, demolishing under construction pillars, stairs, and any other obstructions put up in the allotted decree holders under final decree in FDP 37 of 1989.
Yes.
Annexure B, my lord, is an order, my lord, regarding giving police protection, my lord, assistance for executing. My lord, annexure C, my lord, is the final decree. My lord, your lordship says at page 40, my lord, page 38, at page 40. My lord, the page 40, my lord, your lordship says annexure C, preliminary decree. The plaintiff
Yes.
is entitled, my lord, 1/5 share in the suit schedule property. Schedule
Now,
is.
where you are reading? Page 40.
My lord, I am reading, my lord, annexure C starts at page 38. I am reading at
No,
page
this-
40, my lord. Page
Yes,
40.
this is a suit for
Second
suit for
paragraph.
partition.
This suit for partition, my lord. Suit for
Yes,
partition.
1/5. Yes.
1/5. My lord, schedule is survey number 48 measuring 11 guntas. So plaintiff
Yes.
is entitled, my lord, 11 guntas, 1/5 is 2.02 guntas.
Yes.
No dispute, my lord. Then your
Yes.
lordship says, my lord, in the final decree proceedings, commissioner was appointed. Commissioner goes to the place. He draws a sketch and submits report. Annexure D,
Yes.
my lord, is the report. My lord, kindly turn to my lord page 42. Annexure
Yes.
D. There, my lord, report of the commissioner is second paragraph. Down below, my lord. What is to be given,
Yes.
my lord, to the plaintiff at page 42, my lord. Report of the
Yes.
commissioner. Area covered by A, B, C, D, E, F, G, A, J, K. 1 gunta, 1 gunta, 1 gunta. Total, my lord, 11 guntas. So total
Yes.
area, my lord, is earmarked by him by these letters. Then
Yes.
colored area, my lord, half gunta in RS number 48/6, vacant area, and the area covered by FGJHG measuring 1 3/4 guntas in survey number 48/5. Total is the 1/5 share of the plaintiff is identified. Total though, my lord, it comes to 2 1/4 gunta. Allotment is restricted to 2/1/5. This is not the commissioner's report.
Yes.
Now, my lord, annexure E, my lord, is the final decree. What happens is, while my lord registering the final decree, annexure E, my lord, at page 61, a mistake, my lord, has happened, my lord. Kindly turn to page 64, my lord.
Yes.
Second paragraph, my lord. Upon reading the preliminary decree dated 27/11/1994, passed in OS number so and so, he is hereby allotted a portion of scheduled property carved out of survey number 48/6 to an extent of half gunta, and in survey number 48/5 to an extent of 1/3/4 guntas, which is earmarked by FGJHG. So much, my lord, no objection. In the annexed sketch, measuring this, my lord, your lordship says, measuring east to west 74 feet and north south 75 feet, and the same is bounded. This is a mistake, my lord, addition. This 74 east to west and north south, my lord, 75 feet comes to 5.05 guntas. The rest of the portion, my lord, 2.02 guntas comes correctly. While registering, my lord, it may be a computer mistake or whatever it is. A wrong, my lord, decree, my lord, to that extent, my lord, then, my lord, my client filed an application before the executing court. Lord, your lordship says, Annexure G is the application filed for the necessary orders. The trial court, executing court passed an order, my lord, correcting the same, my lord, holding that the preliminary decree is for 2.02 guntas, and the plaintiff is entitled, my lord, only to such an extent. Then, my lord, that is an order, my lord, on IA number 2 of 2021, my lord, your lordship is Annexure J, my lord, page 97.
Yes.
Page 97, my lord. At page, my lord, 99, my lord, your lordship says the discussion of the learned trial judge, para 8, my lord, about after leaving 3-4 sentences. The report shows the measurement of the plaintiff's share to the extent of east-west 74 feet and north-south 75 feet. This aspect is disputed by the JDR, stating that the land measurement shown by the commissioner is to an extent of 5 guntas. But the share of the decree holder is only 2.02 guntas. Hence, it is contention of the JDR that this honorable court, while executing the decree, cannot go beyond the preliminary decree passed by this honorable court. Accordingly, filed application under Order 21, Rule 28 CPC. That said provision, if you peruse, speaks that any order of the court which the decree was passed or such court of appeal as aforesaid, in relation to the execution of such decree shall be binding upon the court to which the decree was sent for execution. Looking to the provision of CPC, it clearly shows that, however, the decree passed by this court is only to be executed by this court. Hence, looking to the contention of JDR as well as the decree holder, it clearly shows that the decree holder has also admitted that as per preliminary decree, DHR is entitled to 2.02 guntas out of 11 guntas in survey number 48. Hence, considering the contention of both parties, as well as on perusal of the citation relied upon JDR, it clearly shows that the JDR has made out a ground to allow the above point. So, my lord, learned trial judge allowed IA number 2 bar 2021. The decree holder is directed to execute the decree in accordance with the preliminary decree passed in OS number 663 of 1981 and FD 37 of 89 with respect to 1/5 share out of 11 guntas in survey number 48 of Matikere village. So, my lord, this decree, my lord, is over 2.02 guntas covered by these letters, my lord, is the. Now, my lord, the executing court, my lord, again, my lord, says, my lord, once a final decree is passed in a partition suit, the same is engrossed and drawn up. The rights of parties crystallizes in terms of the decree. The decree thus passed has not been shown to have been set aside, modified, or reversed by any superior court. Therefore, my lord, it again says, I can't go behind the decree. And, my lord, while these orders are passed, my lord, your lordship says, on IA number 2, your lordship says, my lord, page 24, my lord. Order portion. IA number 2 filed by DHR number so and so is allowed. The JDRs are hereby directed to remove, demolish the under construction pillars, stairs, and any other obstruction put up in the portion allotted to the decree holders under the final decree in FDP 37 of 89, and to break open the lock and remove the gate and lock obstructing access within 15 days from the date of this order. In the event of failure within the stipulated period, the bailiff of this court is authorized to break open and remove the obstruction, including under construction pillars and stairs situated within the decree scheduled portion, deliver vacant position. Now, my lord, there is no, my lord, obstruction in the portion, my lord, earmarked. The house, my lord, is a 71 years, my lord, 71 constructed house. This house we had supported, my lord, with the pillars to prevent my lord, falling down. Now, there is no clarity, my lord, in which portion, what pillars are to be, no inquiry is held. They filed this application, I filed objection disputing it. The learned trial judge says, my lord, application is allowed. Same, my lord, now what is the area to be delivered? My lord, if east-west 74 feet, north-south 75 feet, my lord, it goes double of the extent. Page 33, my lord, is the order on IA number 3. There also, my lord, your lordship sees second paragraph, page 33, my lord, on IA number 3. The jurisdictional police are directed to provide necessary protection to the bailiff of this court for execution of the delivery warrant in respect of the portion allotted to the decree holders in FDP number 37 of 89, strictly in accordance with the final decree and commission's report. Now, my lord, strictly in accordance with the final decree, my lord, he can go east, west 74 feet, north, south 75 feet, in which event, my lord, 5.50 guntas goes. The decree, my lord, is only 1/5 in 11 guntas. Final decree is also only, my lord, in the registered final decree, my lord, there is.
You are entitled only for 2.02
Whatever, my lord, 2.02.
Which is the 2.20?
My lord,
Is
the
there
same
any-
has been extracted in the commissioner report. My lord, so far as my
Now
lord,
that
the suit,
gate demolition and all, is it under the
my
same?
lord, so far as my lord, the preliminary
Where
suit
they
is
are
of the
going
year
to demolish, my
1981.
lord,
My lord, decree has reached its finality. Final decree proceedings, my lord, the commissioner has been appointed. As against the commissioner report, my lord, the judgment debtor, my lord, he's failed to file his objections, sir. And final decree has also been drawn. Thereafter, my lord, I filed the execution. Execution, my lord, he's or no, he's raised the objections, sir.
No,
Unless, my lord,
see-
challenging the final decree, my lord, the
No. See, you are entitled for
2.02 guntas.
that is has been identified by that commissioner. Where is that commissioner report? Which is
Annexure
that,
D, my lord.
Annex D.
which is
Annexure
your
D.
property in that?
Annex D.
Annexure D. Which is your 1, 2, 3, 4, 5, which is your this thing, Mr. Under the sketch, which is your property, Mr. Which is property allotted to you? Is there any obstruction in that property which
What
is allotted
happened,
to
my
you?
lord, during pendency of this execution, construction and additional construction has been carried out by the judgment debtor, sir.
No.
Now
let
he
him
tried to
do-
avoid.
No. Just identify your property. Show that this is your property. It is measurement should be 2.02. Is there any construction obstruction in that property? The police can support you to remove. It is not in that, other than that 2.02.
Other than that, my lord, have not, my lord, whatever, my
Which
lord.
is your, no, therefore identification, which is your property, which is that under the sketch, it is allotted to you.
If he is aggrieved, my lord, he has to establish, my lord, which portions, my lord, it is under threat of demolition.
No, he's saying that now threat of demolition is not the property which is allotted to you.
It is not correct, my lord.
Show me that which is the property which is allotted and where is that now construction is there. You produce, somebody is produce the photographs, mister. Which is that, see, you first identify which is your portion, 1, 2, 3, 4, 5. And you show me that under this portion, is there any construction? Then that can be demolished because that is the property which is allotted to you. When will you produce that photographs and proper sketch? Yes.
Have this matter on Monday, my lord.
Yes, leave this matter on Tuesday.
Lord, yes, stay may kindly be given, Lord, till then,
Till then,
because
yes, he is undertaken that he will not
Please,
precipitate that matter. Yes.
please.
Yes. Yes, submission is accepted after subjection.
Great.
Serial number 88, Chidananda P.
Yes, for petitioner.
Yes.
Office objection complied, court fees paid, principal. Common
Yes.
order is passed.
Yes.
It's a suit for partition and separate possession and consequential relief, please, Malak. By the plaintiff, it's a defend number 527 petition, please, Malak. The application was filed to recall, reopen and production of the documents.
Yes.
That the other properties which has not been included for the partition, where the trial court has rejected the application on the ground, place, Malad, that the applications are filed at the time of the argument and the defendants have no right to produce the document.
No suit for
Partition and separate possession and consequential relief.
What is that application you have filed?
Recall and reopen and production of documents, please.
Why you are to recall?
But at the time of the cross-examination, they admitted that there was some other properties which has not been included. That documents on great difficulty I have received from the Taluk office and produced the document also, RTC and the mutation register. Trial court says that at the time of the plaintiff's argument and the defendants have no right to produce the documents to lead the evidence, please. Kindly page 18, please.
No, that what is the document you want to produce?
RTC and the mutation register, which has in the name of the prepositor, please.
And to show that it is a joint family.
It is in the name, please.
Joint family that should be. You want to include that properties.
I want to include the property.
Yes. How issue notice. stay of further proceedings in OS number 19 of 2021 pending in the file of Senior Civil Judge JMFC HD Court till next date of hearing. Other office objection is over. Other matter we'll have it on next week. Other matter we'll have it on next Wednesday.
Interim order.
Interim order will be extended.
Bill number 114. Short question of execution proceedings is solved. Of this expedition.
No, 114. 114, have you filed a IA for vacating?
Stay illa.
Stay illa. Then why that? If there is no stay, what?
Executing court says that the order which they have challenged, they have filed a writ petition here on the order of the executing court. No stay is then, but executing court.
No, if there is no stay, let them proceed.
Not proceeding here.
You have to say that
We have
filing
said
in a
that-
writ petition is not an this thing unless stay. is-
It was a very short question here.
Yes, when do you want?
Any day here.
Yes, next Wednesday.
My lord, serial number 89, my lord.
Not reached, we'll
My
have it
lord.
on Wednesday.
Please.
To Monday another transfer.
Same thing. If interim order is there, we'll extend that till next date of hearing.
My lord, serial number 97, my lord.
Yes.
Serial number 97.
Yes.
I'm jobless since 9 years, my lord. Kindly a date be given, my lord.
order is subsisting. We can have
Yes, next Wednesday. Next Wednesday.
Much obliged, my lord.
Next Wednesday. Yes.
Sir, serial number 90. Sir, serial number 99.
What of is the serial number 106?
ಹೇಳಿದ್ರಲ್ಲ ಸಾಹೇಬ್ರೆ ಎಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರುತ್ತೆ ಲಾಸ್ಟ್ ಅವರ್ ನಾಳೆ ಸರ್ ಯಾವ್ದ್ಯಾವ್ದು ರೀಚ್ ಆಗಿಲ್ವೋ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಎಲ್ಲೆಲ್ಲಿದೆಯೋ ಬ್ರೇಕಪ್ ಇಲ್ಲ ಅಂದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ ಹಿಯರಿಂಗ್ ಇಂಟರ್ಲೋಕೇಟರಿ ಅಪ್ಲಿಕೇಶನ್ ಮ್ಯಾಟರ್ ಎಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೆಡ್ನಸ್ಡೇ ಬಿ ಗ್ರೂಪ್ ಎಲ್ಲ ನೆಕ್ಸ್ಟ್ ಥರ್ಸ್ಡೇ ಮೆನ್ಷನ್ ಮಾಡೋದು ಬಿಟ್ಟು ಅಷ್ಟೇ